J'ouvre les portes. Before we go to orders of the day, I have a point of order from the honourable member for New Westminster Burnaby.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Speaker. I want to just speak quickly, but as you'll see, I am standing to raise a point of order on M43 from the member of Calgary Rocky Ridge. I do not want to reproach my colleague who, in good faith, wanted to put forward a motion on a subject that is near and dear to his heart. And I'm pleased, as is the entire NDP caucus, to debate the Taxpayers' Bill of Rights and the Canada Revenue Agency. However, it seems to me that motion M43, as drafted and tabled before this House, it contravenes Standing Order 68.4. As you know, Mr. Speaker, Standing Order 68.4 says that only a minister can table a motion to do what motion M43 is asking. And Standing Order 68.4, a minister of the Crown to appoint or instruct a standing, special, or legislative committee to prepare and bring in a bill pursuant to Section 1 of this standing order shall be considered under government orders. And if you look at page 725 of the O'Brien and Bosque, it's very clear that committee may deal with certain issues, but only ministers can table motions to this effect. And so I think that it is very clear in the case of M43 that we are faced with a private member's motion and that we are debating this during the time allowed for private members' business. We have therefore asked the clerk of the House to indicate to us whether private members' business has ever directed a committee to deal with this kind of a motion. So they gave us two examples: M411, which dates to 2003, and M501 that was issued in 2005. And neither of these motions were allowed to be debated before the House. So we're in somewhat unknown territory here. There was no point of order raised on it either, but this is explained by the fact, indeed, that there's never been such a debate. So since Standing Order 68.5 came into effect, only certain committees have been struck under this standing order. One of the bills was written following an opposition motion that was debated on October 30th, 2007, by the member for Prince George, Bulkley Valley at the time. And so it's important to point out that the government was asked under that motion, under 68.4 of the standing orders, to have a legislative committee struck and to table a bill in order to amend sections of the criminal code that dealt with driving under the influence. And so the same day, about 3:15, there was an amendment tabled by the member for Abitibi. And this was therefore allowing the Justice Committee to develop this bill. And at the end of the day, the debate on the amendment was accepted and this was passed, and therefore the motion was passed with the amendment. So when the minister did so, was from Prince George Bulkley Valley, the minister got the unanimous consent of the House in order to table the Justice Committee to deal with the bill, and this also was passed immediately. The committee tabled the text, a draft bill, in May 1999. Mr. Speaker, the only precedent for an opposition motion that resulted in the drafting of a bill by a committee was done by obtaining the consent of all parties so that a minister would be allowed to mandate this committee, which allowed for the compliance with Standing Order 68-4. So this is not what motion M43 does. This does not require any ministerial intervention. So despite all the respect that I have for my colleague, the member for Calgary Rocky Ridge, this contravenes the standing orders of the House, particularly that motion, Standing Order 68-1, and it should be ruled to be not in order. Thank you, Mr. Speaker. I'd like to thank the honourable member for Regina Capel. And if the member would like to respond. Thank you very much, Mr. Speaker. And I thank my colleague for his intervention in the House. But I think that he has understood the motion before our colleague here.
To read out the procedural portion of the motion that the House is hopefully about to debate. It states that the tabling of a report pursuant to this order shall be in order to bring in a bill based thereon, and when the member for Calgary Rocky Ridge, in proposing a motion for first reading of a bill, states that the bill is in response to the recommendation contained in a report pursuant to this order, the second reading and subsequent stages of the bill shall be considered under private member's business, and the bill shall be placed immediately at the bottom of the order of precedence of private member's business as a votable item in the name of the member for Calgary Rocky Ridge. Now, I can appreciate that there is no standing order that would allow the member to propose something like this, and that is exactly what this motion is. It's a motion to have a provision to do that. The House does this all the time. We hear all kinds of motions, usually done by unanimous consent, as my colleague pointed out, but not necessarily. There are government motions from time to time that are debated and voted on that may direct the House to take a course of action or adopt procedural measures that aren't necessarily contained in the standing orders. The member is proposing an instruction to committee, and it comes with a special order to allow the House to deal with it. I do note that 68.4 indicates what will happen when a minister does something. When a minister does move a motion to have a committee bring in a bill, then Standing Order 68 spells out exactly how that will operate, but that does not in and of itself prohibit other types of instances where a committee could be instructed to bring in a bill, especially when it relates to, or especially in a situation where we have a motion to do just that. So I understand that there is a standing order for ministers, and that's fine. And given that there is not one for private members' business, the member is responding by providing for a special order, and that the House will have an opportunity to decide. The House has obviously have an opportunity to read what's in the motion, both in terms of the content of what the committee will look at, and then what the House will do procedurally. And it's up to the House to decide if it wants to adopt the special order. There'll be a vote, and hopefully we would encourage members to vote in favor of it, but the House will ultimately have a decision to take, and the decision will guide the House procedurally in how to proceed further.
I'd like to thank the honourable member from New Westminster Burnaby for having raised his concerns on this motion.
For Regina Capel for his intervention as well. Je prendrai.
I will take this under advisement and let the House know in time as to whether or not motion M43 is indeed in order in terms of procedure.
Given that the House was given notice that this was the motion to be debated at this time and is prepared to do so, and also in order not to not penalize unnecessarily the member for Calgary Rocky Ridge, in whose name it stands, I will now allow the debate to go forward today. It being 11:15, the House will now orders of the day.
Started debate on motion M43, a taxpayer bill of rights, in the name of Mr. Kelly.
It being 11:15 a.m., the House will now proceed to the consideration of private members' businesses listed on today's order paper. Mr. Kelly, seconded by Mr. Kmeech, moves that the Standing Committee on Finance be instructed to undertake a study to prepare and bring in a bill and to report to the House on A, the steps necessary to establish an enforceable duty of care between the Canada Revenue Agency, CRA, and individual taxpayers, the steps necessary to make the provisions of the Taxpayer Bill of Rights legally enforceable, such as by amending the Canada Revenue Agency Act to establish a duty of care owed by the employees of CRA to the taxpayer when performing duties and functions under all revenue-related law, with the standard of care being defined as the rights contained in the Taxpayer Bill of Rights. C, the steps necessary to amend the Taxpayer Bill of Rights with the following changes. 1. In Right 4, add the requirement that CRA take reasonable and necessary steps to avoid frivolous, vexatious, malicious, and/or grossly negligent actions toward taxpayers. 2. In Right 8, add the requirement that information provided by CRA via any means, including but not limited to correspondence, telephone calls, and its website, be accurate, reliable, and in compliance with all applicable revenue law, and add the requirement that information provided by CRA to taxpayers by telephone be followed within a reasonable time by the same advice in writing. 3. In Right 9, add the requirement that complaints about CRA's service be addressed in a timely manner. Add investigation and enforcement powers to the Office of the Taxpayer's Ombudsman, including the power to dispense remedies to make a taxpayer whole in relation to the standard of care set out in the Taxpayer's Bill of Rights. 4. Or, if the changes mentioned in 1, 2, and 3 are not possible, to add the additional rights mentioned in subsections 1, 2, and 3 as new rights. D. The steps necessary to empower the Office of the Taxpayer's Ombudsman to direct compliance with tax court rulings or formal decisions on specific cases. And E. The steps necessary to impose reasonable limits on the rights forming the standard of care and duty of care created by the sections above, and that the committee report to the House no later than December 15, 2017, provided that in its report the committee shall recommend the principles, scope, and general provisions of the said bill, and may include recommendations regarding legislative wording, and that the tabling of a report pursuant to this order shall be in order to bring in a bill based thereon, and when the member for Calgary Rocky Ridge, in proposing a motion for first reading of a bill, states that the bill is in response to the recommendations contained in a report pursuant to this order, the second reading and subsequent stages of the bill shall be considered under private members' business, and the bill shall be placed immediately at the bottom of the order of precedence of private members' business as a votable item in the name of the member for Calgary Rocky Ridge. Debate. The honourable member for Calgary Rocky Ridge.
Thank you, Mr. Speaker. Death and taxes. Perhaps these are indeed the two great certainties in life. Both are inevitable, but the means of administering them bear debate. Law-abiding Canadians should not be figuratively taxed to death. They should not lose their businesses, their homes, and their physical health due to gross negligence by the tax collector. Although no one relishes the prospect of paying taxes, the vast majority of Canadians dutifully file their returns, keep their receipts, and claim only those deductions to which they are entitled. The Canada Revenue Agency, for its part, normally conducts its business fairly and efficiently. However, an egregious error by the Canada Revenue Agency can cost taxpayers dearly through no fault of their own. Sadly, such errors do occur from time to time. Motion M43 aims to correct this problem by instructing the House of Commons Standing Committee on Finance to study and report on the means of creating an enforceable duty of care from CRA toward Canadian taxpayers. The motion also aims to make CRA more accountable for its communication, to empower the Office of the Taxpayer's Ombudsman, and to allow egregiously wronged Canadians to obtain remedies. Several stories illustrate the need for such reforms. Madam Speaker, Irv LaRue was an enterprising British Columbian. In the early 1990s, he cleared a patch of land to build a campground and recreational vehicle park. His troubles began when CRA audited him in 1996. CRA required certain paperwork which Mr. LaRue supplied. Through an egregious oversight, CRA first lost and then destroyed his original documents. However, this did not stop CRA from continuing to demand that he produce original documents, or from refusing to accept copies he painstakingly acquired and supplied. Instead, CRA continued to demand the originals that they had destroyed. They simply pressed on with their reassessment of his income, having destroyed the only evidence he could use in his defense. 10 years later, in 2006, CRA conceded that Mr. LaRue was correct all along and that he did not owe the taxes that they had originally demanded. However, the damage was done. The struggles with CRA cost Irv his business, his home, even his physical health. Mr. LaRue sued the CRA, and eventually the courts ruled that CRA owed him a duty of care and had acted negligently. His is a story of one man being ruined by egregious treatment by CRA. Madam Speaker, this should never happen again. Madam Speaker, in another case, a constituent of mine from Calgary Rocky Ridge named David was in a shared parenting arrangement with his ex-wife. In order to comply with the Divorce Act, he and his wife made an agreement that compelled each former spouse to pay support to the other based on their incomes. David did his best to comply with the law. He read the rules carefully and looked up information on CRA's website. He thought that he could rely on CRA's website for accurate tax information, especially since he found a seemingly helpful example on the website which matched his situation to a T. But some years later, CRA reassessed him, denied the deductions that his own website indicated he was entitled to, and demanded a very large amount of back tax. Mr. Speaker, clear and reliable communication from CRA to taxpayers would avoid much stress and cost to both tax-paying Canadians and to the Treasury. In a third example, Janet is a hard-working mom from Southern Ontario. She pays her taxes, keeps her receipts, and complies with the law. However, through no fault of her own, someone at CRA checked the box to mark her deceased. One click of the mouse caused months of trouble for this law-abiding taxpayer. CRA flagged her social insurance number, which stopped payments of her universal child care benefit. The CRA demanded reimbursement of an overpayment to her estate. They still accepted source deductions from her employer, presumably as a new category of working dead. Worst of all, her status as primary caregiver for her son was withdrawn. Despite repeated calls to Service Canada and CRA, her son remained without a legal caregiver. It's hard to imagine the stress and anguish of a mother facing the possibility of the state seizing her child and treating her like an abductor. Here is a woman who did nothing wrong, but suffered months of stress, financial uncertainty, unnecessary extra work, and fear of losing custody of her child due to an administrative mistake with far-reaching consequences. What would have happened had this occurred to a senior with reduced faculties who did not have an employer and a helpful member of Parliament in her corner like Janet did? How much suffering would ensue if someone's OAS, GIS, CPP, or other supports tied to their social insurance number suddenly ceased without notice? Madam Speaker, a more user-friendly resolution program with a stronger ombudsman could help reduce such strain on blameless taxpayers. These stories illustrate problems which Parliament can address through passing this motion. Indeed, I believe that it is our duty as an elected legislature to respond to injustices caused by Canada's tax collector. As members of Parliament, we must respond to developments in the law which come up through the courts. When a court, such as the Supreme Court of British Columbia in LaRue and Canada Revenue Agency, makes a new finding in federal law which could have widespread consequences, it's incumbent upon Parliament to respond. In paragraph 209 of the LaRue case, Justice Humphreys concluded that, in the circumstances of this case, the employees of CRA, more specifically the auditors, owed Mr. LaRue a duty of care. She went on to find in paragraph 311 that the standard of care owed to Mr. LaRue was that of a reasonably competent tax auditor in the circumstances. Madam Speaker, the precedent-following nature of Canada's common law means that courts throughout Canada will now treat this duty of care decision as persuasive or a binding precedent, depending on their level. If appeals take the matter to the Supreme Court of Canada, this duty of care may well become the law of the land without legislative input. M43 proposes that Parliament take up its responsibility, get ahead of the courts to study the best way to address the issue. The motion instructs the House of Commons Standing Committee on Finance to study and report on the steps necessary to create a legally enforceable duty of care owed by CRA to Canadians. In plain language, a duty of care means that someone must consider the legitimate interests of the other party in a particular relationship, so that the former takes care not to not unduly harm the latter. Whether we like it or not, all Canadians enter a relationship with CRA, an agency which is far more powerful than any individual or business. Such power may be necessary for a functioning tax system, but should include safeguards against abuse, such as a duty of care. By having the Finance Committee study and report on the matter, Parliament can ensure that we receive information needed to make a wise decision. We can hear from a wide range of stakeholders, from CRA itself to tax lawyers, taxpayer advocates, accountants, research staff at the Library of Parliament, and ordinary Canadians. Referring the matter to committee also ensures that the different parties can have their say for a measure which will affect Canadians regardless of political persuasion. By sending the matter to committee, Parliament ensures that the deliberations are visible to the public, thus contributing to the government's stated objective of open government. Madam Speaker, I recognize that the Finance Committee has many pressing matters to address in the coming months, so I've included a generous timeline for M43. Instructing the committee to report back by the last sitting day of 2017 gives it a year and a half to address the matter without sacrificing other important priorities. Creating a duty of care between CRA and taxpaying Canadians is an important step. One which should be taken carefully and correctly, with the full participation of Parliament, but taken nonetheless. This brings me to the specific measures which M43 proposes and the reasons behind them. Madam Speaker, a duty of care is always accompanied by a standard of care by which it is measured. In the LaRue case, Justice Humphreys found the standard to be that of a reasonably competent auditor. But what guides reasonably competent auditors? What guides CRA as a whole, determining how to treat taxpayers? Madam Speaker, the Taxpayer Bill of Rights already provides a list of expectations for how CRA should conduct its affairs. However, the Taxpayer Bill of Rights remains more aspirational than enforceable. M43 seeks to remedy that by instructing the Finance Committee to study ways to make the rights contained in the Taxpayer Bill of Rights enforceable as the standard of care to which CRA will be held. The motion also contemplates expanding some of the rights contained in the Taxpayer Bill of Rights to address the problems which the stories of Irv LaRue, my constituent, David, and Janet from Southern Ontario faced. Adding the requirement that CRA take reasonable steps to avoid frivolous, vexatious, malicious, and/or grossly negligent actions toward taxpayers codifies something which CRA should be doing anyway, thus giving clarity both to CRA employees and to Canadian taxpayers. Adding the requirement that CRA provide accurate and reliable information addresses David's case. If someone consults CRA's website for information about claiming a deduction or credit, finds an example that matches his or her family's facts to a T, he or she should be able to count on the information being accurate. That brings me to the proposal to empower the Office of the Taxpayers Ombudsman to investigate, enforce, and dispense remedies. A stronger ombudsman with these powers would prevent many disputes from going to tax court and would act as an internal correction measure, balancing the needs to collect revenue efficiently and an obligation to not abuse taxpayers. Most importantly, it would provide a way to make taxpayers whole if the ombudsman finds gross negligence. A stronger ombudsman could help sort out smaller mistakes with large consequences, such as when Janet was incorrectly marked as deceased. It could also discourage CRA employees from digging in and standing by their errors when they make mistakes, since a smooth investigation and remedy system could deal with mistakes quickly and quietly. Mr. Speaker, rights always come with responsibilities, and this motion is no exception. In creating new rights or expanding the existing ones under the Taxpayer Bill of Rights, we in the legislature are responsible for imposing reasonable limits on them so that they do not cripple the CRA's ability to collect revenue. The motion includes an instruction to the Finance Committee to study the steps necessary to impose reasonable limits on the taxpayer rights so that Parliament can strike the right balance between collecting revenue and protecting Canadians. To be clear, this motion does not make CRA liable for every mistake made by its employees, but it does seek to hold CRA accountable for gross negligence. The Finance Committee is ideally suited to discuss these limits and consult with the Minister of National Revenue and representatives of her department on where to set them. CRA plays an essential role in financing the government and so should not be impeded except to the extent needed to protect taxpayers from egregious abuses. Mr. Speaker, let me conclude by appealing directly to my honourable colleagues in each party. Members of the government and other opposition parties may be asking why they should support a private member's motion about the Canada Revenue Agency. To my colleagues in the government, I would say that I support their campaign promise and the Minister of Revenue's mandate to take action to make CRA more fair, more helpful, easier to use, and more, as they put it, client-focused. This motion squarely fits with those laudable goals and offers a thoughtful way to implement them. Through this motion, it may be possible for my Conservative colleagues and me to help the government fulfill this particular plank from their election platform. We welcome the opportunity to work together to study the matter and draft a sensible solution which is good for all Canadians. To my colleagues on my left on these opposition benches, I would say that the measures proposed in this motion go to the heart of their party's historic desire to be Canada's social conscience and to make sure that ordinary Canadians get a fair shake. After all, this motion will be most beneficial to Canadians who cannot afford expensive professional tax advice when preparing their returns and cannot afford legal representation if they become part of a dispute. Regardless of whether a Canadian votes Conservative, Liberal, NDP, Bloc, or Green, we all have to pay taxes and we all want to be treated fairly by CRA. We can, and we do, disagree as parties on what the tax rates should be and how taxpayers' dollars should be spent, but surely we can all agree that the tax collector should be efficient without crushing Canadians. And when it comes to paying taxes and disputing a CRA ruling, the process should never be the punishment. And so, Madam Speaker, I urge all of my honourable colleagues to join me from all parties and vote in favour of motion M43. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The honourable member for Yukon.
Thank you, Madam Speaker, and I thank the member for his thoughtful bill, and I certainly agree with the objectives, improving the work at CRA, and that's why I'm delighted the government has put so much extra funds in the budget this time and advocated for the process, not only for CRA, but for several other departments to make them more efficient. So I'm not sure that this is the exact way to ensure those rights, and I just have a quick question. Where it talks about the necessary to empower the Office of the Taxpayers Ombudsman to direct compliance with tax court rulings and formal decisions on specific cases. I don't understand that totally. If there's rulings and formal decisions, why they're not already enforced? Is it if the court orders something, is it not enforced? And empowering the Ombudsman to order redress it appears to be more powerful than and extensive than any other powers of parliamentary ombudsman. I wonder if the member has any precedents for such a move.
The honourable member for Calgary Rocky Ridge.
Well, thank you. Thank you for the question. Thank the member from the Yukon for what sounded like some support for the intent of this motion, which I think really does and ought to appeal to all of us as parliamentarians. To answer his questions, certainly one would think that that if a court ruling is made, that should be the end of it, and that there would be no further direction that would be required. But that anecdotally doesn't appear to be the case based on some complaints and discussions that we have had over difficulties in actually with the agency complying with Court ruling, so we included that in the motion specifically in response to what we had been told in our research. As far as the giving the Ombudsman further teeth, I'm not going to, I don't have a precedent in terms of other agencies, but the CRA is a unique agency. It has unique power over Canadian taxpayers and Canadian businesses. So because of the reverse onus nature of the way the CRA works when assessing.
There are other people that want to ask questions, so if you can keep your questions and your responses short enough, we'll be able to get through this. The questions and comments, Honorable Député de Sherbrooke.
The Honourable Member for Sherbrooke. Thank you, Madam Speaker, and I'd like to thank my colleague for his initiative. And I'm going to allow him to continue on the issue of the Ombudsman because it interests me as well. In motion C of his motion, it says to grant the Office of the Ombudsman the steps necessary to amend the Taxpayer Bill of Rights with the following changes. And it talks about respecting the decisions of the court. And that intrigues me a great deal because the Finance Committee will be able to study that because right now the Ombudsman Office is an administrative ombudsman who was appointed by Governor and Council. So to change powers to that extent would dramatically change the role of the Ombudsman, and it would take more than that. And it is actually only the government that can change the mandate of the Ombudsman. So what does my colleague think is the solution to address this important issue?
For Calgary Rocky Ridge.
Okay, well, thank you for the question and for allowing me to continue somewhat in the same vein as the previous question. Yes, we have asked the committee to study and report back on this issue and to find ways to address the objectives. One of the objectives is to ensure that the Office of the Ombudsman has sufficient powers to help protect Canadian taxpayers. And so we look forward to, I look forward and encourage the other members to support the motion to allow the study to go ahead and to find ways to enhance the powers of the Ombudsman to ensure that taxpayers can be made whole when an egregious error occurs on the part of Canada Revenue Agency.
Resuming debate, reprise de débat, l'honorable.
The Honourable Member, Parliamentary Secretary, the Honourable Parliamentary Secretary to the Minister of National Revenue. Thank you, Madam Speaker. I'm very pleased to have the opportunity to speak to the actions that were undertaken at different levels in order to uphold the rights and interests of Canadian taxpayers in a responsible manner. The Canada Revenue Agency is committed to delivering real results and professional government to Canadians. And thanks to the budget 2016's infusion of more than $1 billion over 5 years in supplementary funding, the agency will be able to do just that. In addition to combating tax evasion and tax avoidance and enhancing tax collections, the CRA will put this new money to work to improve service to Canadians, especially low-income Canadians, newcomers, and Indigenous communities. An investment of $185.8 million, Madam Speaker, over 5 years will support enhanced telephone access, easy-to-understand correspondence, and increased outreach for vulnerable and low-income Canadians, including Indigenous peoples. So, as you can see, Mr. Speaker, there is a fundamental flaw with this motion. While it is undoubtedly well-intentioned, M43 is unnecessary, and I'll tell you why.
It is a solution in search of a problem that does not exist. And I don't want to say that those problems have not arisen, but I'm talking about the measures that are put in place to help people that encounter the problems. Canadian taxpayers already have numerous means of recourse to resolve disputes if they disagree with their tax assessments. If the House were to adopt this motion, it would merely duplicate the full range of services available. Take the CRA's Taxpayer Bill of Rights, which contains 16 rights as well as 5 commitments to small business that confirm the agency's commitment to serve taxpayers with professionalism, courtesy, and fairness. The service rights of the Taxpayer Bill of Rights are backed up with the CRA's Service Complaints Program and the Taxpayers Ombudsman. More to the point, many rights found in the Taxpayer Bill of Rights are already enforceable under the Income Tax Act, the Official Languages Act, and the Privacy Act. These statutes ensure judicial recourse for Canadians, such as the right to object to a tax assessment or the right to privacy and confidentiality. Moreover, the Supreme Court of Canada has already made a distinction between policy decisions and operational decisions. The court has ruled that operational decisions, the implementation of government policies, are already subject to a duty of care. Consequently, the creation of an enforceable duty of care would be legally redundant. Simply adding the term enforceable duty of care to the Taxpayer Bill of Rights would have no more force than what exists at the moment.
I should point out that the Taxpayer Bill of Rights was amended in 2013. This provides the opposition with ample opportunity when it was the government to make it improvements it deemed necessary. It is curious that the honourable member of Calgary Rocky Ridge now feels that it failed to do an adequate job and must call for this amendment. Presumably, the authors of those recent amendments recognize that CRA's mix of legislative rights and service rights in the right approach. It is consistent with the way many other OECD countries address these issues. I would also note that the member has cited particular cases in media interviews and inspiration for his motion. One of the cases began 19 years ago, well before many of the avenues of recourse that exist today were in force. Bien que je partage.
While I share his concern with this case, Canadians today have more avenues of recourse for their taxes than they have ever had before. And I just want to make that clear. The case was actually resolved shortly after this government came to power, in fact. The honourable member cited the case of one of his own constituents as well. Now, it is not appropriate to discuss detailed taxpayer information, of course, but I would hope that he has advised the individual of the many recourse mechanisms provided by the CRA, because we want to protect privacy, of course. So this constituent needs to be aware of the mechanisms in place. So, Madam Speaker, the second argument against this motion relates to the Office of the Taxpayers Ombudsman. The Ombudsman provides an impartial review of unresolved service complaints from taxpayers. The Ombudsman is neither an advocate for the taxpayer nor a defender of the CRA. Instead, the office investigates complaints related to service delivery to determine if taxpayers received accurate, clear, and complete information in a fair, courteous, and timely manner. The Ombudsman investigates the facts and, when required, recommends corrective action to systemic service problems. This approach provides taxpayers with recourse while avoiding an adversarial, protracted, and often litigious process. This is the fairest way to address contentious issues, since these rights are extended to all Canadians, not just those who can afford to go to court. Perhaps even more importantly, Madam Speaker, is that by fostering a more open and cooperative relationship between individuals and the CRA, complaints can be resolved quickly and at minimum cost. Some complaints and disputes are caused by a lack of information or by a simple miscommunication. And this is why people at the CRA say, talk to us, stay in contact, and I just want to remind the House that we have just announced an unprecedented injection of funding to help with these solutions to resolve conflict. So I will just conclude quickly by saying that if a taxpayer does have difficulties with the CRA, there are a number of ways that they can take action. There is my account, my business account, represent a client, a number of things that can be done online, or they can write to the CRA. What this motion proposes is to require a formal letter to be sent out to taxpayers following each telephone call to the CRA. All this would be doing is to put in writing the information that taxpayers already receive from an agent on the phone. There was an internal investigation into how well the information was being provided on the phone. I think that there were problems, and I'm not sure why that was, but we are investing in a major way to make sure that everything is improved so that taxpayers are served as if they were clients, and they are. This is why I would have to vote against the motion by my honourable colleague. Thank you.
Prise de débat, resuming debate. The honourable member for Sherbrooke.
Merci, Madame la Présidente.
Thank you, Madam Speaker. I first want to thank my colleague for his initiative this morning, which is certainly well-intentioned. I would also like to just read the motion, review what it contains. I think that it is problematic, even though the intentions are good. The motion calls for something that's quite unusual, and that is to refer the study to the Standing Committee on Finance. And then the bills that would be referred would come back to the House. The member would be sponsoring these bills in a way. They would come back under his name, and he would be then sponsoring the debate. So this is quite an unusual approach. I think that the member for Burnaby New Westminster talked about the problems associated with that approach in his point of order this morning. I would like to talk more about the content myself, and that is really what people are interested in. It's a very long motion. In A, the sponsor asked for steps to establish an enforceable duty of care between the Canada Revenue Agency, the CRA, and individual taxpayers. So this enforceable duty of care is the important point there. The second point, B, has the Taxpayer Bill of Rights being made legally enforceable and amending the CRA Act to put that Bill of Rights in it. So this would entrench the rights right in the bill. So C is somewhat overlaps with the other one, so adds requirements. And my colleague raised some of the problems with those aspects. We certainly have reservations about the feasibility and the legality of the content of this motion. The last thing we want to do is to impose on the Finance Committee work that comes out of such a motion, because it is not really something that we could put into legislation and make workable. So these are the problems we see with the content. The committee of the Finance Committee doesn't really have this role. By June, the Finance Committee has a lot of other work on its plate. So let's talk about the legal framework in which we work and the problems with respect to this motion, because if we put the Taxpayers' Bill of Rights into the Act, then the CRA employees would have to take that into account. Obviously, these rights are very important. The Conservative government brought in the Bill of Rights. There are 6 rights. Some of them are legal rights. That is, that the CRA is required to enforce them. For example, providing any reimbursement that taxpayers entitled to, that is a legal right. To serve clients in both official languages, that is a legal right. Right to privacy, confidentiality. There are statutes that protect those rights. They are required to provide fair and consistent service, and they are required also to reduce the taxes owed in certain circumstances. Number 4 is the right to have a review or an appeal, but 5, 6, 9, 10, 11, 12, and 14, those rights have more to do with service. I'll just give you a couple of examples. Number 5 is the right to be treated professionally, with professionalism, courtesy, and the information needs to be timely and fair, accurate, reliable. So this was mentioned by my colleague. If we don't have to have all of those rights enshrined in legislation for them to be legal. When we talk about professionalism and courtesy, then if that is actually in the statute, we might have a difficult legal situation. These rights are not necessarily enshrined in statute, but they do come under the purview of the Ombudsman. Legal rights are already actionable, and people can go to court over those. We have the Office of the Taxpayers Ombudsman. There are frequently asked questions that deal with some of these aspects. And when we have the service standards, they include administrative rights. The CRA has put in place standards to make sure that they provide proper service to clients, they reward good service, and they keep track of the service provided. So these are administrative rights that people are entitled to. We don't want to say that those rights are less important, but there is a difference between certain rights like that and some that need to be considered legal rights in themselves. I mentioned the Ombudsman, and in the question that I asked, I mentioned that the Office of the Ombudsman was created in 2007 by an order in council, 2007-0828, and the purpose of the office was to better protect the rights of taxpayers so that they didn't have to deal with the kind of situation that my colleague mentioned. We want to protect the administrative rights of taxpayers, of course, and that is in the Bill of Rights itself. The Office of the Ombudsman could be improved or changed through an order in council. There are a number of requests here to change the powers of the Office of the Ombudsman, but the power to do that is in the hands of the government through an order in council. So we can't do that through legislation. The Ombudsman works in the administrative area and investigates those kinds of aspects. There are other ombudsmen as well that have legal responsibilities to enforce rules and the law. So I see that my time is just about up, so I want to thank my colleague for his initiative. I'm anxious to see how the discussions go forward. Thank you, Madam Speaker. Resuming debate.
Honourable member for Calgary-Shepherd.
Thank you, Madam Speaker. I'd like to thank the member for Bourassa and the member for Sherbrooke as well for their interventions on this. I think what we need to think clearly on this motion is the very fundamental principle that should apply to taxpayers is every single taxpayer in Canada should be able to fill out their taxes without the assistance of a professional accountant. And to do so, they need to fill out their tax forms and to deal with the CRA without the need for any type of professional help. The relationship a taxpayer has with the Government of Canada and the Canadian Revenue Agency is not voluntary. It's imposed upon them the moment they're born. Now, the only time it's not voluntary is when you're an immigrant and you come to this country. You get to choose to be treated poorly by the Canadian Revenue Agency. The income tax code is about 2,500 pages. Now, I was very much tempted to actually print the entire document and put it on my desk to use it as a podium, to read it from it. I also think of the Yiddish proverb, with knowledge, you are nowhere lost. And I was lost looking at this document in its original format, in very fine print, about 6 font, in Bible-like scripture paper. This document is unreadable to most Canadians. It's unusable to most Canadians. It doesn't even include all the information bulletins, the opinion pieces produced by professional accounting firms, and it also doesn't include all the other material that's out there that's meant to interpret the tax code. So from the very beginning, the taxpayer is placed at a disadvantage when dealing with the Canadian Revenue Agency. When an auditor, when a person calls from the CRA or sends you a letter, you automatically will assume that they are correct in what they're saying. You will automatically defer to their better judgment because the tax code is simply so complicated. So this motion, I think, is very critical towards getting a better relationship and a more equitable treatment for taxpayers because all it's asking to do is to look at the issues, and it basically iterates some of the problems. I mean, right number 9 over here, add the requirement that complaints about CRA service be addressed in a timely manner, add investigation and enforcement powers to the Office of the Taxpayers Ombudsman. Those are points of consideration. So the committee could consider all of these things, consult, report back. I thought these were things that the government was clearly wanting to do more of. It also is an opportunity to call witnesses, and I would love nothing more than to call witnesses from my riding and some of the other people who are sending me emails discussing with me their case. I've talked to many people over the phone now who have had poor treatment from the CRA or have had their businesses destroyed because of errors by auditors or in an assessment. Now, those are patently unfair, and I know that the member for Bourassa said how much money they're spending, and I agree that, some of these investments are pretty good. Let's look at the workload of the Canadian Revenue Agency on page 206, Chapter 7 of the budget. It says the CRA answers over 23 million calls in a typical year. CRA sends out over 130 million pieces of correspondence each year, and it sets out here they're going to make it an easier to read format. I'm all for this. Easier to read format, plain language is a great idea. The problem is it doesn't address the problem of enforcement. What if this plain format is still wrong when it's sent to you? What if it leaves you in error, makes you commit an error, like in the LaRue case, where your business is destroyed, your livelihood is destroyed? So I also look at page 207 here, where it says, again in the budget document, fairness by making it easier for taxpayers to avoid errors and comply with their tax obligations, allowing the CRA to direct its compliance efforts towards cracking down on tax evasion and aggressive tax avoidance. But what about the taxpayer who's facing an aggressive auditor or an incorrect assessment? What about their rights? What are their opportunity to stand up to the CRA and say, this is wrong, you're committing an error that's going to cost me time and money, possibly destroying my livelihood as well? And when I look at here on page 217 of the budget, again, it's Chapter 8, it says that the budget 2016 proposes to provide $351.6 million over 5 years. So again, it's over 5 years. I think this motion provides a great opportunity to inform the government on how to spend this money, where to spend it, where to maximize the usefulness to the taxpayer. It shouldn't be the usefulness to the government. It shouldn't be the usefulness to the Canadian Revenue Agency. It should be customer service oriented. The taxpayer in this case is the customer. They must be treated fairly. And, reading the rest of this budget document as an exquisite piece of marketing sophistry, those are the points I find most useful in there. Now, when we also think about the average taxpayer, they simply don't have the means to fight it all the way to the Tax Court of Canada and win. For very many of them, once you tell them you have to go to the Tax Court of Canada, they simply give up. I've spoken to many constituents, many people across Canada who've called my office and said that is not an option for them. They don't want to litigate for a decade and maybe win. Right. It makes lawyers rich. It doesn't make the taxpayer rich. It doesn't make it right. And when I think about the CRA, it's interesting that in the CRA probe, KPMG was able to get out of paying for running a $130 million tax dodge on the Isle of Man. In that case, they reached an agreement of some sort with the CRA. Now, there's an article on the CBC that says that CRA personnel or employees were treated to hospitality suites at the Rideau Club. Menus for private receptions at the time included sumptuous fare as scallop ceviche, I hope I'm pronouncing that correctly, duck rillettes, crostini, and herb roasted rack of lamb. Now, I'm not a Philistine, but I'm pretty darn close to it. Most of my the taxpayers in my riding can't afford a menu like this to try and convince the CRA that they've been ill-treated. And so when I consider this motion, I consider this is for them. This is for the average, everyday taxpayer who doesn't have the means to go to a tax lawyer, to a professional accountant. They simply don't have it. They have a regular job. They have a family. They have their lives to live. They don't want to deal with a CRA any more than they must. Each of us is this way. I'm this way. Dealing with government is the last thing on my mind. Now I have to deal with it every single day. So when I look at the LaRue decision and the duty of care, the Honourable Madam Justice Humphreys in this case, and I think this is an important decision that every member should get acquainted with. The duty of care, she mentioned, is connected to proximity and foreseeability, the two most important considerations to determine whether there is a duty of care. And in this duty of care, I think when she talks about on paragraph 204, she does mention the Taxpayer Bill of Rights. And You have right number 8. You have the right to have the law applied consistently to you. You have the right to lodge a service complaint and to be provided with an explanation of your findings, of their findings. Now, the problem is oftentimes that explanation is difficult to understand at best. Sometimes it's completely incomprehensible to most taxpayers. I've read some of these documents. I don't even understand. I'm not a tax lawyer either. But you shouldn't have to rely on the expertise of a tax lawyer to understand what the government is trying to tell you when you're trying to comply in good faith with the rulings, with the decisions that they're making. And for many people, like in the case of Mr. Leroux, it destroyed his business. It destroyed his livelihood. And he fought for years, decades in fact. Now, no taxpayer in Canada should have to fight the government for decades to right a wrong. It should simply not work this way. And I'm going to read here just a part out of the decision because I think it's important to see where Justice Humphreys went. On paragraph 247, it said, the interests of CRA and taxpayers are inherently opposed. The self-reporting, self-assessing tax scheme set out in the Income Tax Act depends on the honesty of taxpayers who must make detailed and complete disclosure. Now, the same should apply to the CRA. Now, I have constituents in my riding, and I'm just not going to use their last names because I don't want them to have further problems, but I think of Connor in my riding. Connor had a business for 3 years. His bookkeeper made a mistake. He admits he made a mistake as well, but CRA made a mistake as well for 3 years. And when they realized their mistake, they came back and assessed him with an almost $75,000 penalty, including the interest, because it was over $50,000 that they went on to garnish his wages. They garnished his bank account of his business down to the last 10 cents in it, everything. He had to fire all of his employees, let go of all his staff, couldn't pay his vendors, couldn't pay his rent. That was unreasonable. What the CRA should have done is warned them, provided him an opportunity to comply. He says he made a mistake and he's willing to comply with it. He needs to understand how. Now he has a tax accountant. Now, another case I'd like to bring is Dean and Jody in my riding. They're facing a $6,900 bill. And again, the intransigence of the CRA, they wanted to pay it now, but neither of them are working because in Alberta right now, it's a tough economic situation. They don't have a job. What more can they do? They've sold their cars. They've downsized their house. Does the CRA want them to sell their home and move their family out? That's pretty much where it's going to go. And the last case I want to mention is Sandra. She's been trying to take advantage of the disability tax credit for her daughter who has PKU, a rare condition. Now, she's been told by other families that they've taken advantage of the disability tax credit for PKU-related expenses, and they have no problem. She's appealing this over and over again and getting a refusal, while other families with a similar condition are getting refunded. Now, consistency of application of the law is what we want here. This motion gets us to that point. This motion gets the committee thinking about it, looking at it. It's basically guidelines, a possibility to call witnesses, recommendations. I call upon all members to support this motion. Thank you.
Reprise de débat. L'honorable député.
The honourable member or Laurentier Labelle.
In principle, the bill sounds very interesting. You know, the idea of making the revenue agency have to, not make mistakes and react to those mistakes. But I have a number of implementation questions about this bill. First of all, the Conservatives were in power for a number of years. I'm wondering why they didn't do this already. I wonder also why the Ombudsman would be given powers that no other Ombudsman has. This is not something that normally is given to Ombudsman. You don't get power to enforce, you get power to look at issues and make recommendations. I'm also not clear on how adding an enforceable duty of care to the Taxpayers' Bill of Rights would provide more force than what currently exists. I don't see an improvement here. Again, I think in principle the bill is not a bad idea, but I want to know how these things are actually going to help us in real, tangible terms. The government budget that we just brought down put in $185 million to address the government's commitment to service excellence through a number of initiatives already for telephone services and correspondence. And we're already doing some of the things that this bill requires us to be doing. The Taxpayers Ombudsman reports directly to the Ministry of National Revenue and is neither an advocate for the taxpayer nor a defender of the CRA. Empowering the Ombudsman to order redress is inconsistent with other Ombudsman officers appointed by Parliament who have no such authority. So again, the Ombudsman question, why are we creating new rules that shouldn't, that don't exist elsewhere? Since the Revenue Agency administers tax for all of Canada except Quebec, sorry, Madam Speaker. All provinces except the provinces would likely be interested in actions taken to improve compliance rather than in establishing a statutory approach that would increase the overall cost of administering tax legislation without clear benefits. So, I don't know, Madam Speaker, I don't have a huge amount more to say on this. I am very concerned about the Office of the Ombudsman and the increased powers it would bring in, and I'm concerned that this would limit power to the Minister to deliver on her mandate. Thank you, Madam Speaker.
Resuming debate, reprise de débat, l'honorable député.
The honourable member for Jonquière. We won't have too much time, but thank you, Madam Speaker. I'm always somewhat baffled when I see a motion or a bill coming from the Conservatives. When we read the title, we might say, oh, finally they've understood we're going to provide service to the people. We're happy. But the devil, as we say, is always in the details, and when we read this motion, the devil is really the entire text. Motion M43 does not vary from the tried and true techniques that they have had of misleading the public. Between you and I, that's really the reason why it was imperative that we replace the previous government. I'm proud to represent my riding of Jonquière, and when I rise in the House, I really feel the duty to represent the people back home as best as I possibly can. When I ran, it was with a clear idea in mind to try and improve the daily lives of my constituents, to defend and promote their rights. And it's with this in mind that I tabled my bill preventing replacement workers from being used in order to defend those workers. But, Madam Speaker, in the case of today's bill, what we're studying, or motion here in the House, I don't have the impression that we are really working to defend the interests of our constituents. Let me talk a little bit about the meandering logic that M43 represents. First of all, when the Ombudsman was created in 2007 by the Conservatives, there was never any issue of giving the person any such powers. The powers of the Ombudsman are summed up by assessing the service delivery alone, and it's even specifically said that he shall not review the administration or enforcement of program legislation other than to the extent that the review relates to service matters. The Conservatives created an ombudsman's position to defend the interests of our constituents, but without giving him or her the necessary tools to do so. And now that they're no longer in power, all of a sudden, they want to provide those tools so that the ombudsman can do his job. I call that bad faith. And talking about bad faith, the Conservatives are trying to have us believe that our public servants are dishonest in the services that they provide to the population. That's completely unacceptable. I am proud of our public servants, of the services that they provide, as well as their professionalism. The problem is when they aren't given the means to do the job that they're asked to do. With the money, there have been so many cuts since 2012. In Stephen Harper's budget, their last budget, there was $314 million cut from the CRB. And that prevents people there from providing the services to the people. In Jonquière, I saw cuts in services provided to the people who were waiting to have help and to get their needs met, because either they were limited in the resources, they don't have access to the internet, or through service cuts that were made to CRA, they weren't able to provide the services. They weren't able to use the phone lines. But these people needed to speak to someone. And because of the latest cuts under the Conservatives, they weren't able to do so. It's not because officials don't do a good job. It's because their jobs were cut. And now I see that my time's almost up, Madam Speaker, but I thank you for having given me the floor. And I want to say, once again, that our public servants do a wonderful job, and they need to have the resources to be able to provide these services to the people. Thank you, Madam Speaker. Order. The member will have 6 minutes left next time this motion is before the House. And so the time provided for the consideration of private members' business is now expired. The order is dropped to the bottom of the order of precedence, given that it is 12:15.
Oh, excuse me.
Government orders, government bills, comments. La prise de débat deuxième lecture du projet de loi C10.
Government orders, resuming debate on C10, an act to amend the Air Canada Public Participation Act.
Resuming debate, reprise de débat, l'honorable député.
Honourable member for Laurentides-Labelle. Thank you, Madam Speaker. I will continue from where I was on Friday. The intention of the bill was to ensure that Air Canada would continue to do maintenance work in some regions of Canada at the same time. The bill was oriented towards a public interest aspect that allows a company to be as competitive as possible. As you've certainly seen, the air transport sector has greatly changed since the Act came into effect in 1989. Initially, in 2015, Air Canada had some 80 million passengers and provided regular direct services to 62 airports, many in the United States and in the rest of the world, in Europe, Asia, Africa, and other areas. As you know, Air Canada is faced with the reality that the international market is very competitive. Other carriers and international and national carriers are not subject to the same obligations in terms of maintenance as Air Canada is. It's always so important to recall that Air Canada, in its global markets, has a market that's characterized by big international companies that serve vast networks by using very state-of-the-art equipment. This market is really subject to fluctuations because of its cyclical nature. And we just have to look at the reality of today's world, where there could be terrorist acts committed. We can see that there are important repercussions on a company's bottom line. This service is provided within our country by Air Canada, but also elsewhere in the world, and it's an important job source. Air Canada has some 25,000 employees. This makes us believe that the Air Canada Public Participation Act could impose limits on the company's ability to be profitable and competitive. We therefore believe that the current legislation is not in line with the competitive forces in the transportation sector. In Air Canada, as with many businesses, Air Canada needs to be able to evolve within a competitive framework in order to remain profitable in the long term. As far as the sector is concerned, federal policies emphasize the competitive forces at work in the market. We also look at the principle of the user pay principle in terms of infrastructure and services, which is not the case for all countries competing with us.
We cannot rest on our laurels because the world of aviation is changing swiftly. We are all concerned by the closing of Avios, which caused layoffs across the country. And there are employees who did not have the opportunity to find other work. Obviously, we were concerned about this closure because there was certain maintenance work that was no longer being done in Canada. The recent announcement made by Air Canada regarding its collaboration with the development of centers of excellence. It gave us hope. Hope means that high-caliber employees will once again work in the technological sector. The purchase of C-Series aircraft by Air Canada will allow us to join two sectors that are essential for Canada's economy, air transport and the aerospace industry. This will allow Air Canada to use aircraft that are state-of-the-art, thereby saving money, fuel, and reducing its GHGs while minimizing noise. As you know, these aircraft will be designed, assembled, and maintained in Canada. The creation of centers of excellence for the maintenance of C-Series will have a beneficial effect on the industry and will encourage air transporters to use the services offered. The Quebec government said that this could create 1,000 jobs over 15 years. In addition, the manufacture of C-Series aircraft will allow Canada to create an additional 300 jobs. Furthermore, the creation of a Centre of Excellence for Western Canada would create 150 additional jobs in Manitoba. In closing, you will understand that this will allow us to improve the law. Thank you, Madam Speaker.
Questions and comments, questions et commentaires. The honourable member for North Island Powell River.
Thank you, Madam Speaker, and thank you for the speech. I just wanted to comment on the fact that across Canada we're seeing growing disparity, and we know that good-paying jobs are getting harder and harder to come by. And a lot of that has been led by a past Conservative government that didn't really put the time into making sure that we look after workers. So I just want to ask the honourable member, knowing that we are really taking, giving power to a business to make some decisions that would leave workers behind potentially in this country, knowing that this would open the doors to allow a company to be bringing workers in rather than making sure those jobs stay with Canadians, how do you feel this is going to really make an impact in this country?
L'honorable député de Laurentides-Labelle.
Honourable member for Laurentides-Labelle.
I don't see it quite the same way as the member does. I agree protecting workers is very important, and I see these changes permitting Air Canada to bring in not necessarily fewer workers, but possibly more workers, because they can go off the non-existent Montreal urban community, off the island of Montreal, outside of Winnipeg. They can go to other parts of the provinces and do the maintenance. The aircraft they're purchasing, the C-Series, are not manufactured on the island of Montreal, but they're manufactured very close. These purchases create jobs. The aviation industry creates jobs, and having the ability to have the market flexibility allows the airline to remain competitive, which will guarantee the 25,000 jobs of the airline, not just a few. Thank you, Madam Speaker.
Questions and comments, questions et commentaires. The honourable member for Carlton Trail, Eagle Creek.
Thank you very much, Madam Speaker, and I want to thank my colleague for his comments. I'm just wondering if the member could tell the House what savings Air Canada will gain from this legislation and how many Canadian jobs these savings will cost Canada.
Honourable député de Laurentides.
Honourable member for Laurentides-Labelle.
Thank you, Madam Speaker. I cannot speak for Air Canada in terms of how many jobs will go up or how many jobs will go down. I can say that this will help the competitiveness of Air Canada because it takes locks off of them that their opponents don't have. I think that's important to help Canadian business. Thank you, Madam Speaker.
And comments, questions et commentaires. Resuming debate, reprise de débat, the Honourable Parliamentary Secretary to the Minister of Public Services and Procurement.
Thank you, Madam Speaker. It's a privilege to speak today. The bill is about modernizing the Air Canada Public Participation Act to make it more in keeping with the realities of the global air transport sector and to ensure that the Act will continue to be relevant as the aviation sector evolves in the future. First, it's important to recall that the Air Canada Public Participation Act was brought into force in 1988, primarily to provide the federal government with a legislative framework to enable the divestiture of Air Canada. This was made possible by permitting the government to organize Air Canada not as a federal crown corporation, but as a share capital enterprise incorporated under the Canada Business Corporations Act. By holding Air Canada as a share capital enterprise, the government could dispose of its equity in the company by allowing Air Canada to issue shares for public investment, which the company did through 2 public offerings, the first in '88 and the second in 1989. Air Canada returned nearly all the proceeds from those share offerings to the Government of Canada, allowing a return to be realized as compensation for support the company had during the time it was a federal crown asset. With that second public offering, Air Canada was fully divested by the government, and it has since been engaged in the air carrier industry as a private sector company. The Government of Canada's divestiture of Air Canada was in keeping with the evolution that was happening to Canada's air carrier industry at that time. Then, under the legislated framework of economic deregulation that began in '87, Canada's air carrier industry was one evolving from being a regulated industry to one that had to deal with market forces. Competition was the order of the day, providing discipline to pricing and capacity in the marketplace. Nearly 3 decades have passed since deregulation took effect, and it's now time to update the Air Canada Public Participation Act to reflect the evolution of the aviation sector. I'm referring particularly to the obligation in paragraph 6(1)(d) that requires Air Canada to include in its articles of continuance provisions requiring the corporation to maintain operational and overhaul centres in the City of Winnipeg, the Montreal urban community, and the City of Mississauga. To be viable as a going concern in today's air carrier industry means that inputs from the supply chain must be cost competitive, and that includes the provision of aircraft maintenance. Air Canada is the only carrier, both domestic and international, that has obligations such as these. All of the other carriers, including other Canadian air carriers, are free to take advantage of competitive undertakings to support their aircraft maintenance. The province of Quebec, with intervening support from the province of Manitoba and Air Canada, have been litigating the matter of that company's aircraft maintenance for a number of years. This began with the insolvency in March 2012 of Avios Fleet Performance, a third-party provider of aircraft maintenance, repair, and overhaul (MRO) services. On February 17th of this year, the province of Quebec and Air Canada mutually agreed to pursue an end to their differences in favor of a better way forward. Then, on March 14th, the province of Manitoba and Air Canada announced a collaboration of their own. In both cases, these way forward include cooperating in the establishment of centres of excellence for aircraft maintenance, one in Montreal and the other in Winnipeg. As well, Air Canada is committing to maintaining all of its newly acquired C-Series CS-300 aircraft in Quebec for at least 20 years. These aircraft will also be designed and manufactured by Bombardier of Quebec. In Manitoba, Air Canada will be facilitating and supporting the establishment of a Western Centre of Excellence by 3 of its long-standing suppliers and partners, including HoC Aero Propeller and Components, which specializes in propeller and components, propellers, wheels, brakes, and batteries; Airbase Services, which specializes in aircraft interior equipment maintenance; and Cargojet Airways, to which Air Canada has agreed to lease one of its Winnipeg hangars in favorable terms to enable it to establish aircraft maintenance activities. The Centre of Excellence in Winnipeg is expected to create 150 jobs starting in 2017, with the possibility of further expansion and job creation in the future. These are net new job increases. These developments are consistent with a company and an industry that must continually seek competitive ways of operating to stay in business. These are progressive developments where the parties are collaborating instead of litigating. This conduct should be encouraged. The legislation, as it is currently written, lent itself to this litigation about how it should be interpreted. That's why this government is proposing to amend the Air Canada Public Participation Act to remove any doubt that Air Canada can seek best-in-class, cost-competitive aircraft maintenance wherever it is offered, a choice to which all other air carriers are entitled. At the same time, we are reinforcing the expectation that Air Canada will continue to carry out aircraft maintenance in Manitoba, Ontario, and Quebec. The amendment would also induce providers of aircraft maintenance in Canada to be cost competitive, given the potential business from Air Canada, which should be able to choose from among those services on the basis of best Canadian value. As well, the establishment of a Centre of Excellence for Aircraft Maintenance will reinforce Montreal's role as a world-class aeronautical hub, bolstered also by the Montreal-based headquarters of the United Nations International Civil Aviation Organization, the presence of the International Air Transport Association, the aviation and aeronautical programs at McGill and Concordia, to name but two, and industry stalwarts like Pratt & Whitney, CAE, Bombardier, Air Canada, and others. The Centres of Excellence are good for Quebec and Manitoba and for Canada, raising the profile of local expertise, which would generate positive attention and more investment in our nation's skilled trades and knowledge-based economy. And it all begins with cooperation and collaboration by all of the parties who were formerly in dispute, but are now working together toward a common purpose. I ask that you offer the same level of support. It's my pleasure to speak to this bill, to support it, and to ask all members to do the same as the government moves to support the competitiveness of Canadian airline industry in the 21st century. Thank you, Madam Speaker.
Questions and comments, questions et commentaires. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. And we know this bill will cost Canadian jobs. The member talked about 150 new jobs in Manitoba, but you didn't mention the 400 jobs that were lost as a result of Air Canada failing to comply with their obligations under this Act. But I want to ask the member specifically because she talked about a condition that's holding Air Canada back, allegedly a condition that doesn't apply to other companies. But at the time of privatization, there was not one but four conditions put on Air Canada. For example, one of them being that Air Canada abide by the Official Languages Act. So I wonder if the member thinks that Air Canada should still have to abide by the Official Languages Act, since that does not apply to other companies, and why pick on this one out of four conditions that in fact leads to job losses in Canada?
The Honourable Parliamentary Secretary to the Minister of Public Services and Procurement.
I clearly reject the assumption that we know that it actually will lead to job losses in Canada. We have a very viable Canadian aircraft maintenance and repair and overhaul capability, and we have for many years. But the airlines are focused on delivering air service to moving people from places across the country. They're not in their core business of aircraft manufacturing. What this bill allows them to do is to purchase and procure services from companies whose core business is aircraft maintenance. So we're very fortunate to have extensive capability in Canada, and now the potential of even increased services centres of excellence, and that will make sure that our airline industry, both the commercial carriers, can focus on their business of carrying people, and aircraft maintenance organizations who can focus on maintaining aircraft. And that's why this part of the amendment of the Air Canada Act is focused on that specifically. Thank you.
Questions and comments, questions et commentaires. The honourable member for Nanaimo, Ladysmith.
Thank you, Madam Speaker. So, to the New Democrats, the government's proposal on Air Canada maintenance looks like it protects corporate interests and not workers' interests. The government's proposal sanctions Air Canada's violation of its commitments to workers. And it was a promise of the Air Canada privatization that jobs would be protected from outsourcing to foreign markets. And so through you, Madam Speaker, I ask, with Industry Canada pointing to staggering export of aerospace jobs to Asia-Pacific countries, how will the government keep jobs here at home in Canada? Thank you.
The Honourable Parliamentary Secretary to the Minister of Public Service and Procurement.
Again, this government is committed to the vibrancy of the aerospace industry in Canada, and hence is ensuring that there will still be commitment of Air Canada having its maintenance provided in Canada, but not by Air Canada, the company itself, but rather by service providers who excel and specialize in the business of aircraft maintenance, repair, and overhaul. So this is merely a redistribution. Rather than Air Canada being the primary one delivering, they are purchasing those services from other entities. And that's why this is great for Canada, for the aerospace industry, and will allow Air Canada to become more competitive on the world stage. Thank you.
Comments, questions et commentaires? The honourable member for Carlton Trail, Eagle Creek.
Thank you very much, Madam Speaker. And I want to follow along a similar vein to the questions that my colleague asked. And if, in fact, what the Parliamentary Secretary is suggesting is the reason for the amendment to C10, and that it's about modernizing the Air Canada Public Participation Act, I'm wondering if the member can then explain why the Act, this amendment to the Act, is so narrowly focused and doesn't contemplate measures to support Air Canada that won't affect jobs in Canada.
A brief answer from the Parliamentary Secretary to the Minister of Public Services and Procurement.
This amendment to the Act is primarily focused on their competitiveness around aircraft maintenance, because that's the opportunity that has presented itself and has been of significant dispute as a result of the situation with Avios. And therefore, this government is committed to ensuring the aerospace industry as a whole is vibrant, and Air Canada as well. Thank you.
Resuming debate, reprise de débat, l'honorable député de Mégantic.
The honourable member for Mégantic-l'Érable. Thank you, Madam Speaker. Madam Speaker, I'm quite confused about Bill C-10, an act to amend the Air Canada Public Participation Act and to provide for certain other measures. And I'm rising to speak to this bill today. At the outset, I'd like to say that our critic for transport, the member for Carlton Trail, Eagle Creek, gave us an excellent speech last week, and I'd like to continue. Madam Speaker, on November 3rd, 2015, the Quebec Court of Appeal, the highest court in the province, confirmed the judgment handed down by the Quebec Superior Court, which concluded that Air Canada had not fulfilled its legal obligations set out by the law concerning the heavy maintenance of its aircraft in Montreal, Winnipeg, and Mississauga. Then Bombardier officially called for a support of $1 billion US from the Government of Canada. This was made 2 months after Air Canada had invested the same amount. On February 6th, Sikorsky put itself under the Arrangement for Creditors Act, so the 80 aircraft that had been ordered were cancelled. And then in February, Air Canada talked about negotiations ongoing for negotiations with Bombardier. Madam Speaker, before going ahead, I'd like to say that I will be splitting my time with the honourable member for Boom River. Thank you. Madam Speaker, I'd like us to be clear here. We are very pleased with the decision of Air Canada to buy these magnificent aircraft from Bombardier. Not only is this a decision that will have major impacts on our aeronautic sector, but it will also give credibility to the new Bombardier aircraft. Let's hope that the other announcements made over the past few days will actually occur so that Bombardier will be able to meet the challenge to launch a new economical aircraft to compete with, for example, Airbus. Madam Speaker, now we are rejoicing in this good news about the purchase of Bombardier aircraft by Air Canada. But now we are wondering why this government is introducing Bill C-10 now. The Minister of Transport has never answered our questions on the impacts for the Avios workers. He simply talks about his communication plan. He responds that Bombardier has committed to build these C-Series aircraft, but He never talks about this this is not talked about in C10. And yet there will be major impacts on close to 3,000 workers from Avios who sees the Liberal government turning its back on them without having the even minimum decency, Mr. Speaker, of talking about the jobs that have been sacrificed. And yet, Madam Speaker, these workers were obviously not expecting this new government to betray them in this fashion. And, Madam Speaker, they're right, because they were supposed to be able to count on the influence of very influential members of Parliament. They could count on very, very influential members of the Cabinet, the Prime Minister's Cabinet. So, Madam Speaker, I'm just going to tell you about what these people said, these very influential people. They made a short speech on the Parliament Hill. Madam Speaker, this is what he said. It is such a shame to have to protest, to ask a law and order government to abide by the law. It's ridiculous. They made promises to us. They told us not to be worried. Don't worry about Avios, and now they're doing what we feared. We have lost our jobs. Now, Mr. Speaker, I'm talking about a very influential member of the government. So we're losing the type of job that we need in this country. It is not true that our best resource is in the earth somewhere. Our best resource is human resources. If workers like you, who are qualified and who are building our country every day with your hands, with your arms, and with your intelligence, and with your creativity as well. Madam Speaker, this was said before the workers of Avios. So I'm coming back to what this person said. We're refusing to invest in what made this a very strong country and endangering thousands of Canadians who travel by risking a lesser quality of maintenance. That is not acceptable.
So thank you very much for being here, and I'm with you. So that's the end of my quote. Well, I can imagine that you're wondering who would have made this speech, a very influential member here, supporting so eloquently the Avios workers. Well, here we realize that this was just rhetoric. This raises a lot of questions. People want to know. We want to know who is this influential member of the government who said these words. Who was that Liberal member who was so eloquent and so supportive of these Avios workers? Well, you are going to be extremely surprised. So stay seated. This very influential member of the government is the member for Papineau, the current Prime Minister, and he said this just a few years ago. I want to quote him again. He said, "This is wrong." Now, what has changed so much since he spoke that way on Parliament Hill? He now seems to have changed his mind completely, and has forgotten all of his promises. Yes, now that this colleague is a prime minister, the Liberal promises are no longer being respected. They're just the sunny ways. It's important to recall this episode because it shows that Bill C-10 has come out of thin air. It goes against the commitments that the Liberals made before the election, and it will cost thousands of jobs. The Minister of Transport told us that he is taking action because the provinces, including Quebec, decided to resolve their difficulties with Air Canada. But once again, I think it's important to speak the truth. The Government of Canada did agree, but there was certainly a condition, and that was that Air Canada had to keep its maintenance operations until there was a central center of excellence that was created for the C-Series aircraft. The government of Quebec did not end its court case against Air Canada. It temporarily suspended it. So why is the government in such a hurry to adopt Bill C-10? That is a good question. Bill C-10 gives no assurance that there will be jobs, not for future maintenance of the C-Series aircraft or for the current fleet. So C-10 is a hasty and an incomplete bill that takes too risky an approach. The Conservative Party believes that Air Canada should be a private sector business not funded by taxpayers to provide reliable airline service. This was the initial intention of the Public Participation Act. The bill was an effort to make Air Canada a good airline so that it wouldn't be a Crown Corporation that was not doing well. So it, under the Act, it has to comply with the Official Languages Act. It has to have its headquarters in Montreal. 75% of the voting shares have to be Canadian-owned, and it has to maintain its maintenance and revision centers in Winnipeg and Mississauga as well as in Montreal. So what other measures can be taken to support Air Canada? Well, there are a number, but the Conservative Party certainly can't support this bill. Questions and comments?
Commentaire, the honourable member for London West.
Thank you very much, Madam Speaker, and thank you to the honourable member for his comments. I did want to understand why the honourable member is not considering the creation of the Centre of Excellence in Montreal that could produce upwards of 1,000 jobs over 15 years. While the manufacture of Air Canada's C-Series aircraft could create an additional 300 jobs, plus more jobs in Ontario and Manitoba. I'd like to understand why you're dismissing that. Thank you very much.
L'honorable député.
The honourable member for Mégantic-L'Érable. Well, Madam Speaker, the answer to that question is quite simple. It's because the maintenance jobs were had to do with Bombardier, and we're talking here about Air Canada. There is no mention of Bombardier in Bill C-10. We want to encourage Bombardier to create jobs and have its maintenance done here. But we're talking about jobs that already exist in Canada, people who have skills and expertise. We want to protect those who maintain our aircraft already here in the country, and that is my answer to my honourable colleague.
Questions et commentaires. L'honorable for Cowichan, Malahat, Langford.
Thank you, Madam Speaker, and I appreciate listening to the member's speech, especially his recanting of the quotes from the Prime Minister in 2012. At that time, of course, the Conservatives were in power. I would argue that the Liberals are actually doing something worse now because they are actually going to be changing the Act, whereas previously the Conservatives just refused to uphold the Act. So I'm just wondering if he could explain to this House, now that the Conservatives are in opposition, what has led to their forceful adoptance of the Act, and why are they such stern defenders of it now when they weren't prepared to do so in 2012? Thank you, Madam Speaker.
L'honorable député de
The honourable member for Mégantic-L'Érable. Madam Speaker, I think that we have to look at this bill and the spirit behind it. This bill will enable Air Canada to abandon its maintenance operations here in Canada. There's no guarantee that that work will continue to be done here in Canada. It can be done abroad under this new Act. So we need to make sure that skilled jobs for the maintenance of
Air Canada's fleet be done here?
Questions et commentaires. The honourable member for Carlton Trail, Eagle Creek.
Thank you very much, Madam Speaker, and I'd like to thank my colleague for his comments this morning, as well as thank him for the very good work that he is doing on the committee. I do want to give him an opportunity to perhaps speculate on the number of measures that could have been put into this act to amend the Air Canada Public Participation Act, and why he thinks the minister and this government are being so narrowly focused with this bill.
Honourable member for Mégantic-Lérable.
Moi aussi, Madame la Présidente, je tiens.
Thank you, Madam Speaker. I want to certainly pay tribute to the great work being done by the critic for transport in the committee, and she does very good work. She and her team prepared a very good set of notes that show what could have been done with this kind of legislation to make sure that Air Canada remains competitive. I mentioned certain points in my speech, but there are other things that Air Canada could have done that I didn't get a chance to say, and that is to make sure that the aero sector, the airports are safer. We could make sure that NAV Canada was changed, better governance, better alignment with the Americans, and so on.
Resuming debate, the honourable member for Bow River.
Thank you, Madam Chairman, Madam Speaker. It's a privilege for me to speak on Bill C-10, an act to amend the Air Canada Public Participation Act to provide for certain other measures. Canada's had a long history when it comes to flight. 1909, Silver Dart, Bedeck Bay in Nova Scotia, one of the first flights that occurred in the world. 1913, first cargo flight was the delivery of the Montreal Daily Mail to Ottawa. Its return flight, that was a little iffy. But I have some concerns with the legislation as it stands. One of my biggest concerns is that 3,000 Canadian aircraft maintenance jobs are on the line as a consequence of this legislation. That's a lot of highly skilled, high-paying jobs that we're discussing. It would be a major loss to the communities affected were these jobs to vanish. And I think that would be one of the most negative consequences with this bill. I'm concerned because this could negatively affect the communities of Mississauga, Montreal, and Winnipeg. I find it strange that Air Canada never mentioned aircraft maintenance costs as being prohibitive in their various comments made in the context of the past Canadian Transportation Act review. So I'm skeptical about this legislation. What does it seek to achieve? Why is it trying to fix a problem that doesn't seem to be a problem at all? If we really want to do service to Air Canada and other Canadian carriers, let's fix the situation that experts at Air Canada have identified. Trans-Canada Airlines started in 1937. 1937 saw the first stewardesses being hired. They had to be nurses. Why? To ease passengers' concerns for safety of flying. We now have an excellent maintenance that we can trust, and Canadian flyers on Air Canada can trust this. For the younger members of the House, in 1995, the name was changed to Air Canada. I have some suggestions for ways Air Canada could be made more competitive both here in Canada and at an international level. My suggestions may not put the jobs of 3,000 Canadians workers in jeopardy. One suggestion is tying airport fees to tangible projects with clear sunset clauses. When sunset clauses are effective and travelers see direct results of the fees in improvements, it may result in reduced ticket prices. That means more passengers on Air Canada flights and a direct benefit to the airline's bottom line. That is one way to help Canada without risking 3,000 jobs in Winnipeg, Mississauga, and Montreal. A second way to make Air Canada more competitive is by reducing the excise tax on aviation fuel. We have high taxes for aircraft fuel. There are a variety of federal fees and taxes inflate the cost of air tickets in Canada, making it very expensive to fly within Canada. Air fuel excise tax is one of these examples, so why wouldn't the Minister of Transportation look at this as a possible way to make Air Canada more competitive? As they pointed out in their brief, these excise taxes were supposed to be reinvested in airport infrastructure. If we could fix the excise tax problem, I'm sure Air Canada would appreciate such a change. One of the major issues that ends up affecting Air Canada and all carriers at airports is the issue of security. What we need for security screening is an intelligence-driven, risk-based passenger screening process. This would lead to smoother, quicker system that would save critical time for airlines like Air Canada and airport staff and relieve the burden of the one-size-fits-all process we have now. Let's streamline the security process so that we make, at the same time, a more simple yet more robust security screening process. Let's try and fix some of the issues Air Canada has stated. One of the issues with respect to security is the Air Transport Security Change, or ATSC. This is a fee that is charged to passengers to cover the costs of the Canadian Air Transport Security Authority. It was founded in the wake of 9/11 terrorist attacks and ensures security of those who fly within Canada. The issue is, as Air Canada pointed out in submission, the amount of fees collected from passengers is too high. Looking at the numbers, the amount taken in this surpasses the budgetary needs. In 2013-14, this left a surplus of $123 million. That is a problem, Madam Speaker. Oh, Mr. Speaker. Thank you. My question is, why are we making such a small change to the Act? What kind of support will this give to Air Canada? We're not quite sure what it will do to help the airline. It hasn't been made clear to us. What do we know that is putting the jobs of 33,000 airline mechanical staff in jeopardy in Mississauga, Montreal, and Winnipeg? This bill is not worth the risk. I do not think an unintended consequence of passing this bill would be just that these 3,000 jobs could leave Canada. I'm asking the government to take another look at this and to see that this is not the right course of action to pursue. The Minister of Transport believes somehow this legislation will assist Air Canada in cutting costs. I appreciate that he tells us this is his goal. What we'd like to see on this side of the House, Mr. Speaker, are some actual numbers. I know that our transportation critic, the hardworking member of Carlton Trail Eagle Creek, has asked for this from the Minister. So I'm asking again, can he provide the actual amount this change will deliver in savings to Air Canada? If not, then it asks him to give us more details as to the rationale of this legislation. As we are very concerned about these 3,000 workers, can the Minister confirm that he has consulted with them about any of these changes? Has the Minister consulted with their union on this? Airport rent is another sticking point. Airport rent and fees in Canada are incredibly high, and it makes it very hard for airlines like Air Canada to operate in this business climate. I'm quoting directly from Air Canada's submission to the Canadian Transportation Act review. Quote, in fact, depending on the type of aircraft, Air Canada landing and terminal fees in major Canadian airports are 35% to 75% higher than in major U.S. airports. When factoring in the difference between the airport improvement fee and its U.S. equivalent passenger facility charge that are paid by passengers, airport-related costs are on average 83% higher per departing seat in Canada than in the U.S. This is uncompetitive cost environment is not only causing the leakage of Canadian passengers to the United States, but also the loss of international traffic traveling to or via Canada, end of quote. And this is from the recent National Post article. The World Economic Forum ranks Canada number 16 out of 140 countries for the quality of airport infrastructure. Great, but number 130 when it comes to ticket taxes and airport charges, end of quote. This loss reduces our ability to position our country as an international gateway and to grow our airlines and airports. There's potential to work something out, as I hope the Minister is looking at other options to help the airline industry find solutions to these real problems that have been identified. Air Canada is seeking regulatory changes to how we manage the aviation industry. From their submission, our country also needs an efficient process for determining new aviation policy and rules, one that is able to keep pace with the rapidly evolving technology and operations of industry, end of quote. The issues I've outlined in my speech are real issues, many of them raised by Air Canada itself. Why are we looking at such a small change to the risk of 3,000 workers in Montreal, Winnipeg, and Mississauga? I cannot support the legislation. That being said, I'm looking forward to seeing the minister might offer in terms of really supporting the Canadian airline industry, hoping there will be some future pieces of legislation I could support. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires? Resuming debate, reprise. Oh, sorry, I didn't see there. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you very much, Madam Speaker, and I thank the member for his excellent speech. This issue was first brought to my attention because of a constituent who specifically lost his job as a result of, in his view, Air Canada's failure to live up to its obligations under the Air Canada Participation Act. And we haven't heard anything from the government in terms of what the economic benefits are to this measure. All we know is that job losses are involved. So I wonder if the member can speak a little more to what other measures, what alternatives could exist that could make Air Canada more competitive that wouldn't actually involve the loss of jobs that's associated with this bill.
The honourable member for Bow River.
Thank you, my colleague, for the question, and thank you for my colleague for sharing this time today. One of the things that we understand, and it's really important, if we all own vehicles, we learned quickly the mechanical upkeep of those vehicles are important. When the dealerships have strong support staff and mechanical people in there, we trust to drive our vehicles. And those people live locally in our communities. And I think this is what's important, as my honourable member would say. We trust our vehicles because of the level of trust we have in the staff that maintains them. The only way that works if you're flying is if we could trust the maintenance staff that keeps our airplanes flying. So I think it's critically important to have those people in our communities so we understand and trust that we're flying safely in this country. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. L'honorable député de Jonquière.
The honourable member for Jonquière. I thank my colleague for his speech, and I would like to know what he thinks about what happened when the Conservatives were in power. Nothing was done to keep Avios jobs in Canada. The bill is not clear, or the law is not clear, in terms of keeping jobs in Canada, and the Conservatives were insinuating that the LPPCIC had to be respected. I'd just like to know what he would like to say about that.
Thank you, Madam Chair. Speaking of history, I'm speaking of times when we've had tremendous aircraft industry in this country, recognized worldwide for the safety it has created, how well our flights and our equipment is done so that we feel safe flying. So for me to change this to possibly moving jobs somewhere else where we wouldn't have that insurance is a risk factor for our citizens who want to fly and feel safe in this country. Thank you, Madam Speaker.
Questions et commentaires. Questions and comments. L'honorable député de...
The honourable member for Laurentier-Labelle.
I'm a pilot myself, and I can tell you that I would never put anything to do anything that would endanger aviation safety. So I'd like to know from the member from Bow River does he believe the existing act should be left untouched, or is what the member has done a net improvement at all? Thank you, Madam Speaker.
The honourable member for Bow River.
Thank you, Madam Speaker. Speaking specifically to this piece of amendment, this one piece only, I believe that it affects directly the safety of where these jobs provide for our airline industry, and it affects where they may be in our Canadian cities. So I'm speaking specifically to this particular amendment that I believe causes very much concern in the sense of communities where these jobs exist and for the ongoing safety of our airline industry. Thank you, Madam Speaker.
Commentaires, questions and comments. L'honorable député.
The honourable member for Mégantic-L'Érable. A short question. Thank you, Madam Speaker. I just wanted to ask my colleague, who seems to have good knowledge of the history of Air Canada, if he agrees with the fact that one day, without being a member of Parliament, a member can say one thing, and when they're elected Prime Minister, they can change their position. I'd like to know what his reaction is to that sort of change of attitude.
River.
Thank you. It reminds me of the Canadian passenger arriving at the pearly gates, and there was clocks behind St. Peter, and one of them said, saints, and Mother Teresa's hands hadn't moved on the clock, and they said, why? She never lies. The next one was airline mechanics, and it hardly moved, and he said, they're very truthful, they have to be honest. And the next one was federal politicians, and the clock wasn't there. And the person wanted to know, he says, well, years ago we took that clock and we used it as a ceiling fan. Thank you.
Debate, reprise de débat. The honourable member from Humber River, Black Creek.
Discussion today, and also pleased to see you sitting in the chair and doing a great job on behalf of all of us as women. It's a delight to see you constantly in that chair. So, as I said, I am pleased to stand and speak in support of Bill C-10, legislation that, while somewhat technical in nature for a lot of people to be able to follow, is incredibly important for Canada's national airline, for the aerospace sector, and for the related jobs and economic activity on which the Canadian economy so importantly relies. But before I get to my main points, I want to take a moment to offer my compliments to some of my colleagues who have already spoken on this important topic. We've heard a variety of issues raised, issues that the committee will have an opportunity to review and discuss and to look at very thoroughly. So there already has been very good debate on Bill C-10, as we've heard on Friday, and as of course we've heard from my colleagues today, and I'm eager to add my voice to that. But inasmuch as debate in the House is important, as chair of the Transport Committee, I'm eager to hear from the stakeholders once the legislation is referred to the committee. But before we get to that, I'd like to specifically compliment the Parliamentary Secretary who touched off this debate by clarifying several important points for all of us. For example, the Parliamentary Secretary confirmed that this bill is being submitted for consideration by the House in the context of an historic investment by Air Canada in Canada's aerospace sector. Now that is very true, and as members all know, Air Canada has announced its intention to purchase some 75 C-Series aircraft from Bombardier. Adding to that investment, Air Canada has promised to ensure that these planes will be maintained in Canada for at least 20 years. That's a very significant investment and a huge help for our economy. The importance of these decisions cannot be understated when it comes to jobs and growth of Canada's economy. Allow me to be even more specific. The facilitation of the creation of centres of excellence will be a boon when it comes to jobs across the aerospace sector. Parliamentary Secretary verified that Quebec has estimated that the creation of the Centre of Excellence in Montreal alone could produce 1,000 jobs in over 15 years, while the manufacturing of Air Canada's C-Series aircraft could create an additional 300 jobs. And there will be more jobs in Ontario and Manitoba. So these are not just jobs. These are families that will enjoy a solid income, benefits, and stability for years to come. Those families will support communities, and those communities will fortify our great country, Canada. I say these are the kinds of investments and outcomes that Canada should be pursuing. They are market-driven, they promise to improve Air Canada's bottom line, and they will allow for service improvements by prompting technological investment right here in Canada. But of course, there have been genuine impediments to this approach in the past. For example, in 2012, Quebec's Attorney General took legal action against Air Canada, accusing the carrier of non-compliance with the provisions of the Air Canada Public Participation Act. Madam Speaker, I must stop for a moment. I am sharing my time today with the member from La Salle-Mard-Verdun. I forgot to mention that to you. But now, Quebec has made the decision to end that litigation in light of Air Canada's investments in the aerospace sector. and the related promise involving maintenance commitments in Quebec. This opens an important window for Canada to modernize the Air Canada Public Participation Act, which is what this is all about. But this goodwill, fortuitous timing, and opportunity must not be squandered. But we need action now. You see, the purpose of Bill C-10 is to amend the sections of the Act that have to do with Air Canada's operational and overall centres. With these changes, Air Canada will establish a centre of excellence in Quebec, in Ontario, and in Manitoba. These centres will be able to not only service Air Canada's planes, but also to offer those services to other national and international airlines. Creating this new revenue stream, coupled with increased flexibility for Air Canada management, means a more dynamic and modern business structure, and clearly that should be good for everyone, Canadians, Air Canada, and all of our other spin-off industries. But let's not forget that the current legislation is nearly 30 years old, and this is no longer 1989. The current Act was the product of a time when countries around the world were moving away from high regulation and public ownership in sectors such as air transport. Canada wasn't immune to global trends, and so we followed by deregulating the air transport sector, commercializing our major airports, and transforming Air Canada from a Crown corporation to a private company. This was the right move at that time. But the world has changed, and to be successful in 2016, we must again look to modernize. But none of this can happen if we refuse to provide Air Canada and our aerospace sector with the tools needed to prepare for the challenges of modern businesses and the investment environment. Now, many across the way have raised questions in the House, justifiable questions, questions that are seeking answers. They ask, why must we do this change now? And why must this change occur so quickly? Well, the truth is that the aerospace and air transportation sectors exist in very dynamic environments. Other air carriers, Canadian and international, are not subject to the same obligations regarding their maintenance facilities. That means they can seek out efficiencies in ways that are simply not available to Air Canada, a fact that places Air Canada at a competitive disadvantage. Bill C-10 helps to establish a new balance. So if we want the economic benefits of high-paying, quality, reliable jobs promised by all of the other sectors, we must arm the players within that sector accordingly. And this is why we are here today, and it is why Bill C-10 is so important for all of us in the House and for all Canadians. In other words, this government has introduced this legislation at a critical time in the history of Canada's aerospace industry. Not only is Bombardier offering a game-changing product for the entire global industry, but Canada's most important airline is planning to take advantage of the technological differences and efficiencies and the heightened environmental performance by generously and wisely investing domestically for its aircraft fleet renewal. Investing in a cutting-edge product that was designed and manufactured mainly in Canada will improve Air Canada's ability to compete globally and to serve all Canadians. So everyone would win, but only if we act now. To be clear, the government wants Air Canada to have the flexibility needed to organize and manage its business operations here and around the world. We understand that the air transport sector has evolved and will continue to evolve, and Air Canada needs the tools and the regulatory supports to keep pace. But this must be done while maintaining adequate safeguards for Canadian workers and suppliers. And that is why we are proposing to ensure that the Act continues to require Air Canada to carry out aircraft maintenance in certain Canadian regions. I believe that Bill C-10 does all of these things, and I'm eager to hear from stakeholders at the committee so that we can give a thorough hearing to the many people who will want to make their comments so that we can ensure that we have a strong, positive piece of legislation going forward that will ensure that jobs are here in Canada, but that if work is done elsewhere, it's also done to Canadian standards. Thank you very much, Madam Speaker.
Questions et commentaires, questions and comments. The honourable member from Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. I thank the member for her speech. She said a number of things that might seem curious insofar as the bill doesn't mention Bombardier at all. So I wonder if the member could just clarify, was the decision to introduce this bill influenced by Air Canada's decision to purchase the C-Series? And would the bill have been introduced had the decision to purchase the C-Series not been made?
The honourable member from Humber River, Black Creek.
Madam Speaker, the issues before us require action in order to make sure that Air Canada, that's the issue we're dealing with, has the flexibility to go forward. We all know, those of us who spend a lot of time at airports, see the amount of growth that's happening at any of our major airports, the amount of new airlines that are coming in. And it's important that Air Canada, in whatever it has to do, has the flexibility to be able to move forward, to be able to compete, to be able to make sure that our aircrafts are number one, and to give an opportunity to showcase Canada every step of the way.
Questions and comments. Questions et commentaires. The honourable member for Elmwood, Transcona.
Thank you very much, Madam Speaker. I think it's worth noting, in fairness to the honourable member who just asked a very good question, that there wasn't an answer to that in there, and it's and it's odd to have the Liberals on the one hand wanting to invoke what's going on with Bombardier and the C-Series order in their speeches, and then when they're asked a pretty obvious question, which is if you're going to be talking about Bombardier and Air Canada in the same breath, I think it makes a lot of sense to be asking, well, in that case, is there a connection between the two? I think it seems obvious that there is. It'd be nice to hear the government just say so. In her remarks, she talks about, often the honourable member who just gave her speech talks about flexibility, about the need to compete, Madam Speaker. What I don't understand is, when we talk about the virtues of this deal in terms of jobs and centres of excellence and how wonderful it is that we're going to be building these centres of excellence and how well suited the areas in which Air Canada is going to build those centres of excellence are to doing the work that they're going to be doing competitively, what's missed is that nothing in the Act as it stands prevents those centres of excellence from being established. So why is it that we have to give up legal guarantees for good jobs, different kinds of jobs, in order to get these other jobs if these areas are so well suited to the kind of work that they're going to do? And I would mention, Madam Speaker, because we are giving up jobs with a legal guarantee, what legal protections are there for the jobs at the centres of excellence?
The honourable member for Humber River, Black Creek.
Every time we can try to ensure that whatever legislation we pass is respectful of jobs and communities and people that have those jobs, but opens doors and provides opportunity for new jobs in new areas. Bombardier is a natural partner of Air Canada. We'll have an opportunity to showcase new planes, and if it goes in that direction. But investing in our aerospace sector is a sector that has tremendous growth for Canada to be able to succeed in, to be able to offer expansion, to be able to offer jobs for many Canadians. And more importantly, I think on the aerospace industry, there's a lot of young people who are very keen to get more involved in the aerospace industry. And I think our job as legislators is to make sure that companies competing in Canada have a level playing field. They have the flexibility that they require to be able to do well. And they should not be held back by legislation and things that occurred in 1989 or 1997. We need to be realistic. It's 2016. If we want our national carriers and we want our companies to be able to compete on a broader scale, we've got to make sure that we take the handcuffs off and that we provide the opportunities for them. Thank you.
Very brief question. The honourable member for London West, just a question.
Just wanted to thank you, Madam Speaker. I just wanted my honourable colleague to explain why it's so important at this point to move it on to the committee stage.
The member for Humber River, Black Creek, please.
Well, many of the colleagues that have participated in this debate Friday and today have outlined concerns that they have. That we won't get any answers to those concerns here in the House, but we have an opportunity to hear from various people, the stakeholders and so on at committee, and to be able to make other recommendations as necessary. Thank you, Madam Speaker.
Resuming debate, reprise de débat, l'honorable.
The Honourable Parliamentary Secretary, the Minister of International Trade. Thank you, Madam Speaker. On 24th of March, our government tabled in the House of Commons Bill number C-10, an act to amend the Air Canada Public Participation Act. More specifically, the object or the goal of this bill is to amend sections of the bill that concern maintenance centres for Air Canada. It's important to emphasize that the tabling of this bill has been done in a historic context for the Canadian aerospace sector. As you know, Madam Speaker, Air Canada announced last February that they had the intention of purchasing up to 75 C-Series jets from Bombardier, and that they would do the maintenance on these planes in Canada for a minimum of 20 years as of the first delivery. Air Canada will also establish a Centre of Excellence in Quebec for the C-Series and another centre for the west of Canada that will be situated in Manitoba.
That will allow not only for maintenance of Air Canada aircraft, but also to offer different types of services to other national and international carriers. In other words, Madam Speaker, the bill that we have introduced is the crossroads for the Canadian aerospace industry. Not only will Bombardier offer a product that is a game changer in the industry, thanks to its efficiency and operational performance, but it will also allow other national carriers to invest massively in the renewal of their fleets. These investments, Madam Speaker, seek to improve Air Canada's ability to address world competition, to better serve Canadians by investing in an avant-garde product that is mostly designed and constructed in Canada. In this historical context, Mr. Speaker, we are proposing to modernize the Air Canada Public Participation Act, which seems partly to be obsolete. More specifically, the bill amends paragraph 6.1d concerning the Air Canada's obligation to maintain the operational and overhaul centres in Winnipeg, Mississauga, and Montreal. Obviously, the aim of the bill is to ensure that Air Canada continues to undertake maintenance work on its aircraft in certain regions of Canada. At the same time, Madam Speaker, the bill was thought out with, in mind, service to the public, that is, to privatize a Canadian corporation, a crown corporation, to make it competitive and viable. As you have obviously seen, the air transport sector has greatly changed since the coming into force of this bill in 1989. In 2015, Air Canada welcomed more than 12 million passengers and provided regular direct service to 63 airports in Canada, 56 in the United States, and 86 in the rest of the world. That is Asia, Oceania, Europe, Africa, and South America. As you know, Madam Speaker, Air Canada is not immune to the reality of a very competitive global market. For example, other national and international carriers are not subjected to the same obligations with regard to their maintenance facilities. It is also important to point out that we must consider Air Canada in its global market, a market that is characterized by large international corporations that provide services over vast networks using extremely costly equipment. This market is also very sensitive to fluctuations due to its cyclical nature. You know as well as we do, Madam Speaker, that all you have to do is have a pandemic or an accident to see the market waver, and then there are tremendous consequences on the income and revenue of an aircraft company. Such companies offer essential services to our country, but also to the outside world, and they are extremely important sources of employment. For example, Air Canada alone employs close to 25,000 people This economic context leads us to believe that the Air Canada Public Participation Act could impose limits on the company's ability to be competitive and profitable. Therefore, we believe that the current statute is not compatible with an air transport approach that is based on competitive forces and the market as the best way to offer services at a reasonable price for users. Air Canada, like any company, needs more flexibility to evolve in a competitive environment in order to remain viable in the long term. In that regard, Madam Speaker, and with regard to the air transport sector in Canada, the federal policy focuses on the competitive and market forces of the company. Madam Speaker, we are also focusing on the principle of user payer with regard to infrastructure and services, which is not the case for all countries that compete with us. Therefore, we cannot rest on our laurels, because the world of aviation is changing very swiftly. Obviously, we were all concerned by the closure of Avios, which brought about layoffs across the country. Although some elements of Avios were bought during the bankruptcy process, there were employees who did not have the opportunity to find another job in the same sector. We were obviously concerned about this closure and the fact that Air Canada had stopped doing some maintenance operations in Canada. The recent announcement made by Air Canada concerning the C-Series and its collaboration with the development of centres of excellence restored hope to us. The hope that good quality jobs would return to this high-tech sector. The announcement that Air Canada would be buying C-Series aircraft brings together two elements for Canada's economy, the aerospace industry and the air transport sector. This would allow Air Canada to use aircraft that are state-of-the-art in terms of technology, thereby reducing its cost, its fuel consumption, and its greenhouse gas emissions, while minimizing noise. As you know, Madam Speaker, these aircraft will be designed, assembled, and maintained in Canada. The creation of centres of excellence for the maintenance of C-Series aircraft in Quebec and Manitoba will certainly have a beneficial effect on the industry and will likely attract other air carriers and entice them to use these services that will be offered there. The Quebec government estimated that this Centre of Excellence would create 1,000 more jobs over 15 years. In addition, the manufacturing of the C-Series aircraft will allow Air Canada to create an additional 300 jobs. Moreover, the creation of a Centre of Excellence for Western Canada will create 150 additional jobs in Manitoba. In closing, Madam Speaker, you will understand that by amending the wording used to describe the activities and the place where they will take place will allow us to modernize this statute and therefore make it more relevant. Thank you.
Commentaire, the honourable member for Calgary-Nose Hill.
Thank you, Madam Speaker. I'm wondering if my colleague opposite could tell the House what government intervention should be used, if any, to sustain Bombardier should they come to the government requesting funds.
Honourable Parliamentary Secretary.
Madam Speaker, I would respond to the honourable member's question, thanking her for it, and saying that dossier is before the government. We are trying to promote in this country the technological advances that come with the aerospace industry. We're trying to protect jobs, but we're trying to do so, Madam Speaker, in a responsible fashion.
Questions and comments, questions et commentaires. The honourable member for Elmwood-Transcona.
Merci beaucoup, Madame.
Thank you, Madam Speaker. I would like to say that there is a contradiction between the two arguments that the Liberals are putting forward. They're saying that these changes will create more jobs for Canadians because there will be centres of excellence in Winnipeg and Montreal. But they have forgotten that there is no guarantee that such jobs will actually be created from year to year. And on the other hand, they are saying that the situation has changed since 1989, and that Air Canada needs flexibility, that it needs to be competitive, and that really means that when we're talking about opportunities for other air carriers, they're talking about work being done in other countries. That's the competitive advantage. That's what we're talking about here. So the Act doesn't need to be changed to ensure the jobs that are already in the centres of excellence to have the advantages of flexibility. To have that, they're saying that we have to send the jobs outside Canada. So can we at least hear from the government that this bill is going to mean that significant jobs are going to leave Canada? The Honourable Parliamentary Secretary. Thank you, Madam Speaker, and I'd like to thank my honourable colleague, especially for having put his question in French. I'm going to throw the question back to him. First, I'm going to talk about the second aspect of his question, that is the context. The context is very conducive, the current context is very conducive to changing the statute. Why? Because the situation has changed from 30 years ago, and this bill sought to privatize a Crown corporation. Now things are different. Now we are seeking to improve Air Canada's ability to be competitive on the market. And therefore, the context is very important to understand regarding this bill. Second, to come back to the first part of his question, it's a matter of investing in the industry, because we do have a market. So we can't guarantee jobs, but we sincerely believe that these amendments will create jobs. Questions and comments?
The honourable member for Carlton Trail, Eagle Creek. I'll get to know it by heart.
Thank you very much, Madam Speaker. It's a new riding, so it's not a name we've heard very often in this House yet. I thank my colleague for his comments on this amendment, and given that Air Canada provided a comprehensive submission to the Canada Transportation Act review, and this measure was not a part of that, and given also that the Minister has had this report in his hands since last December, I'm wondering if he could explain why the Minister would undertake to amend this legislation and not the opportunity to address all of the measures that Air Canada did put into their submission.
Brève réponse du secrétaire parlementaire.
Brief response from the Parliamentary Secretary, please.
Thank the honourable member for her question. We are proposing modifications that we feel will give Air Canada the tools to compete in an international market. We didn't accept every suggestion. We picked the ones we thought were the best.
Resuming debate, reprise de débat, the honourable member for Calgary-Nose Hill.
Thank you, Madam Speaker, and I'll be sharing my time with the member from Huron-Bruce. You know, Madam Speaker, I'm really impressed that the Liberals have been able to bring the debate about Bombardier and government intervention about Bombardier to the House in a bill that doesn't mention Bombardier at all. And my colleague, who is the opposition critic for transport, I think really outlined what this bill is all about in her speech last week. She outlined the curious timing of various announcements around Bombardier, Air Canada announcing its order from Bombardier's C-Series aircraft. The same day Air Canada made its announcement to purchase these airplanes, the Minister of Transport announced that he would lessen Air Canada's obligation under the Air Canada Public Participation Act. Then the minister put forward the bill that we're debating on notice on March 14th. Air Canada announced that it would, and so on and so on and so forth. So what I think, let's just call a spade, Madam Speaker. What we're talking about here is this bill is quid pro quo for Air Canada buying the C-Series. And I wish we were just having a simple debate about what the government is going to do, if anything, from Bombardier, because since the dawn of time, this has been an issue that is essentially about robbing Peter to pay Paul, with Peter being Western Canada and Paul being Bombardier. So with this particular issue, with this particular bill, I just have a few questions. There was a report that was tabled, or a report that was completed in, I believe it was the middle of 2015, around the transportation industry, and Air Canada put forward a series of recommendations on different legislation or requirements that could be put in place to make their industry more competitive internationally. And it's quite a thick document. It's over 95 pages, and they actually put forward over 60, actually I count 66 here, recommendations to do just that. And what's in this bill is a very small component of that. My big concern is that I don't understand what the impact that this is going to have on Western Canada, specifically Winnipeg's aerospace sector. There's been so much effort put into, by various different levels of government, building up Winnipeg's aerospace sector. It's arguably a success. What does this bill do for that? That's my concern. So what this bill does is it actually removes the requirement for Air Canada to have its maintenance jobs located in the places that it does right now. But for the purposes of my speech, I'm going to talk about Winnipeg. Manitoba, I believe, dropped their litigation against Air Canada in return for the building of a centre of excellence, as many of my Liberal colleagues have talked about today. But what happens when this bill passes if Air Canada decides to, let's say in 5 years, close down the Centre of Excellence? Or what if they don't exactly comply with how many jobs they're touting? And frankly, we haven't even heard what type of jobs are going to be created through this Centre of Excellence. For me, this is just a terrible example of government intervention run amok, because by trying to use this quid pro quo bill to bolster Bombardier, it's going to have a huge unintended consequence effect on the aerospace sector in Winnipeg. And this isn't an academic exercise. If you talk to the employees of Aveos, I think that they'd probably have something to say about this. There was a really good article that I got from CJOB as a former Winnipegger. I have to give out a shout to one of my favorite radio stations, where employees were talking about how I don't understand why we need a centre of excellence for aircraft maintenance. We're already a centre of excellence for aircraft maintenance. This was the quote that I really liked out of this. We know that for people that lost their jobs, they're not entirely happy because they lost good, well-paying jobs. And right now, they don't have any of those jobs. We're getting 150 back, and we think we can grow to that in 2017 to start a higher number of jobs. And then it goes on to talk about how many of these jobs moved to South America, I believe, when Aveos closed. They went to El Salvador. Quebec was suing the airline after the closure of the Aveos fleet performance in 2012, which led to 2,600 employees in 3 provinces losing their jobs, including more than 400 Manitobans, and these jobs went to El Salvador. Why wouldn't the Liberals just bring forward the issue of Bombardier to study? They voted down an amendment or a study in committee, an industry committee, to have Bombardier executives come and talk about their needs. You know, I pick up the paper and I read things like one of Bombardier's vice presidents saying that they actually don't need a backup plan. We don't need a backup plan because what's secured is already more than we require. As a legislator who is responsible for voting on public policy that impacts people's jobs, these are things that would be good to know. So, this would be my suggestion for the Liberals. Rather than simply tabling this bill and ignoring the fact that there are many jobs on the line in Western Canada, which frankly always gets, I'm struggling for an appropriate term, always gets the short end of the stick when we talk about Bombardier. They should just be bringing that forward for us to discuss. I really don't think this is the right option at this point in time. And if with the time I have, since we're talking about Bombardier, what I don't understand is that the government is bringing forward this piece of legislation essentially to prop up Bombardier when there's over 100,000 people that are out of work in Alberta right now. You know, the government, the Liberal government, for anyone who's listening, what they are doing with this bill is that they are going out of their way to make sure that there's quid pro quo for a company that is going to receive orders for an aircraft. They're changing legislation. They're making sure that there can't be countersuits for Air Canada offshoring some of their jobs, as there has been in the past. They're doing all of this, but have we heard one thing about them making the regulatory environment better for the energy sector? No, we heard the opposite. We heard we're going to change the regulatory environment for the energy sector such that it's going to become a lot less clear for investors looking at new projects. What else did they say? We're going to look at a carbon tax. We're going to put more burden on investment in that area. We are going to go out of our way to say even if a major energy infrastructure project like Energy East goes through the review process and gets a green light, that we don't know if Cabinet's going to approach it or not. And here's the other thing that's relevant to this bill. They talk nothing about retaining skilled labour. In Western Canada, one of the key determinants to economic growth, Madam Speaker, is the retention and attraction of skilled labour. Over and over again. That's what you hear. It doesn't matter what industry you talk about. In fact, the Economic Development Winnipeg, in their brief about the aerospace sector in Winnipeg, talks about the skilled labour workforce, a very specialized skilled labour workforce. What happens if these jobs disappear? What's the impact on other companies in the area? They have not talked about this. And it's the same thing with the energy sector. They haven't talked at all about how they're going to ensure that people in Alberta stay in Alberta. So if there is an opportunity to see new projects go in the future, that investors aren't going to look and say, I guess all of the people that were the expertise in here, that we'd built up this awesome world-class infrastructure of talent, I guess they've moved away. Maybe we shouldn't build here. This bill is so short-sighted, and it just shows the Liberal approach to dealing with economic issues in this country. First of all, look at a squeaky wheel company in Montreal. And I'm not saying it's not important to the Canadian economy, but we should have a debate. If we're going to talk about legislative measures on how we support it, let's talk about Bombardier. And the second component is, where's the discussion on Western Canadian jobs, both in the aerospace sector and in the energy sector? We're just not seeing that. How much time do I have left? 1 minute. It's incumbent upon the Liberals to look at what they're doing here. What they're doing with this bill should be called the quid pro quo bill. We should be voting on it as such. There's no guarantee that these jobs should stay in Winnipeg, and we have no information on what this is going to do for the aerospace sector as a whole. And they should also be talking about why they're not raising this for over 100,000 people that are out of work in my province, Madam Speaker. This is crazy, and I really hope that they reconsider their priorities in future legislation.
Questions and comments, questions et commentaires. The honourable member for Elmwood Transcona.
And thank you to the honourable member for her remarks and for joining with me and trying to notice the way in which the Western Canadian aerospace industry has really been left out of the discussion. It's why we should be taking a more comprehensive approach and actually trying to develop an aerospace strategy for the country that involves all its regions rather than engaging in these kinds of one-off deals. Now, part of the narrative that we're hearing from the government side has to do with this happy coincidence of Air Canada just happening to make an order of Bombardier jets and provincial governments just happening to drop their lawsuits. And so isn't the time propice, I think was the French word used earlier by the parliamentary secretary, to bring these changes forward. But I think, I don't know if it's Sunny Ways just sort of occluding the government's view of how negotiations actually happen, or if there's something more cynical at work, Madam Speaker. But I wonder if the member could comment on how a change in government, and a government that's willing to gut the Air Canada Act, changes the bargaining position of provincial governments that heretofore had a case to make in court and no longer do. So of course they're willing to sign up for a centre of excellence because it's the best they can get in a context where the federal government is selling them out.
The honourable member for Calgary-Nose Hill.
I guess 2 points to my colleague's question. First of all, yes, what this bill will do is it allows Air Canada to set up a centre of excellence, but it removes the legal recourse for provinces to be able to take Air Canada to court should they offshore their maintenance jobs. So that's a problem. But I think he also raised a very interesting point in terms of looking at a strategy for our the competitiveness of our aerospace sector in general. Things like looking at how we can ensure that small, medium-sized enterprise are certified and ready to get into the supply chain of OEMs. Looking at how we retain and attract the best and brightest labor from around the world to ensure that we have innovation in here, that we have receptor capacity such that technology that's developed in Canada is manufactured in Canada. Companies are started in Canada. There's so many things they could be doing, Madam Speaker. Instead, they chose the quid pro quo bill.
Questions and comments? Questions et commentaires. The honourable member for Carlton Trail, Eagle Creek.
Thank you very much, Madam Speaker. And I want to thank my colleague for the comments that she's made in regards to this bill and for the experience. I want to acknowledge the experience she brings to this conversation as the former Minister for Western Economic Development and the importance of legislation as it pertains to retaining skilled expertise in our country. I also then want to, taking that into consideration, ask her if she would be willing to comment on the very narrow focus of this piece of legislation. We know that the minister has in his hand the Emerson report, in which Air Canada made a number of recommendations around what could be done to ensure that they were more competitive. And I'm wondering if she would be willing to comment on that.
The honourable member for Calgary-Nose Hill.
I gladly would be able to comment on that. In fact, I've got the recommendations in my hand. There's over 66 of them. Many of them have to do with taxation structure, building global hubs and developing strong airport infrastructure. There's, I think, over a dozen on that. Ooh, it looks like 24. An efficient regulatory system. I think there's 24 there as well, too. There's quite a few, Madam Speaker. There's so many recommendations that the government could look at that would benefit other industries as well, that would actually bolster things like the Winnipeg aerospace sector. But instead, again, they put forward, short title of the bill, the quid pro quo bill.
Resuming debate, reprise de débat, the honourable member for Huron-Bruce.
Okay, thank you, Madam Speaker. It's a pleasure to rise here today in the House and talk about this bill, and I'd just like to start off by saying that I like Air Canada. I fly Air Canada when I can and generally support what they've done, so I'm not an anti-Air Canada person up here speaking, for sure. How did we get here to this point? Well, there's many roads and paths to get us here to this point, but I think one of the biggest impacts to Air Canada in recent times, certainly in the last decade, we don't need to go too much further than to 2008, 2009, where we saw sky-high fuel prices in the midst of an economic downturn. These caused many, many problems for Air Canada, many other corporations as well in North America. Pension solvency was a huge issue, massive debt load, and many other issues. So that's kind of where, if we take a look back almost 10 years now, that really put Air Canada in a make-or-break situation. I give them full credit for what they've been able to do the last decade to turn around a company that's over 70 years old and, in fact, have 40% top-line revenue growth. So they're obviously doing many, many things correctly. So I will congratulate them on that. One thing I think that would be tremendously helpful, we've heard it today and we've heard it in the past, and certainly when I was at the technical briefing some weeks ago, I wasn't quite sure if this bill passed all the litmus tests or smell tests that you'd like to see in a bill. And I think it'd be great if the minister would turn over his correspondence that he's had with Air Canada, with Bombardier, with the government of Quebec, so we can understand these timelines that we are now we're looking at. And it could all be coincidence, I don't know, but certainly many things happen in a very short period of time that does lead to the raising of a Spockian eyebrow, to say for sure. Like I said, full credit to Air Canada. They have turned around their finances, and their 2015 annual finances were reported just a little while ago. Record profit, $1.22 billion in net income for 2015. 2014, which was also the previous record, was $531 billion of net income. So obviously, many things falling into place for that to occur. As well, another accounting term and reporting term. I always refer to it as EBITDA, but it's your earnings before interest, taxation, amortization, depreciation, and restructuring. So I guess the aviation industry adds an R to the reporting. That was also a record, $2.5 billion on that number. Another great number that's working in Air Canada's favor is the cost per available seat mile. That was another record. In addition to that, the average projected fuel cost, which obviously plays a huge part into the success or failure of an airline's finances. I think they're projecting about 52 cents a litre, if memory serves me correctly, compared to last year, which was over 60 cents a litre. And if we compare that to 08 and 09, obviously these are really good. So there's a lot of things that are trending in the right direction for Air Canada and their finances. And in fact, things are going so well, they also announced that they're going to repurchase up to 10 million shares, and with the option of repurchasing additional 5 million shares. Those shares are close to $9 per share. So obviously there is some available capital to Air Canada at this point in time. I want to read, Madam Speaker, this is actually directly from Air Canada's site, from their media room, to talk about their expenses on the expense side and what they experienced in 2015. This highlights maybe one of the points that I think many are scratching their head over as to the argument about where and when and how they should be able to perform maintenance. Aircraft, this is from their site again, aircraft maintenance expense is expected to increase $250 million from the full year of 2015. So if you read that just on its own, you'd think, well, geez, they are making a point here. But when you read further, which approximately $100 million is estimated to be due to the weaker Canadian dollar when compared to the US dollar. So that obviously means they're performing many maintenance contracts around the world, and when they bring all those financials back home, there's a $100 million negative impact on that. So that also would raise an eyebrow. In addition, the remaining increase is mainly due to higher end-of-lease maintenance provisions, which is due to fewer lease extensions in 2016 versus 15, and the impact of a higher number of operating leases, an increase in maintenance expense to the Boeing 787 aircraft, and the fly-by-hour arrangements that they have. So my point, Madam Speaker, is if doing business in Canada and if the maintenance of Canadian labour was such a burden, we would have seen this certainly in the 14 annual report. We would have seen it in the 2015 annual report, where the CEO or the CFO would have made explicit mention of these high costs. In addition to that, CEOs travel the country, they go to conferences, they make presentations, whether it's to investors, whether it's to to industry. The CEO does not mention, and I'm not criticizing him because he has done a fine job of the economic performance and operational performance of the company, but I would think that that would have to come up in a presentation or in an official document that you're sending out in annual or quarterly reports, is the long-term concern for high labor costs. We don't see that. I'm not the first to mention this today, but certainly the narrative is not being made for these high costs. I go back to my time when I worked in the automotive parts sector. In 2000, we started seeing these problems on a competitive front. and 15 years later, we're still seeing these. But you would see in annual reports, the CEO and the CFO always commenting about the lower labor rates in developing countries. Also, I've heard today and in other speeches from other members, mainly from government members, talking about this will unshackle Air Canada. They will now be able to become competitive around the world on maintenance, etc., which is fine. But what I would say, and this goes back to the review of the Transportation Act, is we can't just do one thing on competitiveness. This is just picking a low-hanging fruit. It's neglecting all the other issues that would allow the aviation industry here in Canada, the airline industry more specifically, to be extremely successful. One key component, and this is a long-standing issue, it deals with traffic rates, landing slots or spots, and the issues around the protectionist nature that we have here in this country. Just to give you an example, Air Canada flies to Dubai every day. They fly from Dubai back to Canada every day. Emirates, you would think the reciprocity would go to Emirates Airlines, where they would be able to fly every day into Pearson and every day from Pearson back to Dubai. My research indicates to me that it's only 3 days a week. It's the same with the major airline out of Qatar. They have 3 flights a week from Qatar to Montreal, vice versa. So why not include that in here? Landing slots. Why not make it available? I mean, Air Canada has increased the number of flights to Dubai. Why not reciprocate? This is all about competition. It's all about thinking about the consumer, the traveler, and letting them have the choice. So that's just one example. The Review Act actually mentions that in it, that there should be 7 days a week for flights to those countries. So I lay that out. I've talked about timing. Others have talked about Avios. I would be interested as well to hear from the union that just ratified their agreement on behalf of 7,500 members. If they were aware of this legislation coming forward, I'm sure they would have some interesting comments for the public on that. And in addition to you can get cheaper elsewhere, I don't believe that. I know at the company I used to work for at Westcast, we dealt with China, we dealt with South Korea, we dealt with Mexico, we dealt with all these, but where do they go now to get world-class R&D work? Right in Ontario, because we have the know-how. Thank you.
Questions and comments, questions et commentaires. The honourable member for London West.
Thank you, Madam Speaker, and thank you to my honourable colleague for his comments. I just want to take the time to reiterate that the government wants to ensure that the changes to the Act continues to require Air Canada to carry out aircraft maintenance in certain Canadian regions. And this proposed legislation maintains that commitment. And the Act currently refers to the City of Winnipeg, the City of Mississauga, and the Montreal urban community. And I take note that the Montreal urban community, which no longer exists as a jurisdiction, did not include all of Greater Montreal. And for example, it didn't include Mirabel. So also Air Canada's activities extend throughout the Greater Toronto area, not just Mississauga. So there have been a number of changes, and this changes to the acts will enforce that the jobs stay within Canada. Thank you, Madam Speaker.
Or Huron Bruce.
I would call that, at the very best, a technical amendment of very little subsequent consequence. But I would say, what's the urgency then? If that's one of the only things that we need to change with this, why waste all this debate on one little line in the legislation? Why not tell Air Canada, hey, listen, we will do this, but we also want to have a much larger bill that has many more benefits that dovetail in with what the review said. To do this little bit and then try and tell us that, next year we're going to do another one. And we know there's 4 years to a mandate. You really only get one chance to do a piece of legislation like this. That's not going to work. This is going to be post-2019. We should have waited. We should have done a lot more to help make aviation in this country competitive.
Comments, questions et commentaires. The honourable member for Elmwood-Transcona. Make it brief, please.
Thank you very much, Madam Speaker. Part of the issue around C10 is really about the nature of a deal and the worth of a deal. So in 1989, when Air Canada was privatized, there was a deal made with Canadians that we would continue to enjoy the benefits of having a major aerospace company be Canadian, and that means do the work in Canada. Now, we've heard a lot from this government that deals can't be broken, Madam Speaker. The deal is sacrosanct. What would the word of the government of Canada be if we went back on a deal, Madam Speaker? So I wonder what kind of responsible conviction it is that allows a government to break a deal with Canadian workers and not be willing to say no to a country with a terrible human rights record and sell them arms, Madam Speaker. What kind of responsible conviction is that?
Very, very brief answer, and then you can. The period for questions will continue after question period.
Thanks very much. I appreciate the question. All I would say is you will get no better results from the people that are currently doing the job today. Those are your center of excellence, the people that are doing those jobs. Fine if you want to move it 20 miles, that's fine. But to think you're going to move to, say, a place in my riding, where are all these workers going to come from? You have the skill in those communities. Let them do their work and let them do it well.
The honourable member will have approximately 2 minutes when we resume this debate after the orders of the day. Statements by members. The honourable member for Avalon.
Thank you, Madam Speaker. This summer, the town of Conception Bay South will host the 2016 Newfoundland and Labrador Summer Games from August 13th to the 21st. The best young athletes will come from all over the province, including the French islands of Saint-Pierre and Miquelon, to compete and demonstrate the skills of elite-level sport. The theme for the 2016 Games is Compete, Believe, Succeed. I'm confident the athletes, coaches and supporters will represent their teams to the best of their ability while taking time to enjoy the comforts and hospitality of Conception Bay South. I would like to thank the Games Chair, Mr. Eric Schibler, and his entire volunteer committee for their commitment. A tremendous amount of hard work from skilled volunteers has made these Games possible. Mr. Speaker, I invite all my colleagues in the House to consider visiting the wonderful province of Newfoundland and Labrador for the 2016 Summer Games in Conception Bay South this August. Thank you.
The honourable member for Cariboo Prince George.
Mr. Speaker, as Member of Parliament for Cariboo Prince George, I have the honour of hearing about organizations in my riding that are truly remarkable. I'd like to say a big congratulations to the 15 recipients of the 2016 Quesnel Community Foundation Awards. Alex Fraser Park Society, Baker Creek Gymkhana Club, Cariboo Hoofbeats Assisted Activity Program Society, Gavin Lake Forestry Education Society, Island Mountain Arts, Lightning Creek Ski Club, Old Age Pensioners Organization Golden Center of Q City Singers. Mr. Speaker, Quesnel Barrel Racers, Quesnel Curling Club, Quesnel Partnership for Student Nutrition, Quesnel Search and Rescue Society, Quesnel SPCA, Quesnel Technics for Gymnastics Club, and the Quesnel Youth Association. Thank you to all the people involved. The time and effort you give is an inspiration to others and makes our communities a better place to live. And again, a huge thank you and congratulations from Ottawa to Quesnel.
The honourable member for Central Nova.
Thank you, Mr. Speaker. This weekend marked the 270th anniversary of the Battle of Culloden, and this May will mark the 35th anniversary of the celebration of my riding. In the aftermath of this historic and deadly battle, a handful of surviving Scots emigrated from Britain to northern Nova Scotia, and their journey is part of the reason we have such a pronounced Scottish heritage in my province today. The celebration is a special one that takes place at the Noidgert Cairn along the beautiful Northumberland Strait, where some of the battle's survivors are buried today. My grandfather, Earl Fraser, takes the history of this event so seriously that he once kicked a hitchhiker out of his car when he found out his last name was Monroe. In fact, years ago, my grandfather gave me a copy of the battlefield plan for Culloden, which I now proudly display on my office on the hill. To celebrate our Scottish heritage, I invite everyone to attend this year's Antigonish Highland Games, which is celebrating its 153rd year. This year's event will take place from July 8th to 10th, features piping, dancing, heavy events, ceilidhs and clan gatherings. Shlán Tava.
The honourable member for Victoria.
Mr. Speaker, on Holocaust Remembrance Day, we reaffirm our pledge never to forget. Today I rise to ask the government to honor its commitment to Holocaust-era property restitution and compensation. When Nazis occupied Central and Eastern Europe, residents were subject to widespread property confiscation, much of which was never returned to its rightful owners. To this day, these victims remain uncompensated. Appropriate compensation would afford survivors of the Holocaust, who have already endured the unfathomable, some security and relief in their latter years. Mr. Speaker, over 40,000 Holocaust survivors have settled in Canada. We are home to the third largest concentration of survivors in the world. Canada must uphold the Ottawa Protocol on combating anti-Semitism and the Terrorism Declaration. Mr. Speaker, the past cannot be changed, but that does not absolve us of our responsibilities to survivors today. It would be fitting for our government to renew its commitment to Holocaust-era property restitution as but the smallest measure of justice for survivors' unthinkable losses.
The member for Willowdale. The honourable member for Willowdale.
Mr. Speaker, April marks National Poetry Month, providing us with an opportunity to recognize the centrality of poetry to Canadian identity and culture. In that spirit, I am honoured to welcome to the House today a much-celebrated Canadian, Ms. Suzanne Buffum. Ms. Buffum is an award-winning Canadian national treasure, having been awarded the Gerald Lampert Memorial Award and the CBC Literary Award for Poetry, as well as having been shortlisted for the prestigious Griffin Poetry Prize. In quintessentially Canadian fashion, Ms. Buffum's first foray into poetry was inspired by a family canoe trip to the Yukon while she was in primary school. She has certainly come a long way. Over the weekend, the Globe and Mail described her latest collection of poetry, A Pillow Book, as one of the most finely controlled, subtly structured books of Canadian poetry in recent memory. This evening, Ms. Buffum's contributions to the poetic canon will be celebrated at the Christ Church Cathedral in Ottawa. I would like to acknowledge Ms. Buffum.
Honourable member for Mégantic-L'Érable. Thank you. Mr. Speaker, in a tiny gymnasium in the Robertsonville sector of Thetford Mines, a 16-year-old young man is preparing to become one of our best Olympic hopefuls. Thomas the Ghost Chabot trains while other young people have fun. He follows a strict diet while his friends eat poutine. He self-imposes severe discipline because he knows that efforts get results. Thomas Chabot is a young boxer who won the Canadian Junior Championship title, a third national consecutive title. He was also named the best boxer of the tournament. And for the third consecutive year, this is never been done before. Jason Genet of the same club also won the Canadian Junior title. Thomas Chabot wants to participate in the 2020 Olympics. He'll be supported by his trainer, Stéphane Lachance, his father, Constant Chabot, and all the population of Thetford Mines, and I hope by all Canadians. He's an example of courage and determination, and I'm proud, on behalf of all colleagues in the House, to congratulate him for his outstanding accomplishments, and I hope he achieves his Olympic dream.
The honourable member for South Shore St. Margaret's.
Mr. Speaker, I'm rising in the House today to recognize students in South Shore St. Margaret's for their science fair projects through South Shore Regional, the Tri-County Regional, and the Halifax Regional School Board Science Fairs. Projects included the effect of adverse weather conditions on solar panels, water quality and environmental responsibility, bridge design, Wi-Fi security and safety, and so many others. Adam Culbert, Kennedy Frittenberg, Sohail Ghaffari, Madison Greek, and Lindsay Nickerson will be going on to the Canada-wide Science Fair in Montreal. I am so keen to speak about these students today, not only because of their hard work, but because Canada needs innovative thinkers of all ages. The questions that these students are investigating are ones that drive our country forward to become more healthy, prosperous, and environmentally sustainable. Congratulations and kudos to all of the students, and a big thank you to the teachers, parents, guardians, and schools that support this new generation of movers and shakers.
The honourable member for Brampton North.
Mr. Speaker, this week marks the National Organ and Tissue Donation Awareness Week.
I rise to raise awareness about the importance of registering as a donor. 1 Canadian dies every 3 days while waiting for a transplant. In Ontario alone, more than 1,600 men, women, and children are waiting for life-saving organ transplants. I encourage all Canadians and my fellow members of Parliament to register themselves as donors. 1 organ donor can save up to 8 lives and enhance as many as 75 lives through tissue donation. In Brampton, Ontario, there are close to 500,000 people eligible to register as donors, and I want to let my constituents of Brampton North know that they can quickly and easily register online by going to beadonor.ca. Mr. Speaker, thank you for this opportunity, and I hope that you too are registered as an organ and tissue donor.
Yes. The member for Edmonton Manning.
Mr. Speaker, I rise today to pay tribute to a constituent, a young man tragically taken from us just as he was beginning to make his mark. Kadmus Halabi was 22 years old, an engineering student at the University of Alberta. Then came the diagnosis, leukemia, something not quite real for someone so young. He fought bravely, inspiring others with his attitude. In the words of J. Fraser Forbes, Dean of Engineering at the University of Alberta, the world has been robbed of a talent, not permitted to develop or realize a potential that would undoubtedly perform great works. He was a kind and gentle person with a bright future, extinguished too soon. A life lived to the fullest, though all too short. Our prayers with the family as they mourn.
Yeah. The honourable member for Surrey Centre.
Mr. Speaker, today I would like to address a tragedy in my constituency that occurred 4.5 years ago when Maple Battaglia, a talented young woman, a health science student at SFU, an upcoming model, was murdered at her school. The death of Maple Battaglia has, for the past 4 years, been a colossal wound to our community. When I speak to the Battaglia family and members of our community, they share the story of a young woman who was a trailblazer, an inspiration to her peers, someone who was known for a strong and courageous character, a woman who I am certain would have had a bright future. On March 7th, 2016, the perpetrator was sentenced to life in prison. I believe too often there's a sense that violence against women is a private issue. To all those women and families listening, I challenge you to break this silence. Partner violence, and in particular, violence against women, is a community issue that we need to address together. To the battalion.
The member for Toronto Danforth.
Mr. Speaker, on April 17, 1985, Section 15 of the Canadian Charter of Rights and Freedoms came into effect, enshrining equality in our Constitution.
The adoption of this section marked a turning point in the history of Canada. For the first time, women's rights to equality were enshrined in legislation. That is why on April 17th we celebrate Gender Equality Day.
It states that every individual is equal before and under the law. It gives every Canadian equal protection, regardless of race, national or ethnic origin, color, sex, age, or mental or physical disability.
Gender Equality Day reminds us that we must never take fundamental rights for granted. Never. Today, I invite you to remember this major event in our history and reflect on the various ways through which our shared values, respect, equality, and fairness, continue to enrich our lives as Canadians. Thank you.
The honourable member.
The honourable member for Richmond-Arthabasca. Mr. Speaker, today all of my thoughts and prayers are with the families and loved ones of the victims, particularly the 2 Quebecers who died in the earthquake in Ecuador. The death toll keeps rising. There are at least 350 persons who have lost their lives and more than 2,500 are wounded. During such events, we can only recognize how strong nature is and how vulnerable man is. I am with the people of Ecuador. The Laflamme family was in the wrong place at the wrong time when their roof crashed down on them. Pascal, Jennifer, Lauriane, and Arthur were real globetrotters, a united family who had just traveled around the whole world together. We can only imagine all the sadness that Pascal and his daughter Lauriane, the two survivors, are currently experiencing. In conclusion, I offer all of my support to the Canadian government in the management of this tragedy, and my most sincere sympathies are with the Quebec families who are showing exemplary strength under the circumstances.
The honourable member for Whitby.
Mr. Speaker, April is Parkinson's Awareness Month, a month-long campaign across Canada to recognize those impacted by the disease. Parkinson's is a disease of the brain that touches almost every aspect of daily living. It is a progressive neurodegenerative disease to which affects more than 100,000 Canadians and to which there is no known cause or cure. Therefore, most Canadians, including many of us in this chamber, know someone who is affected. Parkinson Canada offers services and support to those living with Parkinson's, their caregivers, and their family. More broadly, Parkinson's disease is a part of a larger group of neurological conditions which affect millions of Canadians. We must do more to decrease the stigma associated with neurological conditions and mental health conditions by increasing our understanding, education, and awareness. Thank you.
The honourable member for Algoma, Kapuskasing, and Manitoulin.
Mr. Speaker, I rise to honour OPP Constable Al Boyd, who recently retired after serving the communities of Manitoulin Island for 35 years with dedication and commitment. Though he grew up in Montreal, Al quickly adapted to life on Manitoulin Island and adopted it as his own. While many people knew him as Community Services Officer, he performed many different roles, both within the OPP, in his community of Little Current, and on Manitoulin Island. Al joined the OPP Auxiliary before becoming a police officer, was a crisis negotiator in the Northeast region, and was recognized as Volunteer of the Year for his work with Manitoulin North Shore Victim Services, among many other accomplishments. Al was instrumental in the implementation of the UCCM Tribal Police and built bridges with the island's First Nations. His voice was always welcome and instantly recognizable as he delivered daily OPP radio reports. I ask all members to join me and offer our thanks to Al Boyd for his dedication and commitment to public safety over the years and congratulate him on a distinguished career. Happy retirement, Al.
The honourable member for Thompson, Kamloops, Thompson, Caribou.
Thank you, Mr. Speaker, and it gives me great pleasure to welcome Edward Dostoller, also known as Fast Eddie, to Ottawa. Fast Eddie is a constituent of mine from Kamloops whose goal is to run across Canada and back, and to do this unaccompanied. His mission is to raise awareness and funds for breast cancer and Alzheimer's research. He began his 22,000-kilometre journey in Victoria last March. 6 months later, he reached Cape Spear, Newfoundland. He is on his return trip back to Victoria. I would like to encourage all members here to lend their support to Eddie as he passes through your constituency. And Eddie, just remember that everyone back home in Kamloops admires your courage and determination and are extremely proud of your accomplishments.
The Honourable Member for Avignon, La Métis Matin, Matapédia. Mr. Speaker, over the last few days, Ecuador and Japan were hit by deadly earthquakes. In Ecuador, it was the most powerful earthquake to have hit this country in decades. Hundreds are dead, thousands are wounded. It's with great sadness that we learned of the death of 2 Canadian citizens, Ms. Jennifer Mon and her son, Arthur Laflamme. On behalf of all members in this House, I want to express my most sincere condolences to the Mon and Laflamme families, their loved ones, and everyone affected by this devastating earthquake. We also want to wish a quick recovery to the wounded. Canadian officials in our Quito embassy are trying to provide the necessary assistance to families and also to all Canadians affected by the earthquakes. Canada will continue to cooperate with local authorities in Ecuador and Japan to assess the repercussions of the earthquakes and the needs on the ground. But today, above all, our thoughts are with the Mon and Laflamme families. Thank you.
Oral questions, questions orales. L'honorable député de Lac.
The honourable member for Lac Saint-Jean. Mr. Speaker, we might point out that an earthquake of record intensity hit the province of Manabí in Ecuador. This was on Saturday, and a Quebec family living there for a few months lost 2 of its members. On behalf of the official opposition, we would like to offer our sincerest condolences to this family. Mr. Speaker, can the government provide an update on these tragic events and what it is doing to help this country that has decreed a state of emergency? The Honourable Minister of International Development. Mr. Speaker, please allow me to express our sincerest condolences to the grieving family, and I would like to reassure them that they will be accompanied at the consular level. We have been in contact with local authorities to assess the impact of the earthquake and the after effects on the ground, and I can say that we will be supporting the local authorities to the tune of $1 million. The Honourable Member for Lac Saint-Jean. Mr. Speaker, recently we warned Canadians that the Liberals' excessive spending today would become the taxes of tomorrow. And on Saturday, the former parliamentary budget officer sounded the alarm, and he confirmed what we have been saying for some weeks. He is warning Canadians against possible tax hikes that will have to compensate for rising deficits. Canadians realize that they can't trust this government. Mr. Speaker, can the Prime Minister tell us which taxes he intends to increase in order to reimburse his out-of-control spending? The Honourable Minister of Finance. Mr. Speaker, we want to invest in our economy to grow our economy for our people of today and Canadians of the future. We know it is very important to do that. We have very low interest rates and a GDP level that is one of the lowest in the G7. Now is the time to grow the economy with investments. It will be good for now and for the future. Member for Lac Saint-Jean.
Mr. Speaker, former budget watchdog said this Saturday what our official opposition has been saying for the past few weeks. This government lacks transparency. He said, when you don't see the details, usually somebody's trying to hide something. There's a reason for the lack of transparency. Canada cannot trust this government, Mr. Speaker. Does the Prime Minister have something to hide? Why the lack of transparency?
The Minister of Finance.
Mr. Speaker, we've been open and transparent with Canadians and will continue to do so. We've shown Canadians important measures that can grow the economy today and that can grow the economy tomorrow. We made it very clear that we wanted to show measures, infrastructure investments, innovation measures that can make a real difference. We've shown 2 years of measures in order to make sure Canadians understand there's more work to do in the future to make sure we invest Canadians' money wisely in growing our economy.
Member for Regina Capel.
Speaker, they just think that they're transparent because Canadians are finally seeing through them. As families prepare to file their taxes, Canadians are discovering just how mean-spirited the Liberal budget was. They've lowered contribution limits on tax-free savings accounts. They've eliminated income splitting for families and canceled important tax credits for fitness, arts, textbooks, and education. Now, experts agree that Canadian families are worse off under the Liberals. Will the Liberals show a little compassion and reverse their cold-hearted tax policy?
The Honourable Minister of Finance.
Mr. Speaker, we want to help families who are really challenged. The measures that the member opposite was speaking about do not help those families most in need. We put in place measures that will encourage tax fairness. The Canada Child Benefit will help 9 out of 10 families who get that benefit. We will see more families with more money in their pockets for things for their family, for their children this year than last year and the years before.
Member for Regina Capel.
just not the case, Mr. Speaker. The Liberals are so off base that they're actually out in left field. And while the Prime Minister would rather watch the game from the owner's box, we want kids on the field. By striking out the children's fitness tax credit, the Prime Minister is putting Canadian families in a real squeeze play. Instead of hitting one out of the park, the Prime Minister keeps hitting fouls. Will the Liberals listen to Canadians and bring back the fitness and arts tax credits, or would they prefer the kids watch the game from the bleachers?
The Minister of Finance.
Mr. Speaker, the credits that were being spoken about by the member opposite are credits that unfortunately were not available to those kids who are most impoverished in our country. We want to create tax fairness for all Canadians. Our measures will help 9 out of 10 families with children to have more money in their pockets. There will be more children on more sports fields this year than in the years gone by.
Member for New Westminster, Burnaby.
We have just learned that senior executives of the Canada Revenue Agency took advantage of cocktails, duck confit canard, duck confit poutine, and Merlot sauce filet mignon served at the very posh Rideau Club, treated by people like KPMG, who they're supposed to be monitoring and investigating. How can Canadians trust these investigative powers when they are being treated by the people that they are supposed to be investigating? The Honourable Minister of National Revenue. Mr. Speaker, I would like to point out to Canadians that our government is transparent and open. With regard to the facts alleged by my colleague, I will be clear. This event was organized by the Professional Accountants of Canada, who are a professional body, and most of our employees who work in accounting and in auditing are part of that professional body. The Honourable Member for New Westminster Burnaby.
Remedial course in what conflict of interest really means, Mr. Speaker. The Minister of Justice was caught raising funds at a private law firm. Now senior CRA officials are at private parties hosted by people they're supposedly investigating, while KPMG negotiates sweetheart deals to get millionaire clients off the hook. Now, it doesn't take a quantum computer to see this doesn't add up to any accountability or transparency at all. So will the minister reopen the sweetheart deals and launch an investigation into this apparent conflict of interest?
The Honourable Minister of National Revenue. Mr. Speaker, Canada is a partner with which this agency has collaborated in Canada before, and the agency will continue to cooperate with its partners, including the CPA. It meets with its partners in order to put forward its activities and interests and promote tax law. The officials who were tasked with the KPMG file and who formulated recommendations thereon did not take in the reception organized in 2014 and 15 by the CPA. The Honourable Member for Laurier-Sainte-Marie.
Canada's ambassador recently laid out this government's priority in Saudi Arabia. Oil and gas, agriculture, healthcare, mining, etc. But no mention of human rights. Yeah, riders whipped, opposition members executed, women made second-class citizens, and 20% of the government's own human rights assessment is being blacked out. Why is the government making oil, gas, and arms sales its priorities while looking the other way when it comes to human rights abuses?
The Honourable Permanent Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. Our government is committed to advancing human rights everywhere, including in Saudi Arabia. We do not miss an opportunity to raise this with our Saudi counterparts, nor do we miss opportunities for positive engagement. Canada has a strategic partnership with Saudi Arabia. We maintain an ongoing dialogue with Saudi Arabia on a number of issues, including human rights and the critical role the kingdom is playing in efforts to tackle ISIL in the front lines.
Honourable Member for Laurier-Sainte-Marie. Mr. Speaker, with regard to the sales of arms to Saudi Arabia, the government has been duping Canadians for weeks, and now we're beginning to understand why. Canada's ambassador to Saudi Arabia laid out his priorities, but he forgot one: human rights. That is completely left out. So why is the government so bent on being such a good crony of such an authoritarian regime? The Honourable Parliamentary Secretary.
Mr. Speaker, let's be clear. This contract was signed under the previous government. During the election, the Conservatives, the Liberals, and the NDP committed to honouring the contract. In fact, the leader of the NDP said you can't cancel a commercial contract retroactively. It's just not done. Our Prime Minister has made it very clear that we will not weaken Canada's credibility by tearing up this contract. The release of the report on Friday was the first of many steps we will be taking to provide greater transparency on human rights assessments. Thank you.
For Carleton.
To quote the government, Budget 2016 proposes that further reductions in the small business income tax rate be deferred. But wait, the small business minister said this month, quote, "I wouldn't say it was deferred." Mr. Speaker, if it was not deferred, then it is either A, going ahead on schedule, or B, cancelled altogether. Which is it?
The Honourable Minister of Small Business and Tourism.
Thank you for the question, Mr. Speaker. Small business owners want and need a robust economy to succeed. We are making investments to support that growth. Small business owners need strong consumers. Our middle-class income tax cut, the Canada Child Benefit, our investments in infrastructure, incubators, accelerators, and the list goes on. All of it, absolutely all of it, supports small and medium-sized businesses, their consumers, the middle-class Canadians who own them, and the people who work hard for small business. Thank you, Mr. Speaker.
Honourable Member for Carleton.
Well, she didn't answer the question, Mr. Speaker, and as early as this Wednesday, the government will introduce legislation which would amend the Income Tax Act to raise the small business tax rate by a half point, a point, and a point and a half over the next 3 respective years. Mr. Speaker, I wonder if the member will rise today and confirm that she and her government are abandoning plans to raise taxes on small businesses and that she will agree with the Conservative plan to keep taxes low for our job creators.
Honourable Minister of Small Business and Tourism. Minister of Finance.
Mr. Speaker, I'd like to be very clear. We put forward a budget that helps small business. We put forward a budget that maintains the small business tax rate. No taxes are being increased here. We put forward a budget that will help consumers in Canada, the very people that buy goods and services from small and medium-sized business. We're going to grow this economy. It's going to help small business. It's going to help Canadians across this country to have better lives.
Honourable Member for Richmond Centre.
Mr. Speaker, last week the Minister of Small Business told us to look at the budget in regards to small businesses. So let's do that. The fact is, the Liberals dismissed recommendations from the Finance Committee and ignored recommendations from small business owners. The Minister claims to be working with stakeholders, but recent history shows there is no sense in trusting what they say. When will the Minister stop hiding behind empty promises and stand up for small business owners?
The Honourable Minister of Small Business and Tourism.
Thank you for the question, Mr. Speaker. I have been working closely with small business owners and stakeholders across this nation. Since being put in this post, I've met with almost 250 stakeholders, small business owners, and the people who work hard for them. Our budget actually supports small businesses. We are listening to Canadians, we are listening to small business owners, and that's what we'll continue to do. Thank you, Mr. Speaker.
The Honourable Member for Richmond Centre.
Mr. Speaker, the Minister's mandate letter tells her what her priorities are. One of these is, and I will quote, work with the Minister of Finance as the small business tax rate reduction is implemented. Can the Minister for Small Business explain why her Finance Minister ignored her and instead raised taxes on small businesses?
The Honourable Minister of Small Business and Tourism.
Thank you for the question, Mr. Speaker. This government is taking a whole-of-government approach. We work very closely with each other. Part of working together is listening to each other and engaging in conversations and difficult conversations. I work closely with the Minister of Finance. We have consultations and discussions every day. What we're doing is we're not just listening to each other, we are listening to Canadians, small business owners, because we need to ensure that they have the robust economy that they need. And that's what we'll do. Thank you, Mr. Speaker.
Honourable member for Portneuf-Jacques-Cartier. Mr. Speaker, this government is turning its back on SMEs in Canada. It promised to reduce their tax rate from 11 to 9%. Another broken promise. Higher tax rates, payroll tax hikes, a carbon tax, nothing in this budget to help small businesses to create more jobs and be more competitive. Mr. Speaker, why is this government attacking these creators of jobs and wealth? Honourable Minister of Small Business.
Mr. Speaker, and I'd like to thank the member for the question as well. We actually reduced taxes. In January, the tax rate went down from 11 to 10.5 for small business owners. Furthermore, we will be reducing EI premiums for small business owners. We are giving small business owners the support that they need. We are growing strong consumers. Our middle-class tax cut, the Canada Child benefit, all of these will support our customers and our small business owners. We will continue to do the good work that we are doing. Thank you, Mr. Speaker.
The Honourable Member for Portneuf-Jacques-Cartier. Mr. Speaker, this government should respect our Canadian families, not take them for fools. The Liberals would have us believe that this budget is good for them, but that's false. Their tax burden will increase by close to $4 billion over the next 2 years, with the scrapping of the children's fitness and arts tax credits. Families have the right to know how much this is going to cost them. Will this government be honest and come out and tell them directly that it is at families' expense, their family's expense that is going to finance its astronomical deficit? The Honourable Minister of Finance. Mr. Speaker, we began by reducing taxes on the middle class. 9 million Canadians have more money in their pockets thanks to this tax cut. But in addition, with the Canada Child benefit, 9 out of 10 families with children have more money this year. On average, $2,300 more. This is a budget for the middle class and for people who want to join its ranks. It grows the economy and will do so for future.
Churchill River.
Mr. Speaker, a legal misstep has allowed the Catholic Church to avoid paying millions of dollars to victims of residential school abuse. No funding could ever really compensate for the suffering of defenseless children at the hands of those who are supposed to care for them. But to discover that legal miscommunication has led those responsible off the financial hook is shocking and unacceptable. Will this government step in and demand full payment for the victims of this tragedy? Thank you.
The Honourable Parliamentary Secretary for Indigenous and Northern Affairs.
Mr. Speaker, we're committed to certainly achieving reconciliation for all those that are tragically impacted. It seems that the previous government did create an unfortunate misjustice that has allowed, Mr. Speaker, them to not own up to their implications. But, Mr. Speaker, we want to pledge to the people, despite the actions of the former government, that will continue to encourage them, Mr. Speaker, and all parties to reach a settlement and a reconciliation that is appropriate.
The Honourable Member for Saint-Hyacinthe-Bagotte. Mr. Speaker, what we learned today concerning the residential schools and the Catholic Church is shocking. Mistakenly, the government allowed the church to shirk its legal obligation of amassing $25 million for programs to help the victims of residential schools. The road to healing this, with regard to this national tragedy, is long and difficult. The church should not be allowed to shirk its obligations, even though this was a mistake, and it betrays the objectives of healing. How can the government justify such an aberration?
Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. We far from justify. In fact, Mr. Speaker, we too are very concerned about what has happened here. We'll continue to work with those involved, including the Catholic Church, to try and achieve the full reconciliation that is owed to those that are tragically impacted. Unfortunately, we have no control over the correspondence that has allowed them to be off the hook that was originally sent by the former administration.
The Honourable Member for Red Deer Lacombe.
Mr. Speaker, the Minister of Trade was in Manila on November 19th.
She had her seat reserved on the government Challenger to make her way back home, but instead, she booked herself through LA and charged the taxpayers nearly $20,000 for a trip to Hollywood. Wow. And the reason? A vanity interview. While the interview with Bill Maher was painful to watch, it turns out it was just as painful for Canadian taxpayers. So why have Canadian taxpayers been stuck with the bill for her California dream?
Permit for Secretary for International Trade.
Mr. Speaker, we're proud of the work that our minister has done advancing Canadian interests around the world. All expenses on all of her trips, Mr. Speaker, are transparent and done according to all the various ethical guidelines that are imposed on her.
Member for Red Deer Lacombe.
$20,000. Well, Mr. Speaker, cabinet ministers can do what they want with their personal vanity projects, but Canadians shouldn't have to pay for them. First-class tickets from Manila, 2 days in Los Angeles with her staff in tow. Why are Canadian taxpayers footing the bill for a first-class trip to Hollywood just so the minister can be on an American talk show?
Honourable Parliamentary Secretary.
Mr. Speaker, it bears repeating that all of the minister's travel is done according to guidelines that are set, and she follows all the rules, Mr. Speaker. We will continue to be transparent in this regard.
For Elgin, Middlesex, London.
Well, Speaker, not quite the case. It's actually worse than that. The minister traveled first class, scarfing down gourmet food, then turned around and claimed per diems for the same meals. We all know this is against the rules. Mr. Speaker, she cannot charge taxpayers this vanity trip. She double billed them for meals. Is her integrity worth more than the $104.20 that she has taken from the taxpayers? Will she be returning the money to the taxpayers?
Parliamentary Secretary.
Mr. Speaker, all of the minister's travels are done according to the guidelines, according to the ethical guidelines and the guidelines to which we have to comply as members of the government. We'll continue to do so, Mr. Speaker, in the future.
The honourable member for Lévis-Lobinière. Mr. Speaker, the questionable ethical issues of this Liberal government are piling up almost as fast as its deficit. Now we learned that the Minister of International Trade spent close to $20,000 to appear on a Hollywood talk show. Mr. Speaker, this is unacceptable. Since she was not in Los Angeles to negotiate a free trade agreement with Hollywood stars, can she explain why Canadians should foot the bill for her costly trip to California? The Honourable Parliamentary Secretary. Mr. Speaker, the minister's expenses are published, public, and transparent. We are following the rules, and we will continue to do so.
Sue.
Last week, Canadians were alarmed to discover that the Liberals' defence review included consideration of privatising search and rescue. Now we've learned the Liberals are also reconsidering Canada's participation in the Star Wars missile defence scheme. Mr. Speaker, I have a bad feeling about this. Canadians thought this debate was put to rest more than a decade ago. So will the minister tell the House, and this really is a yes or no question, are the Liberals reconsidering Canada's participation in this dangerous U.S. missile defence scheme?
The Honourable Minister of National Defence.
Mr. Speaker, Canada currently does not participate in the ballistic missile defence. No decision has been made to change this policy. Through the Defence Policy Review, the government is consulting Canadians on a wide range of defence-related issues in an open and transparent manner, and including ballistic missile defence. Thank you, Mr. Speaker.
Honourable Member for Rosemont-la-Petite-Patrie. The Liberals are full of surprises. One day they want to privatize research and rescue missions, and then they want to reconsider participation in the missile defense system. Yes, you heard it right. They want to restart the Star Wars system debate, which was rejected by the public 10 years ago. Can't he just watch the movie? Why, instead of getting us into this useless thing that would cost us billions?
Because the government wants to ensure that Canadians, Canada, and North America is well defended from all threats. And we want to make sure that the defense review is open and wide. And by not opening up the discussion to ballistic missile defense, allowing Canadians to have a say in this, it wouldn't be an open defense review. Thank you, Mr. Speaker.
The Honourable Member for Brossard-Saint-Lambert. Mr. Speaker, we were very sad to witness from afar the tragic events that took place in Ecuador with the earthquake. Can the government tell us about the latest developments as well as the services to Canadians who are in the region? Honourable Parliamentary Secretary. Our thoughts and our sincere condolences go to all of those affected.
Citizens who were tragically killed during this earthquake. And as a nation, we send our deepest condolences to their families, their friends, and their loved ones. Consular officials in Ottawa have reached out to the family and are offering support and assistance. Canadian officials in our embassy in Quito are reaching out to Canadian citizens in that country to provide assistance. We will continue to work with local authorities to assess the impact of this devastating earthquake and with what is needed on the ground. Thank you.
Member for Caribou, Prince George.
Mr. Speaker, the MP from Steveston, East Richmond, wants to shut down the Port of Vancouver and have it subject to an environmental assessment. The same environmental assessment process that has tied up the Pacific LNG project in more and more red tape and has put the creation of thousands of well-paying jobs on hold. How many more jobs are the Liberals willing to kill before they start approving the projects Canadians depend on for their livelihood?
The Honourable Parliamentary Secretary for Environment.
Thank you, Mr. Speaker. I'm not sure if the honourable member knows, but the ports already have an environmental assessment process through which they deal with projects that are ongoing. Projects that reach a certain threshold are reviewed by the Canadian Environmental Assessment Agency. As we move forward and we initiate the review of the broader environmental assessment processes in Canada, we will be looking at how environmental assessments are done generally, and these will be part of the discussion. Thank you very much, Mr. Speaker.
Prince George.
Well, Mr. Speaker, more and more verbal gymnastics from the other side. Mr. Speaker, the president of the Vancouver Port Authority said this: "We regularly engage with the community, but it's kind of hard to know what social license is." He's referring to the same social license that is causing a delay in the Pacific LNG projects, which would be the largest private sector investment in British Columbia history. When will the Liberals stop using environmental buzzwords to kill Canadian jobs and instead become a beacon of light in rough waters and start approving job-creating projects?
Honourable Parliamentary Secretary.
Mr. Speaker, in the modern age, Canadians expect that the environment and the economy work together hand in hand. They expect rigorous environmental assessments of projects so that people can have comfort that when projects proceed, they're done in an environmentally sustainable manner. With respect to Pacific Northwest, the proponent provided additional information, which we are now reviewing. There will be a decision within the next few months, and it will be based on science and on data, not on politics.
For Prince George, Peace River, Northern Rockies.
Thank you, Mr. Speaker. Today and tomorrow, mayors from my riding and myself are meeting with federal Liberals to discuss the benefits of the LNG industry and agree with the minister that we want to grow our economy. Many residents and small businesses have been hit hard by low energy prices, but it doesn't have to end this way. BC projects will create thousands of jobs, billions of dollars in tax revenue, while also reducing global emissions. When will the Liberal cabinet hear the voices of strong support for BC LNG and approve projects like Pacific Northwest LNG?
The Honourable Parliamentary Secretary.
Mr. Speaker, I'm not sure if the honourable member was not present, but the wood fibre project actually was approved. It went through a rigorous environmental assessment process where we determined that the environmental impacts could be managed in a sustainable way, and that project is going forward. The same process will be used with Pacific Northwest and all other LNG projects to ensure that environmental impacts will be managed if, in fact, the projects are to proceed.
Member for Prince George, Peace River, Northern Rockies.
Thank you, Mr. Speaker. One more time. Mr. Speaker, while we wait for the Liberal cabinet to make a final decision on Pacific Northwest LNG, Progress Energy is cutting investment as we speak. This is yet another blow to families of northeastern BC, real families, Mr. Speaker, where the unemployment rate is the highest in the province. There is now growing concern about further delays. What would that mean to our communities? When will the Liberal cabinet step up, support our families, and approve BC LNG and grow our economy?
The Honourable Parliamentary Secretary.
Mr. Speaker, we very clearly understand that major resource projects are an important part of the economy, but they must be done in a manner that balances the environment and the economy. One of the reasons why this group is sitting on this side of the House and that group is sitting there is Canadians lost faith in the ability of the previous government to manage the environment.
Member for Windsor West.
Canadians are gathering outside today's Trade Committee meetings in Vancouver, calling for the government to reject the TPP. And they are not alone. Industry leaders from manufacturing and high tech have warned that this deal would be bad for Canadian businesses. And Nobel laureate Joseph Stiglitz called it the worst trade deal ever. The TPP would cost us 60,000 jobs and increase growing inequality. The Liberals are barreling ahead with this job-killing trade deal. Why is the minister finishing the bad work of the Conservatives?
The Honourable Parliamentary Secretary for International Trade.
Mr. Speaker, the TPP was negotiated in secret by the previous government. The member's party rejected it without even having read it. We said we would consult. We are looking at every corner of the agreement, Mr. Speaker. There are those, as the honourable member has cited, who are against it, but there are many others who are for it and cite various positives for the Canadian economy. We plan to study it, put it before Parliament, and therefore put it before the Canadian people.
The Honourable Member for Berthier-Mascaranger. Mr. Speaker, the Liberals made a commitment to defend supply management and dairy producers, but 6 months later, the record is poor. The problem of diafiltered milk isn't solved. There's not a penny in the budget for compensation for the trade agreement with the European Union, and the government wants to go ahead with the TPP. So when will the government keep its promise and stand up for producers? The Honourable Minister of Agriculture.
Mr. Speaker, I appreciate my honourable colleague's question and her concern. We, of course, support supply management, and as we indicate, we understand the importance of compensation in the supply management sector. And it has been indicated by my colleague what will take place. It will be fully consulted with the stakeholders across the country, and there will be an open debate in this House, and then we will vote to see whether it will be approved or not. Thank you, Mr. Speaker.
Member for Markham Unionville.
Thank you, Mr. Speaker. The Liberals' fully costed campaign platform pegged the cost of their Syrian refugee program at $250 million. We know now it will be several times that. Lack of advanced planning on behalf of the Liberals has resulted in millions of dollars being wasted on unused hotel rooms, staff overtime, and transportation. Do the Liberals have any idea how much the Syrian refugee program will actually cost? Thank you.
The Honourable Minister of Immigration.
Mr. Speaker, not only can I say that we are under budget, I can also say that I am extremely proud of our refugee program, which has brought 26,000 people to Canada. And yes, there were some hotel bills, but I can tell the member that 87% of those refugees are now in permanent housing, and their hotels were a temporary cost only. So he should celebrate the success of our refugee effort.
Member for Calgary Nose Hill.
Speaker, it's easy to be under budget when you don't have one. So, Mr. Speaker, if the minister can't tell the House what the final cost of the initiative will be, can he explain to the House why, after spending all this money, we still see Syrian refugees in hotel rooms, they don't have access to language training services, and they're having to access food banks on a day-to-day basis. So if refugees aren't receiving the support they need, where's all this money going?
Minister of Immigration.
Speaker, it sounds like the honourable member didn't hear my answer to the previous question. Perhaps she should revise her questions in light of what has been said. But the point is that they are largely out of hotels. 87% are in permanent housing. And the other thing I said is that we are under budget. We have delivered this program on time, under budget, and it is good news.
The member for Calgary Nose Hill.
Interesting to see what largely is defined as, now that they've increased humanitarian assistance to refugees by over 250%. Mr. Speaker, if the Liberals have had any plan to deal with this, Mr. Speaker, they would see that they should be ensuring that government-sponsored refugees aren't sitting in hotel rooms. So, Mr. Speaker, why aren't the Liberals matching Syrian refugees that are sitting in hotel rooms with privately sponsored refugee groups?
The Minister of Immigration.
Mr. Speaker, refugees always spend some time in hotels. And for the third time, I would inform the member that 87% of those refugees are now in permanent housing. And also, I am probably the only immigration minister in the world whose major problem is an inability to get refugees to Canada fast enough to satisfy the overwhelming generosity of Canadians. But I can tell you, I'm working on it.
The honourable member for Calgary Skyview.
Thank you, Mr. Speaker. Mr. Speaker, Budget 2016 announced $2 billion for post-secondary institution strategic investment fund to improve research and innovation infrastructure at Canada's post-secondary institutions. I know that post-secondary institutions in Alberta see this investment as not only a net positive for science, but also for the Canadian economy. Can the Minister of Science tell Canadians why our government is making such a big investment? Thank you.
The Honourable Minister of Science.
Mr. Speaker, post-secondary institutions are frontline agents in fostering science and research excellence. That's why we announced last Friday nearly $20 million to 33 Canadian universities. The new CIF fund will improve research and innovation infrastructure at Canada's post-secondary institutions. As the University of Calgary President Elizabeth Cannon said, these investments will support students and scientists with modern labs, green technologies, and enhanced capacity for commercialization. We're proud to tell this House that the application process is underway.
Member for Kamloops, Thompson, Caribou.
Mr. Speaker, in response to the Daniels decision, National Chief Dory stated that the 600,000 Métis and non-status Aboriginals should have access to the same resources available for decades to those with status. He also noted that the government always has a pool of money set aside for unexpected events. Mr. Speaker, any prudent government would have analyzed the full implications of this decision. Again, I'd like to ask the Minister to share with Canadians what the projected costs will be.
The Honourable Parliamentary Secretary for Indigenous and Northern Affairs.
Thank you, Mr. Speaker, and I thank the Minister for her question. First of all, we welcome the ruling by the Supreme Court of Canada, and we respect the ruling. We have every intention, Mr. Speaker, to continuing our partnership with Métis and non-status people in this country to advance them and move them forward. In fact, Mr. Speaker, the President of the Métis National Council have already said, and I quote, the Trudeau government has already recognized the Métis Nation and is prepared to deal.
Order, unless she was referring to a previous government, I'd remind her that we don't refer to members by their proper names, but by their titles. Might have said the Prime Minister's government, perhaps.
The Honourable Member for Jonquière. Mr. Speaker, yesterday a coalition of associations representing Quebec workers launched a campaign for genuine reform of the EI system. The fund has been looted for years by Liberals and Conservatives, and too many workers continue to be excluded. The budget had no commitment to help seasonal workers, and the government continues to dip into the fund nearly $7 billion over the next 3 years. Why won't the Liberals fix their past mistakes and actually help workers?
The Minister of Employment.
Thank you, Mr. Speaker. I'm very pleased to say that we've provided $2.5 billion to Canadians from coast to coast to coast, including reducing the deductible, improving service, reversing the negative 2012 changes, eliminating the punitive measures that targeted women, youth, and immigrants, doubled the work-share program, and, Mr. Speaker, reduced premiums for small business.
Member for Brampton East.
Mr. Speaker, since the great people of Brampton East sent me to this House, my office has received over 500 immigration cases, clearly showing that the system was broken under the previous government. Can the Honourable Minister of Immigration please update this House on how we're going to make the immigration process more accountable and more transparent for all Canadians?
Government immigration.
Mr. Speaker, I thank my colleague for his good question, and in the near future, we will be making it easier for international students to become permanent residents We will also be reducing significantly the processing time for families. And already, Mr. Speaker, we've brought in more than 26,000 Syrian refugees. We've re-established refugee health care. And, Mr. Speaker, we have re-established the principle that there is one, not two classes of Canadian citizens.
Member for Sherwood Park, Fort Saskatchewan.
Mr. Speaker, here's what Katrina Lantos Sweat with the U.S. Commission on International Religious Freedom had to say about the Liberal decision to kill the Office of Religious Freedom. The world is on fire as it relates to religious freedom, so the timing couldn't be much worse. Now, the Liberals said they would replace the office with something else, but the office is now gone, and we still have no planned replacement. Could we actually get a timeline? When are the Liberals actually going to do something about international human rights?
The Honourable Parliamentary Secretary for Foreign Affairs.
Thank you, Mr. Speaker. The promotion and protection of human rights, including the freedom of religion, belief and conscience, is an integral part of Canada's constructive engagement in the world. I know you know the words. The Minister just announced in Burma Canada's $44 million investment in a bilateral development assistance program, which will strengthen and promote democracy and its fundamental freedoms, including those of religious minorities, for instance, like the Rohingyas. We are continuing our important work as we move toward a comprehensive vision of human rights. Dr. Bennett and staff remain with us during this transition. Thank you.
When the Parliamentary Secretary says, I know you know the words, I guess she's talking about me. But otherwise, I know she wouldn't use the word you. So I'd encourage her not to use the word you unless she means me. And I The
Honourable Member for Rivière-du-Nord. Thank you, Mr. Speaker. Mr. Speaker, we learned this morning that KPMG accountants and executives from the Canada Revenue Agency were drinking together to taxpayers' help. KPMG and the CRA are thick as thieves. The accounting firm even recruited a senior advisor from the CRA. They have even agreed on an amnesty for those who are benefiting from the tax shelters. Does the minister find this acceptable? Mr. Speaker, I'm very pleased to be able to tell my colleague that the event that was organized by the Professional Institute of Canada was a professional event, and most people who worked in the audit area were from the firm. The Honourable Member. We know that there is an investigation. This is complex. For weeks now, the minister has been reading us the same lines. We know there's a new approach and people are being audited and that there are cases before the court. Okay, but the government is investing. The problem is that in most cases, this avoidance is actually institutionalized and legal. In Barbados, for example, will the minister finally end the cocktail season and cronyism in her department? The Honourable Minister of National Revenue. Mr. Speaker, I keep hearing the same question. He needs to understand the answers. We have a budget of $440 million. This is unprecedented. We are going to be investigating tax evasion and tax avoidance. This is what we will be doing during the year. The Honourable Member for Montcalm. Mr. Speaker, when questioned about Bill C-14 on Friday, the Parliamentary Secretary for the Justice Minister said that the bill would have enabled Kay Carter to be eligible, even though there is this gray area about reasonably foreseeable natural death. Can the minister tell us if she agrees with her colleague, and if so, how could someone with spinal stenosis actually meet the criterion of reasonably foreseeable natural death?
The Honourable Minister of Justice.
Thank you, Mr. Speaker, and thank the honourable member for the question. We look forward to having a vigorous debate on Bill C-14. And as the Attorney General, I read the Carter decision very carefully. I am confident that we are responding in a substantive way to the Carter decision, as well as ensuring that it is in compliance with the Charter of Rights and Freedoms. We have put forward what we believe is the best solution now that balances personal autonomy and ensures that we protect the vulnerable. I look forward to the debate.
This brings question period to an end in record time.
The Honourable Minister of Finance.
Mr. Speaker, pursuant to Standing Order 83-1, I wish to table a notice of Ways and Means motion to implement certain provisions of the budget tabled in Parliament on March 22, 2016, and other measures. Pursuant to Standing Order 83-2, I ask that an order of the day be designated for consideration of the motion. Monsieur le Président, conformément...
Mr. Speaker, pursuant to Standing Order 83-1, I have the honour of tabling a Ways and Means motion dealing with certain provisions of the budget tabled in Parliament on March 22, 2016, and implementing other measures. Pursuant to Standing Order 83-2, I ask that the study of the motion be added to the orders of the day. The honourable member for Laurentides-Labelle.
Seek it, I believe you'll find unanimous consent for the following motion. That, notwithstanding any standing order or usual practice of the House, at the expiry of the time provided for oral questions on April 19, 2016, the House shall consider Ways and Means Motion Number 6 immediately following the taking of the Deferred Recorded Division on Ways and Means Motion Number 2. Thank you, Mr. Speaker.
Does the honourable member have the unanimous consent of the House to propose the motion? The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Carried. Tabling of documents. That the honourable member for Regina-Capel wishes to add some comments in relation to the question of privilege he raised last week. The honourable member for Regina-Capel.
Thank you, Mr. Speaker. I'll be very brief on this. I just wanted to raise a follow-up point to my question of privilege that I raised last week on the premature disclosure of Bill C-14, an act to amend the criminal code and to make related amendments to other acts. When I did so, the Chief Government Whip rose in his place and offered his sincere apologies on behalf of the government, and of course I do want to thank him for that. However, I don't believe that it is sufficient to leave it at that. I trust, Mr. Speaker, that you will allow the House to decide this matter, and hopefully the House in its infinite wisdom will send the matter to the Standing Committee on Procedure and House Affairs for further study. In my question of privilege, I referred to the case in 2001 where the government House leader at the time, the Honourable Don Boudria, also apologized for the premature disclosure of the contents of a government bill. The Speaker in that case allowed a motion to be proposed referring that question of privilege to committee. Members from all sides of the House then, and it would appear that members from all sides of the House today, believe that this is a grave matter deserving of further consideration. We do not know what the circumstances are. The Chief Government Whip himself admitted he does not know what the circumstances are. He stated on Thursday, "I am not aware of the details surrounding the media report referred to by the member, but I want to assure the House that our government takes any breach of the privilege of members and of the House very seriously. I can tell the House that at no point was anyone authorized to publicly discuss the specific details of the bill prior to introduction," end quote. Now, if no one was authorized to discuss the bill publicly, then we need to find out how this happened. The Chief Government Whip went on to say that the government will work to ensure that this does not happen again, which I think members will appreciate. However, this is not a matter solely for the government. This is a matter involving the privileges of this House. This matter should be reviewed by a parliamentary committee. If the government gets to the bottom of this internally or has new policies to offer relating to the confidentiality of bills, then I expect them to explain all that to a standing committee of this House. In short, Mr. Speaker, an apology, while appreciated, I think it is indicative of the seriousness in which the government views this matter. Of course, the opposition does as well. The apology does not take away the breach, the contempt that exists, and specifically, since we don't know who did it, I don't suppose the government whip was taking on any of the blame himself. It clearly seems to be someone else. That apology cannot be made on behalf of an unknown person. We need to find out, see if it's possible to find out who did it, what the circumstances were, and have the committee report back to the House. So when you are finished deliberating and have heard all the arguments, I will, if you find in our favor, I will be prepared to move the appropriate motion to send this to committee.
I thank the honourable member for Regina Capel for his further intervention on this question of privilege, and I look forward to getting back to the House shortly, very soon, with my ruling on this matter. Tabling of documents. The Honourable Parliamentary Secretary to the Prime Minister.
Mr. Speaker, pursuant to Standing Order 36-8, I have the honour to table in both official languages the government's response to one petition.
Dépôt de projet de loi éminent du...
Introduction of government bills. Statements by ministers.
Three delegations. The Honourable Member for Louis Hébert.
Mr. Speaker, pursuant to 34.1, I have the honour of presenting three reports in both official languages from the Assemblée parlementaire de la Francophonie. The first concerns the 31st Regional Assembly of the American Region in Lafayette and Lake St. Charles in the United States of America, July 27th to 31st. The second concerns the Bureau meeting of the APF in Siem Reap, Cambodia. And the third, the meeting of the Executive Committee and the meeting of the Network of Women Parliamentarians of the APF in Tangiers, Morocco, from February 24th to 26th, 2016.
Member for Breaches East York.
Speaker, pursuant to Standing Order 34 sub 1, I have the honour to present to the House, in both official languages, two reports of the Canadian Group of the Interparliamentary Union respecting its participation at the annual parliamentary hearing at the United Nations held in New York, February 8th and 9th of this year, and the steering committee of the 12 Plus Group held in Brussels, Belgium on February 22nd of this year. Thank you, Mr. Speaker.
Reports from interparliamentary delegations. Presenting reports from committees. Honourable Member for Bay of Quinte.
Mr. Speaker, I have the honour to present both initial languages the second report of the Standing Committee on Veterans Affairs entitled Main Estimates. 2016-17, votes 1 and 5 under Veterans Affairs and votes 1 under Veterans Review and Appeal Board. Thank you.
Presenting reports from committees, the Honourable Member for Etobicoke Lakeshore.
Mr. Speaker, I have the honour to present in both official languages the first report of the Standing Committee on Natural Resources entitled Main Estimates 2016-17. Thank you.
Presenting reports from committees, the Honourable Member for Yukon.
Conformément au mandat que Louis
Pursuant to the powers under Standing Order 104, I have the honor of tabling in both official languages the report of the Standing Committee on Procedure and House Affairs. If the House gives its consent, I intend to move the adoption of this report later today.
Dépôt de projet de loi émanant des députés.
Introduction of private members' bills. First reading of Senate public bills.
Motion. The honourable member for Yukon.
Monsieur le Président,
Mr. Speaker, if the House gives its unanimous consent, I move that the seventh report of the Standing Committee on Procedure and House Affairs, tabled in the House today, be adopted. Does the honourable member have the unanimous consent of the House to move this motion? All right. The House has heard the terms of the motion. Would it please the House to adopt the motion? Adopted.
This is a motion. Okay. Monsieur Caron.
Mr. Caron, seconded by Mr. Julian, moves that it be an instruction to the Standing Committee on Finance that during its consideration of Bill C-2, an act to amend the Income Tax Act, the committee be granted the power to divide the bill in order that all the provisions related to the contribution limit increase of the tax-free savings account be in a separate piece of legislation. Debate. The honourable member for Rimouski-Nejet-Témiscouata-les-Basques. Thank you, Mr. Speaker. As you know, we are currently at the Finance Committee studying Bill C-2. This is the first bill that was tabled by the government intended to amend the Income Tax Act. When we look at the substance of the bill more carefully, there are two distinct issues. That one deals with the income tax rate that was proposed by the government to bring down the highest rate 22% to 11%. And the second deals with the contribution limit increase for a tax-free savings account, which under the Conservatives had moved to $10,000 a year, and this bill is intended to bring it back down to $5,500. And the reason why I am asking for the House to give this instruction to the Finance Committee to split the bill and separate these two issues is because they are fundamentally different.
Tax-free saving accounts. Many people think or are under the impression, and it was the way it was presented to the Canadian population, that this is basically a savings account for retirement, that people are saving money, they are putting money aside in that account after paying taxes, obviously, on it, and then it can actually grow with interests, with returns, and eventually they'll be able to get that money out tax-free because they already paid tax on it. When we're looking deeper into TFSAs, it's a bit more complicated than this, Mr. Speaker. It's more complicated because it's not only money that you can put in this account. You can actually put all kinds of things in these accounts. You can put stocks, you can put bonds, you can put derivatives, you can put all kinds of financial tools. So the concern with the raising of the ceiling to $10,000 was the fact that it became something else than a retirement saving mechanism. It became basically a way to shelter returns on financial investments. You know, if I'm going to invest on the stock market and I make a significant return on my investment, I won't even pay the same income taxes as most of the population. With this money, I will be taxed only for half of what I would be earning, and I will only be paying taxes on a portion of that half, while people earning an income through work will actually be will be taxed on the entirety of their gains. So we are in a situation right now where capital gains have a different taxing status than income tax gains, basically. So when you raise the ceiling, it actually brought the possibility that it would be no longer used as a savings mechanism, but it would be used as a slush fund, basically, in which you're putting money and basically playing the market with it through a variety of financial tools, and eventually escape altogether the capital gains tax. And this possibility, Mr. Speaker, I would submit, is not available to the large majority of Canadians. It's really those who have the means to actually put money and play the stock market, play the derivative market, is actually a very limited number of people. Et c'est en fait, Monsieur le Président.
And Mr. Speaker, that's really a great concern for many analysts when they look at the TSFAs and the implications of raising that contribution limit. The parliamentary budget officer estimated that raising that would have permanent implications that would be quite significant. And in fact, if I take the update of his report, which analyzes the impact of raising that contribution limit, he estimated, among other things, that by 2080, the tax impact of the TSFAs would reach the equivalent of 0.65% of the GDP. So it would be impossible for Canada to meet its international commitments in terms of international development, which are 0.7%, because we can't seem to find the funds to do so. And yet this measure, raising the contribution limit, would practically achieve that objective. But the benefits of that would be redistributed to a small percentage of the population, and that also was taken note of by the parliamentary budget officer. He mentioned that the distribution of the benefits of TSFAs are really as a result of wealth. So if we look at the different brackets of people, of the 20 wealthiest would have a far greater financial advantage to 80% of the families that indeed are not part of the wealthiest group.
So the proposals that the Conservatives had put forward was extremely harmful for the country's fiscal situation. It opened the door, in fact, to the use of this vehicle, not only for the use of savings, but also to protect the capital gains tax, which is already much lower than than the way citizens are taxed on their income through work, for example. And therefore, instead of being a savings vehicle, and this is our concern, it became practically a tool of tax avoidance, and that was for purposes other than those for that which it was introduced and voted in this House. So this government wants to overturn this measure, and instead of having the contribution limit of $10,000 during 2015-16, they want to lower it to, excuse me, Mr. Speaker, they want to lower it to $7,500. Now, we agree with that measure. In fact, we had presented it ourselves during the election campaign, and we deemed that $7,500 was a sufficient level to achieve the purposes of savings for retirement. For example, if people can put aside $5,500 plus interest, which is not taxable, and that would be on top of other tools, other vehicles that exist as well, that are used, for example, RRSPs, for example, obviously old age security, which people will be able to access at age 65, and obviously the CPP or the QPP. So the TFSA is an additional mechanism, one tool among so many others that can be used, and we deemed that the ceiling of $5,500 was sufficient.
Which is extremely different than the ceilings of the TFSA, and that's the modification of the tax brackets. The bill proposed to change the second bracket. For those who or might be listening at home, right now we have 4 brackets of taxation in Canada. We have a first one that applies from income from $11,000 to about $45,000, which is at 15% right now. Then from about 45%, any income between $45,000 and about $90,000 is taxed currently at 22%. Then you have taxation from $90,000 to about $135,000, which is taxed at 26%, and then over that amount is taxed at 29%. The bill makes two changes. It decreases the second bracket, so all the revenues, all the income from 45 to 90,000, from 22% to 20.5%, and adds another bracket for those earning over 200,000 that will be imposed at 33%. Now, during that debate and during the campaign, I was actually a bit surprised of the low level of understanding on how our tax system works. That reduction of amounts between 45 and 90,000 will not only affect those earning a total of between 45 and 90,000. It will actually be applied on all incomes over 45,000. Somebody earning right now 150,000, the ordinary member of parliament, for example, which is above 135,000, will actually have a 1.5 reduction of his or her own taxes of all the income between 45 and 90,000. So about 45,000 of that income will be taxed 1.5% less. Many people are under the impression that people earning over $90,000 will not be affected. On the contrary, they get the full tax reduction at that level. Now, we are going through the analysis. Much analysis has been done, including by the parliamentary budget officer. And what we're seeing is that while Liberals during the campaign promised to have a middle-class tax cut, it's clear that those earning less than $45,000 will not have a single cent of that tax reduction. It's clear. It only affects people earning over $45,000. I would submit, and it's been told to me in no uncertain terms, that if you are earning $35,000 to $40,000 to $45,000, you might legitimately claim to be a member of the middle class, which is, as you know, a very difficult term to define. One way to define it is to look at all the income divisions in Canada to exclude the 20% who earn the most, 20% who earn the less, or who earn the least, and that will give you a middle class that's anywhere between $20,000 and about $50,000. Let's go up to $60,000. That would be roughly what the middle class is in terms of income for a year. Now you have a large chunk of that group who will not touch a cent from that tax reduction. So to call this a middle class tax cut is, in my mind, Mr. Speaker, misleading. Now we have the second part of it, which was supposed to pay for the lost revenues, which is the new bracket for income over $200,000 at 33%. Now, we know, and I think even the government was forced to admit it, that it won't pay for the tax reductions. We all agree on this. Now, not only will it not pay for the tax reduction, but even people making an income over $200,000 will still have a tax reduction, overall tax reduction, even though they are supposed to be imposed more, because they still get the full tax reduction of that second bracket. That means that somebody earning $210,000 will still have an overall tax reduction. Somebody earning $215,000 will still have an overall tax reduction. Is that what we mean by middle class tax reduction, tax cut? So, you see, Mr. Speaker, we have a problem on this side of the House. We agree with one large measure, which will, if it's not addressed right now, have significant fiscal incidence, fiscal impacts on the Canadian government. On the other side, we disagree with a measure that we find is misleading, that is not achieving the aims on which it was presented to the Canadian population, especially during the election.
And beyond that, Mr. Speaker, we wanted to be constructive because Canadians elected this government partly because of this promise to reduce taxes for the middle class. We respected that, and we made a proposal to the government. Instead of excluding a large section of the middle class, instead of simply reducing the second tax bracket, let's reduce the first income tax bracket on which people are taxed. So as of about $11,000, because people have basic exemptions that are not taxed. So let's talk about starting at $11,000 or $12,000. So we should reduce their tax rate from 15 to 14%. What would that do, Mr. Speaker? Well, it would allow people who are truly part of the middle class to be able to benefit from this tax cut. It would allow people who currently have a 1.5 reduction to have a 1% reduction on a similar income, which ensures that people who earn $210,000 will not receive a tax cut. So I'm convinced that all Canadians would agree with this type of measure, and inexplicably, the government is opposed to this measure. Well, I can't do anything about that, but I don't think the government can oppose the idea that both of these measures are very separate. I think that they should be studied on their own merits, and we have done part of this work at the Finance Committee. And I think it is in the government's own interest to accept our proposal, because we're giving them this opportunity on a silver platter. And they have really thrived on this measure in the media. We're offering them the opportunity to have two separate debates on measures that they have presented and that they are proud of. So it would be really a good idea that this House should be able to vote on the legitimacy of splitting this bill. Now, obviously, I know this was technical, but when we're talking about income tax, it is technical. So these two measures have categorically opposed effects.
To the notion of transparency and the notion of accountability as well, that this House could actually pronounce itself separately on those measures. We'll have that chance in the Finance Committee. You know, the bill, C2, is only 10 articles long. And we'll do a clause by clause. It's only 10 clauses long. We'll have a clause by clause vote in the Finance Committee. We'll have an opportunity to actually demonstrate in the Finance Committee which clauses we're in favor of, which we're not. I think in this instance, especially since it's the first bill that was presented by this government, and it's one of the key measures that they wanted to bring forth to the Canadian population, that this House have the opportunity to actually do the same and to vote separately on those arguments. I think it would actually be beneficial for the trust that the population puts into this government. It goes to the issue of credibility as well. And you know, it will go to actually answer and contribute to answer to that question that many have asked so far, because, you know, since we voted on the Ways and Means motion, on which we could not divide per se, people are under the impression that starting on January 1st, they had the tax reduction if they are part, or if they consider themselves as part of the middle class. And starting on January 1st, when they started seeing their tax, not their tax, but their pay slip, or their pay paper, pay slip, thank you. They might have been surprised not to see any impact, any changes. And they still don't understand. I haven't really heard the government so far in this debate talk about the technical aspects of it publicly. They always talk about, and I hear the answers that either the minister gives or the parliamentary secretary give on this, saying that they have given the middle class a tax cut. Point.
That's it. Period. Nothing else. And I think that the question deserves to be clarified. We are in this House. So there are 338 of us who represent all Canadians. And I think that the government would be well served by clarifying this matter, not only by debating in each of these matters, but debating each of these matters separately. So we're calling for C2 to be split. The other elements have to do with these two matters, including the amendments of the tax credit formula for charitable donations that generally follows the upper taxation brackets, and since that would be changed, well, the matter of charitable donations would would have to be amended as well. So we just want to split Bill C2 in two, so we can study the TFSA on one hand and the income tax brackets on the other hand. So that's the offer that we're making to the government, and I certainly hope that this House will accept our proposal so we can do better work on the Finance Committee so that we can be accountable to all Canadians. Thank you.
Questions and comments. Questions et commentaires.
The Honourable Member for Laurentides-Labelle.
Member for Rimouski-Neigette-Témiscouata-Les Basques wants to debate concurrence on something that he has already agreed to send to committee in a vote in favour of C2 on the second reading on March 21st, 2016. Mr. Speaker, why does he not want to change? Why does he now want to change a bill he has already and recently voted for? The member already has the right to vote for or against each clause in the bill. There's a whole section of committee appropriately named clause by clause for this very task. So again, the bill has already been referred to committee by that member himself. I don't see why he is now writing new conditions for his support. Why won't the member let the committee do its work and hold its own debate rather than pushing for unnecessary delays? Thank you, Mr. Speaker.
The Honourable Member for Rimouski-Neigette-Témiscouata-Les Basques. I'd like to thank my colleague for the question. Just to clarify, this is not a concurrence motion. This is a motion of instruction. This House must be able to give instructions to committees for drafting the reports that they're going to be will be presented here in Parliament. And I've heard that I'm not on the Finance Committee. And well, I mean, yes, the committee will be studying this bill, but it is composed of 5 Liberals, 1 NDP, and NDP member, and 4 Conservatives. But there are 338 members in this House. This is a basic issue. We're talking about a substantial income tax amendment, several $1 million over 6 years. And the PVO says it will cost $9 billion on an entirely different matter. We're talking about the cap on TFSA limits. So by 2080, this measure could cost up to $132 billion to the Canadian Treasury. So these are 2 measures that are fundamental. They will have a significant impact, and that is why this House, if the members actually want to do their work, should note the report that will be issued by the committee, and it should also give instruction to the committee to split the bill in 2.
Questions and comments. The Honourable Member for Sarnia-Lambton.
Merci, Monsieur le Président.
Thank you, Mr. Speaker, and I'd like to thank my colleague for his speech.
With what my colleague has said, that we don't see a lot of openness and transparency from this government. They say it's a middle-class tax cut, but as the member has pointed out, it doesn't apply to some of the middle class, and then the rest of the wealthy are getting an advantage. And so I don't think that is open and transparent and clear to Canadians. I also think that the math was bad because they were supposed to be revenue neutral. So when they added up the number of people that were going to get the tax cut, they should be able to figure out the amount of money to make it neutral, but they're $1.7 billion short every year. With respect to the tax-free savings account, I was interested to hear the member say he agreed it's a good savings vehicle, because I think that is true. And I see a lot of seniors in my riding that are having to take out their RRSPs and are putting them in the TFSA to keep their savings protected. And so I wonder if we would remove the ability to put stocks and the things that you're concerned about into TFSA, would the member be willing to increase the cap on it?
The Honourable Member for Rimouski-Neigette-Témiscouata-Les Basques. Thank you, Mr. Speaker. Honestly, I think that this question could be studied. Obviously, I can't respond right here and now concerning what the tax impacts would be in future, but I would be very happy to study that question.
Actually, I'd like to get back to who wins and who doesn't win from this measure. Even those who are making over $45,000, at which point the tax reduction starts to apply. And those numbers came from David McDonald, and they were confirmed by other economists. That's from the Canadian Centre for Policy Alternatives. And he said that those families earning between $48,000 and $62,000 would earn an average of $51. 51. That's the remainder of that middle class as defined by the income brackets, income deciles. Those families earning between $166,000 a year and $210,000 a year will not get an average reduction of $51. They will get an average reduction of $813. So this is why this measure actually deserves to be voted on its own merits.
Questions and comments? The honourable member for Courtenay Alberni.
The member for my colleague for his in-depth work and bringing this forward. I also have gone back to my riding and talked to people in my riding, and there's huge support for keeping tax-free savings accounts and bringing it back to a reasonable amount that future generations can afford. But when I talk to people, and it doesn't matter what income level, they don't think that it's appropriate that a government that ran on a platform of fairness, inclusivity, would go ahead and ignore taxpayers up to $45,000 and believe that it's fair that they don't get a tax break. And I talk to people of all income levels, people that are earning over $90,000 a year, and they think it's wrong. They think that when the Prime Minister goes out across the country and says they want to help, he wants to help, and this government wants to help lift those that aren't in the middle class to join the middle class. Clearly, this doesn't do that in this bill. And we need fairness, and this bill is supported by many Canadians on one part of it, tax-free savings accounts. But when it comes down to tax fairness, I think that the members across the floor need to go into their own ridings and ask people, their own constituents, whether they think this is fair, because they'll quickly find out if they're listening and do what they promised to do, consult their own constituents. Because I'm hearing across this country that it's time for them to relook at this. I want to thank the member for bringing this proposition forward. And I will ask him, how many Canadians will not benefit from this from this bill as it's presented through the tax proposal? Maybe the member could talk about how many Canadians aren't going to benefit from this proposal.
The honourable member for Rimouski-Neigette-Témiscouata Basque.
To my colleague for this actually very important question, because we hear time after time after time, especially the parliamentary secretary and at times the Minister of Finance, just boast about the fact that 9 million Canadians, 9 million, will get a tax cut under this plan. What he is not saying, though, is that 14 million will not get any tax cut under this plan.
That's right.
And most of them are actually under $45,000 a year. And among that 9 million, we have countless individuals who are making over $90,000, who we can argue are maybe part of the upper middle class, and a large chunk before $217,000, at which point you start finally paying more in taxes rather than getting a tax reduction, who are not part of the middle class, who are part of that 9 million. So let's keep that number in mind. We have actually 25, and I said 14 million. Actually, it's more than that. It's 16 million, or 15 to 16 million, because we have 24 million taxpayers in this country. So deduce 24 less 9, it's 15 million. 15 million Canadians don't get a tax cut.
Questions and comments? Questions et commentaires? La députée.
The honourable member for Rosemont-le-Petit-Patrie. Thank you very much, Mr. Speaker. I'd like to thank my colleague for this proposal that is full of common sense, and it's the proof that the NDP is a progressive opposition party, and but we know how to differentiate between the wheat and the chaff. And so we know how to keep the things that are good and to set aside everything that is bad for taxpayers.
But now we have the Liberal government with the situation, an omnibus bill that changes a lot of different legislation, and that's what the Conservatives used to do. But the Liberals won't be able to adopt this. Well, we'd like to see a well-informed debate around this. So I would like to know from him why the Liberal government is refusing to have two distinct debates.
Ms. Catale-Basque.
The honourable member. Thank you, Mr. Speaker, and I would like to thank my colleague for his excellent question. Obviously, I can't really read the minds of our Liberal colleagues, even though I might well like to. But from budgetary different point of view, there is no real reason when it comes to the tax system. These are two different things. They are in one bill, but it's really a matter of policy and public relations. The government is just talking about what it wants to do for the middle class, so it included this measure, even though much of the middle class won't benefit. Now, if I put myself in the shoes of a government that wants to get reelected, then of course I would talk about the middle class without necessarily saying how that is defined. And there are a lot of people in the middle class who won't benefit it at all. So we should look here in the chamber at what the definition of the middle class is. And we have asked, but there is no answer given. If the government wants to continue to combine these two aspects, it is just politically driven and public relations.
The honourable member for Calgary Signal Hill.
Thank you very much, Mr. Speaker. I'm going to rise and make a few comments on this particular motion. I happen to serve on the Finance Committee with the honourable member that has proposed the motion, and one of the things that I've learned in the short period of time I've had to work with the gentleman is that he's a very effective and convincing speaker, and I found out today that he's also very creative, because this is a nice way to get another 30 minutes of debate on the budget that maybe there wasn't time for during the regular debate. And I know myself, I got squeezed out of my time for speaking, so I'll take this opportunity to make a few comments that relate to this particular motion, Mr. Speaker. I will support what the honourable member is proposing, but probably for entirely the opposite reasons that this member has raised in terms of proposing this motion. First of all, Mr. Speaker, I'm all in favor on our committee of having as many different opportunities to examine and study various legislation. And if this particular initiative ends up giving us more opportunity to go in depth into various parts of this legislation, I'm certainly all in favor of it. I would also look forward to the opportunity where I might have the chance to ask some questions of some of our witnesses that I think really the government has failed to answer. And I'll give you a couple of examples. I had the opportunity during my few brief moments on the budget address to talk a little bit about this middle income tax cut that the government is proposing. It's the kind of thing that I always like to refer to as a lot of smoke and mirrors, Mr. Speaker, because the government continues to talk about this so-called middle-class tax cut. And as my honourable member, or my honourable colleague raised the point that clearly this is not a tax cut necessarily for the part of the tax-paying public that probably most necessarily requires the tax cut. And so that's something that I think our committee could certainly take the time to review. In addition to that, Mr. Speaker, when you really run the numbers on this particular tax cut and you divide the average savings that this tax cut is going to provide to the average so-called middle-class Canadian, works out to about $540 annually, and that's the numbers that were provided by the government's own finance department. So if you take that $540 and you divide it by 365 days in a year, that ends up being about $1.25 a day, Mr. Speaker. Now, we all know what $1.25 a day will buy. And as I started to say before I got cut off in my budget address, was that if we took an average couple at $540 a year or $1.25 a day, frankly, at the end of the week, that couple might be able to go to Tim Hortons on a Saturday morning and actually have a couple of cups of coffee. That's really what that so-called middle-class tax cut does. And so, you know, we continue to hear from the government about the what they're doing for the so-called middle class, and really, the substance is not there, Mr. Speaker. So if we could actually take that out and pull it aside, and have the government members on the Finance Committee talk less about their so-called middle class tax cut, I think that would help our deliberations at the Finance Committee immensely. And then, of course, we could spend a little bit more time on talking about the merits of the tax-free savings account. Now, Mr. Speaker, I listened intently to the members' comments in proposing this motion and talking about the tax-free savings account and the criticism of the tax-free savings account that, my goodness, people could actually put things like stocks and actual investments that were going to make some money into this tax-free savings account, like somehow that was illegal or somehow that wasn't correct. Well, that's the whole point of the tax-free savings account, Mr. Speaker, is to manage your money so that when you retire, your tax-free savings account has given you that ability to retire because it has grown. If you don't put things like stocks into your tax-free savings account, what's the purpose of having the tax-free savings account, Mr. Speaker? We all know that if you put cash in there, it's not going to grow. Why would you have a tax-free savings account? The whole purpose of it is so it can grow, Mr. Speaker. So I'd be happy and delighted at the Finance Committee to debate that point with the member, and if we have the opportunity to call some witnesses, I would be more than delighted to have that discussion at our Finance Committee. So in summary, Mr. Speaker, I'm quite happy to support the motion as proposed by my colleague, but making it clear, I support it entirely for different reasons than he said. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Cowichan, Malahat, Langford.
Thank you, Mr. Speaker, and I appreciate hearing my honourable colleagues' comments on this. I appreciate that the Conservatives and the NDP do look at the TFSA from different viewpoints, and that's fine. In the NDP, we have always said that we don't want to get rid of it. We just wanted to bring back the limits to a reasonable level. I'm sure every MP has different reasons for why they got into politics, but I know when I decided to run, it was not to give myself a tax break of $679. Yeah, that's exactly what these tax breaks are going to do. Everyone who is in an income range comparable to members of Parliament gets the maximum benefit. The people I was sent here by, the hardworking residents of Cowichan, Malahat, Langford, the ones who are earning $45,000 or less, and that's a great deal of them, they're getting nothing from this. And I think my honourable colleague would agree, despite our differences on the TFSA, I think we've heard a lot of similar approaches to the way the tax measures are. Will he agree with us that it's better for accountability's sake that we split this bill so that the Liberal government is held accountable, so it has to explain itself on two separate measures? And I'd like to hear his comments on that. Thank you, Mr. Speaker.
Member for Calgary Signal Hill.
Well, Mr. Speaker, I actually have trouble finding reasons to disagree with what the member just said, because I think we're saying much the same thing. There are a whole host of things that we could debate on and throughout the evening and never agree at the end. But in this particular case, I think this is an opportunity that the government would be accountable. I think one of the things that we have to, when we're talking about TFSAs, Mr. Speaker, is, the TFSA is a relatively new way of saving for the future. And, there's been some criticism that, well, this percentage or that percentage has actually had a take-up on the TFSA. And I know that the third party in the House has argued the fact that, in fact, I think the government has argued the fact that that few people have actually maxed out under the new maximum that exists out there that this former government brought into existence. Well, in any particular program, Mr. Speaker, in the first year or two of the existence of that program, you have to give it time to work its way through the system, and I think that we needed to give this one a little bit more time, and I'd be happy to make those comments at the Finance Committee, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Durham.
Thank you very much, Mr. Speaker, and I'd like to thank my colleague for his remarks, and in particular talking about two things. First, the relatively new tool of the tax-free savings account, which encouraged savings, which we've seen decline in Canada in recent years, and helped seniors prepare for and during retirement, Mr. Speaker, and he outlined that new benefit quite well to this House. He also, Mr. Speaker, highlighted the fact how the so-called large tax cut for the middle class is a bit of a myth, Mr. Speaker. When you look at all the things that were cut for families by the previous government, programs for income splitting, universal child care, a range of tax credits for children and families, and compare it with the regime now, most middle-class families with dual-income workers in Calgary or in the Toronto area are actually further behind than they are now with the new child benefit regime of the Liberals. I'd ask the member to highlight that in a little more detail to show that a lot of Canadian families, rather than universality of application, the Liberals have taken a lot of families that need the assistance out of those programs, and it's going to set them back.
Honourable member for Calgary Signal Hill.
Well, there's no question, Mr. Speaker, and again, that I think that my honourable colleague from Durham has put it very well. There are a number of family-oriented tax incentives that the former Conservative government had brought in that actually allowed families to, what I would call, more pick and choose how they wanted to shape their life, how they wanted the tax system to best suit them, whether it's the universal child benefit or whether it's the, as my colleague mentioned, the fitness tax credit or the arts tax credit or the income splitting, Mr. Speaker. I think that as well, we shouldn't underestimate the fact that I had a constituent come to me the other day, and he was quite upset about the initiative by the new government to reduce the amount for the TFSAs, because he said, I have a son who is making in that low-income category that our friends from the third party have referred to, and he said, this tool allows me to put after-tax dollars into a TFSA so that my son, at some point in time, can have a reasonable retirement account because he doesn't have a pension plan, and this is a way that I can help my son, and my son can then manage that money to make it grow for him. So I think a lot of this ability to control your own destiny has been taken away, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Elmwood Transcona.
Thank you very much, Mr. Speaker. Tomorrow it'll have been 6 months since the new government was elected. The most recent bill introduced is Bill C-14. So that's as far as we've gotten. Now, a handful of the bills that are before Parliament are actually quite routine. They have to do with the estimates. Somewhere around 3 of those 14 bills are straight-up repeals of the previous government's laws. 2 of those bills are mandated by the Supreme Court, which is why we're dealing with them. In fact, pretty much the only bill that comes from the government itself of its own volition and that isn't routine is a bill to betray Air Canada workers. That's really the only sort of original legislative initiative we've seen from the government, and I'll have more to say on that shortly. I'm just wondering, given the extreme paucity of the legislative agenda so far, is there really any good reason at all why we wouldn't be given the time to consider these 2 things separately? It's not like there's anything else getting in the way, Mr. Speaker.
The honourable member for Calgary Signal Hill.
Well, it's as the member points out, I have no idea what the government House leader has in the way of an agenda coming forward. We all know that the weather's getting nice, and so I'm not sure how hard or how long he wants us to work here. And so all I can say to the honourable member is that would be a more appropriate question to put to one of the members of the government, if they so chose, to take the few minutes on this time that's left to speak on this particular motion, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member. We have the honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker, and I thank the member in particular for his comments about tax-free savings accounts, something that's very important to many families, many individuals in my constituency. And I just want to underline that it's a fact that seems to be missed by the other parties in this House, that more than half of those who max out their tax-free savings accounts make less than $60,000 a year. And the response has been, well, okay, but we don't need to increase that limit. Well, if people are already maxing out at the $5,000, clearly they have room to put in more, and they wish to put in more, and they will put in more at the higher limit. So we've already got many, many people under $60,000 a year in terms of their income that are using this savings vehicle, that are maxing it out, and are looking for more room to save more. So I wonder if the member could comment on that particular element in terms of how this benefits people on the low income end of things, and just the importance of tax-free savings accounts as a result.
The honourable member for Calgary Signal Hill.
Well, as I mentioned earlier, I think that one of the things that we've done is we've pulled the plug way too quickly on this, Mr. Speaker. Most of new programs literally can take a generation to determine whether or not the public picks up on them and how they can find success using them. So I really think that, as I said earlier, this should have been given a lot more time to see whether it was successful or not. As has been mentioned on many occasions, the TFSA itself is a relatively new program. It's only been in existence for less than 10 years. The take-up is, I think if I recall right, something like 20% of Canadians have been putting money into a TFSA in some form or another. As I said earlier, there's also the opportunity for those who want to take some of their income and put it into a TFSA for one of their children. I know one of my colleagues had mentioned earlier that in fact, that's how he purchased his house, was because he had, with his help of his family, built up a TFSA that allowed him and his wife to purchase their first home. So I think we need to give this a little more time before pulling the plug on it, Mr. Speaker.
Resuming debate. Reprise de débat. Resuming debate. La Chambre est-elle prête à se...
Is the House ready for the question?
Yes. La question est la suivante.
Question is the following one. Mr. Caron, seconded by Mr. Julian, moves that an instruction to the Standing Committee on Finance be given that during its consideration of Bill C-2, an act to amend the Income Tax Act, the committee be granted the power to divide the bill in order that the provisions related to the contribution limit increase of the tax-free savings account be in a separate piece of legislation. Is it the pleasure of the House to adopt this motion?
So that's enough.
All those in favor of the motion will please say yea. All those opposed will please say nay. In my opinion, the nays have it. Call in the members.
Speaker, I ask that the vote be deferred to the end of time provided for all questions tomorrow, Tuesday, April 19th, 2016.
Accordingly, the recorded division is deferred until tomorrow at the end of the time provided for oral questions. Now we'll revert back to la Chambre va maintenant pour...
The House will now proceed with the remaining routine proceedings. Motions.
Presenting petitions. Présentation de pétitions. The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It gives me great pleasure to rise today to present two petitions. The first is from many, many residents within Saanich Gulf Islands, as well as I look at the petitioners, hail from as far away as New Brunswick and some indeed from Ontario, call on this government to take action to ensure that consumers know what they're buying by having mandatory labeling on products that contain genetically modified materials. The second petition, Mr. Speaker, has a number of hundreds of signatures, and this is one where we are in the midst of responding to the petition. The petitioners want to see a full consultation to get rid of the perverse voting system, first past the post, and move to a system by which we are here as members of Parliament elected in a system where every vote counts, that is by proportional representation. Thank you.
Presenting petitions. Présentation de pétitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Prime Minister.
Mr. Speaker, I ask that all questions be allowed to stand.
Is that agreed? Agreed? Yes? Agreed and so ordered. Orders of the day. Ordre du jour.
Government orders, government bills, comments, reprise de débat, deuxième lecture.
Resuming debate on Bill C-10, an act to amend the Air Canada Public Participation Act and to provide for other certain measures. On the amendment of Mr. Dubé. Resuming debate. The honourable member for Rosemont, la petite patrie. Thank you. It's an enthusiastic welcome. First of all, Mr. Speaker, I'd like to tell you that I'm going to share my time with the honourable member for Elmwood Transcona, who will have the opportunity to speak to this very important bill, because there are tangible effects on people's lives. I'd like to begin my speech, Mr. Speaker, by saying that most of the time I'm happy to be able to participate in debates and to rise in this House in order to be able to debate issues with my parliamentary colleagues. But today it's a little bit different. I'm rising in this debate and I'm somewhat discouraged because of the Liberal government's decision. And this is really a betrayal. There's an absence of confidence, of trust that they have, this government and 2,600 families across the country, including 1,700 in the Montreal region, who find themselves completely abandoned and rejected out of hand by this bill, C-10, and by this Liberal government. One has to understand, I'm trying to put this into context briefly, in 1988, the Air Canada Public Participation Act was set up because there was to be privatization of Air Canada the following year in '89. In the bill, in the legislation, it is clearly said in Section 6 that aircraft maintenance for Air Canada must be done within the country and specifically in 3 specific cities: Winnipeg and Montreal. And this has worked for years. Air Canada complied with the legislation, particularly with the contract that gave Montreal subcontract with a company called Avios that went bankrupt in 2012. But things got complicated afterwards because Avios went bankrupt and disappeared, but Air Canada did not replace them. On the contrary, they took advantage of that to send those jobs elsewhere, and that work to be done in other countries of the world, in Asia and in the U.S. and in Europe. So these people have lost their jobs, even though they were guaranteed by federal legislation that had been implemented years before. What we saw at the time was a conservative government that just crossed its arms and stood back and did nothing to ensure that the legislation was complied with. And the Liberals at that point in time wanted to show their support for the workers, their fraternity, their camaraderie, and we even saw the current Prime Minister, the member for Papineau, go and protest at the time on Parliament Hill. And he was shouting with the workers, so solidarity, and requiring or demanding at the time that the Conservative government at that point in time enforce the act. So they were the so-called law and order government, and they should have done that. These are good paying jobs we're talking about in a really good sector. So the Liberals come to power, and all of a sudden their position changes. They change their tune, and they aren't saying so solidarity anymore. They're shipping the jobs away. Forget about those good jobs. They're abandoning the aerospace sector, and they're telling these people that their jobs are gone for good. Because what the Liberals discovered when they came to power was not that they were to enforce the act, but they just said, we'll change the legislation. So that would be easy. They won't need to enforce it anymore if they change it, if there's no longer any obligation for Air Canada to have this maintenance done in country. We're wondering if that is the Liberals' job creation plan, to abandon the good jobs we have here and in Quebec and in Mississauga and in Winnipeg and do job creation in the United States and in Europe, because that's the consequence of C-10. That's what happens when they abandon all these workers. They're represented by the FTQ and the Machinists Union. And this is interesting, Speaker. They went to the Supreme Court in 2013. The Quebec Superior Court said, you're quite right. Air Canada appealed the decision. It went to the Court of Appeal in Quebec. And in 2015, the court said to the workers, you're right. And Marie-France Biche of the Quebec Court of Appeal said that from the moment where Air Canada's business has resulted in them closing the Avios Centre in Montreal because it no longer corresponds to what they had agreed to in the last few decades, it is against the law. Now, it couldn't be any clearer than that. The problem with C-10 is that they want to pull the rug out from under the feet of these workers by making any court cases much more difficult. Because if they go to the Supreme Court, and they intended to, well, Section 6 of the legislation of the Act has been amended. So this results in a whole new legal framework and a whole new reality, because C-10 and the Air Canada Public Participation Act are very weak now on Air Canada's obligations. There's no longer any requirement in terms of maintenance within the country. There is no floor in terms of the number of jobs to protected or percentage of what percentage of this work should be done in the country. So, in other words, Mr. Speaker, it's a blank check they're handing to Air Canada. The government wants to give them flexibility, but Air Canada will become a contortionist under this, you'll see. And they're just getting rid of the well-paying jobs that exist here at home. I'm very sad to have this kind of a government without any conscience whatsoever of the effect on the lives of these 2,600 families, will abandon them after having supported them publicly. It's very sad.
Today about a really sad story. The story of employees of Air Canada who have lost their jobs in 2012. We're talking about 2,600 families all around the country because Air Canada had the legal obligation to do the maintenance of its planes here in Canada, especially in Winnipeg, Mississauga, and Montreal. Now, they can do whatever they want. When the Liberals were in the opposition, they were standing outside this building with the workers, with the union, singing solidarity, brothers and sisters, and we will support your jobs because they are good jobs. And they were asking the Conservative government to apply the law, the 1988 law about Air Canada. And suddenly, I think it's, when you gain power, it's like some magic appears. And they change their mind completely. And they sing another song. Now it's no solidarity forever. Now it's job creation for United States, Europe, or Asia. Because with this law, with C-10, there is no more legal obligation for Air Canada to keep those good jobs here in this country. Air Canada have a blank check. They can do whatever they want now. And it's sad because the workers and their union, the machinists, and in Quebec, the QFL, they went to court and they won twice, in Cour supérieure and in Appeal Court of Quebec. And the decision of the judges were crystal clear. Air Canada was not respecting his legal obligation about the maintenance of his planes. Now, they are changing the law, and it might have a really profound and brutal impact on the legal pursuits of those hundreds of workers in Supreme Court of Canada. What they are saying right now is that we don't want to help you anymore. We will say that Air Canada can do whatever they want, find another job. But aerospace is a very important sector in our economy, especially in the Montreal area. Et Monsieur le Président, nous not...
And Mr. Speaker, we're not buying the Minister of Transport's argument, saying that, yes, Air Canada will buy the C-Series from Bombardier, so there'll be job creation. That's comparing apples and oranges. If Air Canada's buying the C-Series, it's because it's a good plane and they need it. We refuse to put the manufacturing sector in competition against the maintenance sector. We are capable of doing both. We should do both. The Liberals should understand that, and they should be ashamed of letting very good jobs down, and we are going to fight against this and let them hear reason for once. Questions and comments? The Honourable Parliamentary Secretary to the Minister of Transport.
Thank you very much, Mr. Speaker, and thank you to the Honourable Member for his comments. I think we can agree that the aerospace industry in Canada is so very important. But I think you have forgotten some of the key points to the changes to this Act and what this will do. Quebec has estimated that the creation of the Centre of Excellence in Montreal alone could produce 1,000 jobs over 15 years, while the manufacturing of Air Canada's C-Series aircraft could create an additional 300 jobs. Air Canada also intends to support the creation of 150 jobs in Manitoba, with the possibility of expanding beyond that. So, Mr. Speaker, it's obvious the opposition is not understanding the positive impact that the changes to the Act will have. Thank you very much.
Honourable Member for Rosemont, La Petite Patrie.
Thank you, Mr. Speaker. I thank my colleague for her question, but she doesn't have the facts really right. First of all, the supposed, Excellency Center is not in Montreal. It's supposed to be in Trois-Rivières. So, you have to have the right city first. And by the way, this law has nothing to do, and C-10 has nothing to do with the fact that Air Canada will buy C-Series of Bombardier. Exactly. Air Canada is buying C-Series, and it's a good thing because it's good planes, it's good jets. What we are talking about is legislation that will change a law about maintenance of airplanes with Air Canada. It's two different things. Don't compare bananas with oranges or apple or whatever fruit you want. And about the Excellency Center in Trois-Rivières, it will maybe make the maintenance for the C-Series in 15, 20 years, and we have absolutely no guarantee about job creation there. So we are talking about real families and real jobs that you are abandoning right now, and this is bad.
Questions and comments? The Honourable Member for Sherwood Park, Port Saskatchewan.
Thank you, Mr. Speaker. And I'm a bit incredulous about the arguments that the government is making, especially as it respects the C-Series, because many of the speeches, the comments made by the government, they allude to these jobs associated with the C-Series. But of course, Bombardier is a separate company. The government will not be clear about the connection between the Air Canada Participation Act and the investments being made by Bombardier. It's curious that the government seems to draw this connection, but won't answer a direct question about whether or not the introduction of this act was dependent on the purchase of C-Series by Air Canada. It's curious that they won't identify the connection. I wonder if the Honourable Member can perhaps speculate on what the connection between these two things are and why the government continues to refer to Bombardier in the context of this debate when the Air Canada Participation Act does not directly mention Bombardier in any way.
Honourable Member for Rosemont, La Petite Patrie.
Speaker, I want to thank my colleague about his question. It's really pertinent. and he's absolutely right. And I will probably not say that for many issues, but on this one, he's absolutely on target. I think that the government is trying to put forward, some job creation about the fabrication of the C-Series to make people forget that they are abandoning 2,600 families and they are not respecting a promise that they have made and repeated to those workers and those families. I think they should reconsider C-10 and say that, Air Canada should continue to keep those good jobs here in Canada. It's good for our regions, it's good for our cities, it's good for our economy. That would be a good creation plan, job creation plan from the government, and it's really sad that they are doing otherwise.
Questions and comments? The Honourable Member for Skeena, Bulkley Valley.
Thank you, Mr. Speaker, and I thank my dear colleague from Quebec, because I imagine there are two versions of the Liberal Party now. There's the version we heard from during the campaign, the two versions of the member for Papineau, the new Prime Minister, who was standing with the workers and their families. He made some very strong statements saying we'd protect your jobs and your families. But imagine the new version of the Liberal Party saying the same things they're saying today to the workers during the campaign. I'm sorry, but we're going to change the legislation. We're going to change the law and do away with jobs for 2,600 families. Air Canada wants something. It wanted this legislation to be changed. C-10. And they said, we'll buy a few planes. So that's good. The member for Papineau, the new Prime Minister, said, sure, no problem. But this is against the workers. So which version of the Liberal Party, which version do we have of the member for Papineau here? The Honourable Member for Rosemont-la-Petite-Patrie. Thank you, Mr. Speaker, and I thank my colleague for his excellent question. This is a real classic in our history. The Liberals in opposition are the friends of all of the workers and all of the associations and the unions and various groups, and suddenly when they come to power, poof, they become best friends with all the people on Bay Street and the business owners. So my colleague is right. If they had had the honesty during the campaign that they were going to change the Air Canada Public Participation Act to legalize these job losses, to authorize this, I think that in many ridings they wouldn't have gotten the votes they got, because today all those workers feel disappointed, they feel betrayed, and they're furious with the federal government. The Liberal government will continue to fight for these people and their jobs.
Honourable Member for Elmwood-Transcona.
Thank you very much, Mr. Speaker. I'll start by saying just how disappointed I am to have to rise to speak on this bill. It's not the kind of bill that I expected to have to deal with. Certainly if you go back even a year from now and you were to tell me that the Liberals were going to be in government and then base a projection about this kind of bill on what they were saying at the time, I never would have thought that I'd be standing to speak to such a bill, Mr. Speaker, because at that time, in the last Parliament, the now Prime Minister was standing on picket lines with Air Canada workers, shouting solidarity and probably taking a few selfies too, Mr. Speaker. And that was great because he was out shopping for votes at that time. And it might have been the case that many workers who actually felt that the Prime Minister was serious in his, in his expression of solidarity may well have gone out and voted for a Liberal government because they never would have suspected that a Liberal government would bring forward an act like this. And if you were to look at what some of the Prime Minister's then members were saying in the House, some of whom have returned, like the member for Winnipeg North. They were saying the law is clear. The corporation is to maintain operational and overhaul centres in the City of Winnipeg, the Montreal urban community, and the City of Mississauga. That is the law. The government says it's tough on crime. It's time to get tough on Air Canada, Mr. Speaker. That's the kind of remarks that we were hearing from Liberal MPs like the member for Winnipeg North at the time. Fast forward to today, Mr. Speaker, and as I was mentioning in debate on a motion just earlier, we're 6 months into the new government. Most of the legislation that's been brought forward either is a kind of is routine business with respect to the financials of government. They're bills responding to Supreme Court decisions, usually with the court-imposed timeline, or they're a straight up and down repeal of certain measures brought in by the previous government that were explicit election commitments of the Liberal government. If you want to look for a bill that isn't that, really the only indication of the legislative spirit of the new government, if you will, Mr. Speaker, that goes beyond those things, the only indication of what they're going to be like for the next 4 years on issues that weren't foreseen in the election is this bill. And I have to say, it's a complete betrayal of the workers that they pretended to be the champions of when they stood beside them on the picket line. And it's shameful, Mr. Speaker. It's absolutely shameful. And it's a sign of the kind of cynicism and condescension, I think, that the Prime Minister must feel towards Canadian workers, because I don't know how you could stand on a picket line with them and say that you're going to protect their jobs, that the government should, to shame the government of the day, Mr. Speaker, for not enforcing an act that in the end it was his intention to change when he came to government. I mean, that is a rhetorical sleight of hand, the likes of which I don't know that the previous government even was capable of. So if the campaign was righteous, oh, they should be enforcing the act, they should be enforced, we'll enforce the act. Yeah, right after you change it, to get rid of the very provisions that would protect the jobs and the very reason for which the workers would like to see it enforced, Mr. Speaker. So I just, I'm appalled, frankly, I am. And maybe having spent as much time around politics as I have, I shouldn't be surprised, particularly not by Liberals, Mr. Speaker, but we're 6 months in and they've already managed to teach me new depths of cynicism when it comes to politics, Mr. Speaker. So they would have you believe, if it's a contest of narratives, as politics so often is, that there's this happy coincidence of factors, Mr. Speaker, that it just so happens, without any prodding or conversation between government and Air Canada, that Air Canada decided to buy some C-Series Bombardier jets. Just so happened to be at a time when Bombardier was in trouble. I think some other honourable members have done a good job of trying to poke and prod at this issue to get the government to affirm that there is a connection between those things. But if you listen to the government answers, they say, no, there's no connection. It's just a happy coincidence. Bombardier was in trouble. Air Canada came forward. It just so happened that when Air Canada came forward and there were some rumblings about the federal government selling out Canadian workers and the provinces, that the provinces just happily decided to drop their lawsuits, Mr. Speaker. And because all these things magically came together by some force unseen, well, this is a great time to change the act because, after all, don't we need to be fair to our Air Canada? The very same Air Canada, Mr. Speaker, it was time to get tough on not that long ago when the Liberals were in opposition. That's the story. And then they say, oh, and there's going to be a whole bunch of benefits to accrue from this act. It just so happens that none of them are in the act. The centers of excellence aren't in the act. There's no legal guarantees for those jobs. There are for the ones that are getting gutted, Mr. Speaker. But for the new jobs that we're supposed to take as this great trade, Mr. Speaker, there are no legal protections for those jobs, and there's no guarantee that Air Canada is not going to turn around and walk away and put those jobs somewhere else, Mr. Speaker. In fact, under the terms of this act, and it's not the clause, incidentally, Mr. Speaker, that says, oh, instead of having the jobs in Winnipeg and Mississauga and Montreal, we're going to have them in Manitoba, Ontario, Quebec. That's not by far the most contentious clause. It's the one right under it, Mr. Speaker, that says that Air Canada is going to define for itself the type of work that's going to be done and the type of work that's going to satisfy the requirements of the act. It's the clause that says they're going to determine the volume of work, Mr. Speaker, and the level of employment. Air Canada could rent a closet in Winnipeg, put some engine parts on it, and pay a guy to come around once a year and check up on them, make sure they're still there, maybe dust them, and that would be sufficient, Mr. Speaker, to meet the requirements of this act. So you can't tell me that we're supposed to be happy with that situation and accept a bunch of jobs that don't have any guarantee at all, and particularly when the language of the company and the government, incidentally, next time there's a spot for a Liberal speaker on this, Mr. Speaker, I wonder if maybe we just shouldn't invite the Air Canada corporate execs in and hear from them directly and cut out the middleman, Mr. Speaker. They're expensive middlemen for Air Canada in this debate, and I would say we don't need them. We've heard these kinds of arguments before when we hear about flexibility, when we hear about the need to compete. And I'm sensitive to some of that, but one wonders, Mr. Speaker, there's a tension here. And that is, are we saying that we've come to the point where we can't do maintenance on planes in Canada and have a competitive company? Is that what we're prepared to say? Is this what the Liberal government is encouraging Canadians to believe? That the global economy has come to a point that we can't do maintenance on planes in Canada, that they have to be shipped somewhere else in order for companies to be competitive? One wonders why one should be so concerned about the viability of a company once it doesn't mean any direct employment in Canada anymore. So we're giving up guarantees for these jobs because we need to be flexible and competitive. Well, that language means moving the jobs out of Canada, Mr. Speaker, and the government can't have its cake and eat it too. They can't say that this is all about creating jobs when the obvious logic, all of the jobs that they're talking about, frankly, Mr. Speaker, are completely consistent with the Act as it is. There is zero reason in order to establish those centers of excellence to change the Act, Mr. Speaker. So if this wasn't about exporting jobs, if this wasn't about sending jobs to Mexico or to someone was mentioning where some of those jobs went earlier, and the name is escaping me, Mr. Speaker. But if it wasn't about sending those jobs away, then why the changes to the Act? It doesn't make sense. So on the face of it, Mr. Speaker, this is what that is about. It's about taking good-paying Canadian jobs and moving them out of Canada. And the rest of it, the window dressing, Mr. Speaker, none of which is in the Act and none of which is legally enforceable, is all about giving a fig leaf to cover the government's cover the government in this, Mr. Speaker. That's what this is about. Well, yeah, and they need a big one because there's a lot that's ugly to cover, Mr. Speaker. There's nothing to say that a month later Air Canada, and I'm not saying there will, maybe it'll be 3 years, maybe it'll be 4 years, maybe it'll be 5 years. But there's nothing to prevent those jobs from being taken away. The Liberals knew that well when they were in opposition. They did. That's why they said the government should enforce the Act. They can't. I mean, they must realize that now there won't even be an Act to enforce, Mr. Speaker. Not in any meaningful sense, because Air Canada, under the Act, will have been given every right to define the scope of this work right out of Canada. So that's, I mean, it's the Liberal narrative on this, Mr. Speaker, is so contorted, it's just shocking. And I hope that Canadians will listen to this debate. They don't have to listen to a lot of it to understand what's really going on. I hope they're paying attention because what's going on here is completely unacceptable. Thank you.
Very good. Questions and comments. Question commentaire. The Honourable Member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker, and I congratulate my colleague on his speech. I worry that I'm agreeing with New Democrats a little too much today. But you know, he is absolutely right to highlight the strangeness of the government's arguments here. We have these repeated kind of wink, wink, nudge, nudge references to Bombardier, and yet there's no reference to Bombardier in the legislation. But even so, even if there is some kind of quid pro quo going on here, it's rather poorly set up because after this legislation passes, there is, of course, no guarantee that the purchase of the C-Series will go forward. These aren't guaranteed jobs at all. The government really is, at this stage, giving up something for nothing. So, Mr. Speaker, I wonder if the member has thoughts on why, at this stage, the government is giving up these Canadian jobs and getting absolutely nothing in return for workers or taxpayers.
Well, member for Elmwood, Transcona.
Well, thank you very much for the question. And I think that is the question that the government has yet to answer. So what really is here? As you say, we've got some nods, we've got some winks. Well, this is, maybe going to help out Bombardier, and that would be nice because, geez, that seems like a big issue, and it is, Mr. Speaker. It's important to continue having work at Bombardier, but we've got a government that, what the proper response would have been to sit down and say, geez, we need a strategy for the aerospace industry in Canada. That's what we need to do. And instead, it was sort of, I don't know if it was just a sort of panic or inexperience or what it was, but they said, hey, here's a one-off deal. We can give something to Air Canada. We can make Air Canada execs happy. We can create some jobs at Bombardier. And oh, yeah, Western Canada. Where is that again? What we need is a national strategy so that we're not doing the same old of pitting region against region and that each region gets its due. There are serious challenges in the aerospace industry today. The way to do it is to sit down and come up with a strategy instead of cutting a bunch of one-off deals and finding out later it was the wrong play.
That's right. Well said.
Questions and comments?
The Honourable Member for Belleuil-Chambly. I'd like to thank my colleague for his speech.
That a Liberal member said in the Transport Committee in 2012 when this issue was before us, and let's try and guess who said this at the time. The member goes, what interests me is it's important for us to know there must have been some form of a fairly strong relationship between Avios and Air Canada. I talked with numerous employees of Air Canada who were ultimately shifted over to Avios. I can recall very clearly that many of the employees who made that shift indicated they were concerned that this was just a shell game Air Canada was playing, and Avios was just executing what Air Canada wanted to be able to ultimately facilitate the demise of those very important jobs. Who said that, Mr. Speaker? The member for Winnipeg North, who stood in this place and presented petition after petition, who went to committee. This excerpt I've just read to you was fighting for a motion to get Avios in front of committee to stand up for those workers that I assume live in his riding, and my colleague will be able to tell us about that, workers that he has now betrayed. I'd like to allow my colleague to elaborate on that.
Honourable Member for Elmwood-Transcona.
Well, thank you very much for the opportunity to note that the reversal of position by the member of Winnipeg North on this is just totally appalling. He was up in the last Parliament many times, 15, 20 times. He presented 10 petitions. This was terrible. We need to get tough on Air Canada. We need to enforce the Act. You know, and as a politician at the provincial level and then at the federal level, he spent over 20 years in opposition, Mr. Speaker. He finally got a chance to do something for those workers that he stood beside for all that time, and he dropped the ball, Mr. Speaker. Not only did he drop the ball, but he's since been up in this House talking about how we need to, be fair to Air Canada and recognize their difficult position, Mr. Speaker. The very same things that if they come out of the mouth of a Conservative cabinet minister no more than 12 months ago, he would have been all over them for in the House, Mr. Speaker. I think it's shameful, and it's a testament to the fact that that's a member that, if he belongs anywhere in this House, belongs in opposition.
We have time for one more short question and response. The Honourable Member for Yellowhead.
Thank you, Mr. Speaker. The Honourable Member, I agree wholeheartedly with him. But I was flying back from Edmonton to Ottawa last weekend, and I remember looking at this little brochure in the Air Canada thing, it's saying carbon pricing, carbon tax. They put these light food containers in. I just wonder what the member thinks about them flying right across United States to Mexico and how much fuel they'd be using versus putting light food containers in their aircraft to save on carbon tax. Thank you.
Member for Elmwood-Transcona.
Well, I'm really heartened, Mr. Speaker, to hear a concern about the carbon footprint of Air Canada's operations coming from a Conservative member. And I would agree that when it comes to this, given where the jobs are most likely to go, as with a number of issues when it comes to global trade, Mr. Speaker, that assessing the carbon footprint of goods and not simply the cost charged at the counter to consumers is very important indeed. Thank you.
Before we go to resuming debate, it's my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Belleuil-Chambly in respect to rail transportation, and the Honourable Member for Courtenay-Alberni in respect to telecommunications. Resuming debate, reprise de débat. L'honorable député.
The Honourable Member.
Thank you very much, Mr. Speaker. And it's my privilege to rise today to speak on C-10 before this House and to join the debate today. And this is one of those unique circumstances where the opposition in many ways is united in parts and in some ways speaking with a unified voice, but for different reasons perhaps. But in many ways, this debate's an interesting one for me, given my background in the Air Force, Mr. Speaker. My background as a lawyer, which in my early days, articling as a first-year lawyer, I was involved in the CCAA restructuring of Air Canada. And that was a time where Canadians worried about losing our flagship carrier, Mr. Speaker. And the company successfully restructured under CCAA that protected a lot of jobs, a lot of commercial relationships across the country, and it protected the airline, Mr. Speaker. We all remember years where there was many more serving the country, companies like Canadian, Wardair. It shows how globally competitive this industry is, Mr. Speaker, and I was very proud as a young lawyer to be involved acting at a firm that represented Air Canada in that restructuring many years ago. Its heritage, Mr. Speaker, as a former Crown corporation, is really why we're here with C-10, an act to amend the Air Canada Public Participation Act, which was a creature of the privatization. And most of the comments from my NDP friends along the way relate to the commitments made back in 1987 and 88 when this Crown corporation was privatized. And I don't even think my Liberal friends would suggest that the industry is the same today as it was in 1988. So to suggest even the members of the unions they're talking about are performing the same tasks on the same type of aircraft would be false, because certainly the industry has changed in terms of technology, in terms of the needs of the workforce, in terms of the globalization of the supply chain, Mr. Speaker. So we have to have these debates in the Commons. Where I'm united with my concern with my NDP friends is really how this debate is coming to the floor. And in many ways, this new Liberal government is showing that the old ways, and in fact the ways a lot of Canadians disliked about the Liberal governments of the past, appear to be back. When deals are made to benefit, special interests or certain groups, and a full discussion of the public policy ramifications of an issue aren't actually spoken about. And I'm going to raise a few of these points in relation to the debate here at C-10 because I think they're important, Mr. Speaker. In many ways, the Liberals, prove that old adage, why take one position on an issue when you can take two positions on an issue politically and advance both? And here is one that the Liberal Party, most of the Liberal Party at the time in the 1980s, opposed privatization of Air Canada. At the time, the Mulroney government proceeded with that privatization. Yet here they're sneaking in an amendment to the participation aspects and sort of the job guarantees provided in the 1980s with limited discussion, no real mention in their election document, which they hold sacrosanct in all other aspects of what they're doing in their early days. And we're here as a result of it. It's also the result of their bad policy decision with respect to the Toronto Island Airport and the fact that a private sector operator was looking at buying a Bombardier aircraft at a time that Bombardier was seeking government assistance. There was a private sector purchaser, but because of a small and very influential within their caucus lobby group in downtown Toronto, they circumvented the regulatory process looking at the expansion of a regional airport. That is not just a decision made in isolation, Mr. Speaker, because our transportation networks are integrated, and what happens on Billy Bishop will impact Hamilton, will impact the airport in Kitchener-Waterloo, will impact Pearson, will impact the Pickering Airport and what size that takes in the future, Mr. Speaker. So these decisions can't be taken in isolation, but they stop the expansion applications and review for the Toronto Island, thereby eliminating a private sector sale for Bombardier at a time that they're teetering. Yet, behind C-10, Mr. Speaker, is really a deal, I believe, that was crafted by the federal government in relation to another purchaser acquiring said aircraft and coming to the rescue, so to speak. And I would like the minister to bring to this House, was this discussed, was C-10 discussed as an element of the private sector sale to Bombardier that we see Air Canada announcing? Because The announcement came mere days, Mr. Speaker, after that company met with the minister. So what someone needs to do is really just connect the dots on all this and see that what led up to C10, the reason it wasn't in the election platform of the Liberal government was because it has come about as a result of the challenges Bombardier is facing. That is my concern, Mr. Speaker. We need to have a full debate with a full discussion of the impact of Bombardier's financial difficulties alongside sales of aircraft and alongside litigation that several other provinces were party to in relation to the Air Canada Public Participation Act, Mr. Speaker. C10 is a small bill in terms of the number of words, but when you peel the onion on the issues underlying this, as all members of the opposition have been doing today, you see there's a lot more to this bill than the couple of pages that it appears to represent. And the government has not been transparent on that at all. For a government that had their hallmark being transparency in sunny ways, we see that jettisoned on most issues within weeks, Mr. Speaker. So in my remarks, I'm going to explore why I think these underlying public policy decisions relate to what's before us in C10. And that's why I have serious concerns with C10, Mr. Speaker, is the government has not been transparent on the road that has us here, considering this amendment to a long-standing act and a long-standing practice. I'm also proud, as I said, as a former officer of the RCAF, very proud of our aerospace industry, Mr. Speaker, very proud of Bombardier, proud of Air Canada, our carriers, proud of the suppliers, which are world-class. And that's why when the government made a quick move to scuttle the expansion of Toronto Island without proper consultation, that impacts our industry, which is world-class. A lot of Canadians don't realize that Canada was the third nation in space with Alouette 1. Canada basically trained most of the pilots of the free world that won World War II with the British Commonwealth Air Training Plan. On the weekend, Mr. Speaker, I played the Honourable George Hees, John Diefenbaker's transport minister, at a recreation of the Avro Aero dinner, Mr. Speaker, and we celebrated aerospace and our achievements. Diefenbaker himself wasn't celebrated at this dinner because he did cancel the Aero, Mr. Speaker. But we have a tremendous heritage, and the opportunities in this industry are really not well known by Canadians. We remain the #1 producer from an R&D and a production standpoint of flight simulators around the world. When I was in Seoul as the Parliamentary Secretary for International Trade, Mr. Speaker, in the previous government, I toured CAE's simulator just outside Seoul, providing flight training and aircrew training for Asian airlines, Mr. Speaker. We were there as part of the South Korean trade agreement. That's a company with a global reputation as the best in the business, and we should celebrate that. Canada remains the #3 producer in terms of aircraft production, small and medium-sized aircraft, with a new larger one on the horizon with Bombardier. That will again be best in class, Mr. Speaker. We're third in engine production for civilian or civil air purposes, Mr. Speaker. These are incredible numbers. They're all well-paying, all highly skilled and high-trade jobs, Mr. Speaker, and they're all trade-focused. So at a time where our dollar is lower and we have the ability to trade very competitively, we should be taking advantage of leveraging this industry, not secret deals that actually hold it back. $28 billion in revenue across the companies within this sector, both in the supply chain and production and in manufacturing, Mr. Speaker, and 76,000 jobs across the country in all provinces, but with particularly well-regarded and highly concentrated industries in the Montreal area, in Winnipeg, in Toronto, also in mainland BC as well, Mr. Speaker. So these are jobs we should foster, we should work with, and our previous government did in terms of reforming research and development. In fact, the Red Wilson report the previous government outlined to make sure we constantly looked at our competitiveness, Red Wilson had been a leader, a corporate leader at CAE, Mr. Speaker. And it's worth noting some of these companies, and I have a particular passion for them, not just because I'm ex-Air Force, but because I'm ex-Minister of Veterans Affairs. A lot of them are veteran employers, Mr. Speaker. Very, very, in some cases, their senior leadership are veterans. McDonald Detweiler and Associates, the famed Canada arm, Mr. Speaker, in space, probably our biggest iconic R&D development. Viking Air, which has recreated some of the old classic de Havilland aircraft that have been flying for generations. Cascade, Avcorp, Bombardier, CAE, Comdev. And of course, we also have global companies producing in Canada, companies like Boeing, Canada's companies like General Dynamics, companies like Lockheed Martin, through our industrial regional benefits programs, Mr. Speaker, that provide supply sector jobs as a result of our defence purchases, which at times with this government seem somewhat uncertain. But if something is acquired, there is money put into research and development, to jobs on the ground here. And I think that supply chain is critical, Mr. Speaker, and why our industry here does have to modernize. So we do have to have a debate on the ground about public participation, about the industry, so that our manufacturers, including some of the businesses I named, not just take advantage of servicing for Air Canada or WestJet or Porter. They really need to be involved in the global supply chain for both maintenance and production, Mr. Speaker. So what are we here for on C-10? We've heard a lot of passion on the side of members of the New Democratic Party, but it boils down to really three subtle changes to the Act, which came in as a result of the privatization of Air Canada in 1988. One, and it's amending Section 61D of that Act, changing the maintain, operations, and overhaul description of securing jobs as they stood in the 1980s into carry out or cause to be carried out, which kind of recognizes that a lot of specialized manufacturers, whether it's landing gear or components, they can provide that specialized maintenance, that life cycle maintenance that's important in the airline industry, Mr. Speaker. And that specialization can happen through the carrying out. So that actually makes sense, Mr. Speaker, in this environment. But you haven't heard that because of the secret deals that has brought us to C-10. The operation and overhaul has been expanded to certainly show that it includes any type of work related to airframes, engines, component parts, mainly because we have some expertise on a subcomponent basis in Canada in terms of some of the leading producers. And the geographic areas protected back in 1988 with the privatization, which at that time were described as the city of Winnipeg, the city of Mississauga, and the Montreal urban area, because I think they needed to describe that in a wider sense. The new amendments proposed in C-10 would just refine that to the provinces as opposed to those cities proper, Mr. Speaker. So the substance of C-10, in some ways, recognizes the fact that the industry is not the same industry it was in 1988. And I can certainly understand why Air Canada probably wants to be unshackled from the requirements put on in 1988 to make sure that the privatization wasn't too disruptive. And if you look at the airline as it stands today, it's strong and a global leader in many ways, Mr. Speaker, but it's also subject to global competition and has to be able to take advantage of the same expertise and opportunity. So if you're going to carry out or cause to be carried out in a certain part of Canada, as long as you're getting that best-in-class ability to maintain and modernize fleets, that's really what we want to see. The other thing I said, Mr. Speaker, at the outset that has us here in this debate today that the government hasn't been transparent on is the fact that C-10 is really the result of litigation in relation to adherence to this Act. And as I said, Air Canada probably understandably, feels unfairly shackled by something that was done not just by the last government or the previous government, 3 governments ago in the 1980s at a time where privatizations were, a little new. But I think today, most Canadians would certainly not expect the federal government to operate their airline in a competitive environment where there's lots of choice, Mr. Speaker. In Quebec, Quebec and Manitoba, I should say, joined the International Association of Machinists and Aerospace Workers in litigation related to business changes in those jurisdictions. And certainly with that union involved, that's why my friends in the NDP are as passionate. And I respect their standing up for workers and items they believe. But I would suggest that their workers would tell them that this is not the same industry that it was in 1988. But what we saw was both Quebec dropping its participation, the government of Quebec dropping its participation in this litigation as a result of an Air Canada decision to purchase aircraft. So obviously there was some political horse trading that went on, and the Quebec government removed itself from this litigation in return for Air Canada supporting the industry through the acquisition of Bombardier aircraft. Manitoba, Mr. Speaker, also removed itself from this litigation by carving out a deal where Air Canada supported 3 world-class aerospace services suppliers in Manitoba and leased one of the Air Canada maintenance hangars to an operator in Manitoba, Mr. Speaker, on favorable terms. So in that case, there was another provincial government coming up with a deal they thought was sound to remove themselves from a civil action in relation to an act from the 80s. As I said at the outset of my remarks, I would have much preferred the Minister of Transport to come to this House and tell us that C-10 is the result of yet another pragmatic deal that was made. But to do that, you'd have to outline all aspects of that deal, Mr. Speaker, and what exactly happened, and did the government approach a private sector player to help it with respect to requests from Bombardier for assistance? Because I think this is where we get into some difficult territory, Mr. Speaker. Should the government be convening these meetings behind closed doors to cobble out a position, particularly when the minister was getting heat for ending the exploration of expansion of the Toronto Island Billy Bishop Airport and cancelled that with a tweet, Mr. Speaker, after demands from people within his caucus and within a group in Toronto advocating against an expansion, Mr. Speaker. What that cancellation led to was a private sector company that was planning an acquisition of Bombardier aircraft. They could no longer proceed. So all of these events gather, Mr. Speaker, and that is the run-up to why we have C-10. So we can't actually have a rational discussion on whether it would be helpful to unshackle a company from requirements that limit its competitiveness from 1988 legislation. We can't have that discussion, and I'd like to, Mr. Speaker, because the minister in this government has not come to the House in an open and transparent way. Much like the parliamentary budget officer said they approached their recent budget, the least transparent in over 15 years, Mr. Speaker. I would like this government to outline all aspects that went into C-10, the related litigation, the pressures in relation to the financial stability of Bombardier, and Air Canada's need to be competitive in a global age. I think we could have a proper debate if that was here before the House, Mr. Speaker. I'm very disappointed that information is not here for this debate. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Minister of Transport.
Thank you very much, Mr. Speaker, and thanks to my honourable member for his comments. And I just wanted to underscore, I wanted to be clear on a couple of points. The government wants Air Canada, which is a private company, to have the flexibility that it needs to manage its business operations in 2016. And we understand that the air transport sector has evolved since 1989 and will continue to evolve. And Air Canada needs the tools and regulatory supports to keep pace. But this must be done within a framework, within maintaining adequate safeguards for Canadian workers and suppliers. And that is why we are proposing to ensure that the Act continues to require Air Canada carry out aircraft maintenance in certain Canadian regions. And that's why we want this Act to proceed to the committee stage so we can hear from stakeholders and get more debate at the committee level. Thank you very much, Mr. Speaker.
Honourable Member for Durham.
Thank you, Mr. Speaker, and I'd like to thank the Parliamentary Secretary for her intervention. I think she could detect from most of my remarks here that it's not the actual policy within C10 that I have the issue with. It's the road to getting to C10 that causes me some difficulty, because I do think, as I said at the beginning of my speech, having worked on the restructuring of Air Canada and seen the growth in recent years and the success, and in fact the strong leadership of Kaylin Rovanescu and the team they have, there is a good debate to be had on should they be shackled exactly to the purposes of the 1988 Act. What I would ask her was she part of the meetings on February 15th that the minister took with that company? Because what I'd like to know is, did the minister facilitate this sort of deal, much like the Quebec government facilitated settlement of litigation, much like the Manitoba government facilitated a deal? It's the facilitation that hasn't been explained to this House that's an important part of C10.
Commentaire, questions and comments. The Honourable Member for Beloeil-Chambly.
Merci.
Thank you, Mr. Speaker. I would like to thank my colleague for his speech. Even if the two opposition parties are both opposed to the bill, we don't necessarily have quite the same views. But I want to talk with my colleague about the difference in the Liberals.
Committee. So this member says, I do believe in the rule of law. I believe that when an individual or corporation breaks the law, there should be some justice that comes out of it. The workers of Avios, who are formerly Air Canada employees, feel there has not been any justice, that their government has let them down. Then goes on to read the law as it currently exists, before C10, of course, and then goes on to accuse Air Canada of wanting to privatize, and says, as someone who is concerned about the worker, we read and interpret it as Air Canada is obligated to maintain those overhaul centres. Then Air Canada kind of privatizes and pushes that responsibility over to Avios. A court then makes a decision that because Avios is now there, Air Canada is indirectly keeping those jobs. Who said that, Mr. Speaker? Once again, the member from Winnipeg North is showing us how this Liberal government opposes one way, governs another. I'd like to hear my colleague on that.
Very good. Honourable Member for Durham.
Thank you, Mr. Speaker, and I'd like to thank my colleague for his passion on this issue, and we've heard some of his colleagues express the same concerns. I think where we do differ is the progressive Conservative government of Mr. Mulroney, Prime Minister Mulroney, privatized Air Canada, and at the time, the public policy decisions were reflected in the Public Participation Act. And I would think it would be fair for me to say, and I think my friend would agree with me, that the centers of excellence of the aerospace industry, and I mentioned our strengths in that industry, in Montreal, in Winnipeg in particular, and in Toronto, are still quite strong. What has changed is the nature of the global supply chain. So these are the debates we should have in this Commons. Not in the court of law, like some of the unions have taken this route, to hold the industry to a frozen moment in time in 1988 would not be prudent. But what we haven't had here is the full discussion that they've had in Quebec or in Winnipeg about how those governments took pragmatic public policy decisions to then remove themselves from litigation related to this act. I think the same thing has happened here. I've outlined in my speech where I think it's happened. I just would prefer if the minister got up and said that to the House.
Questions and comments? Question commentaire. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker, and I thank the member for his excellent speech. I just want to note that there are many other things that the government could be doing that would improve the competitiveness of Air Canada that don't negatively impact workers. For instance, they could raise the foreign ownership threshold. They could work to streamline processes in terms of customs. They could work to realign regulations. There are a variety of things that Air Canada has mentioned as contributing to their competitiveness, changes that would help their competitiveness, and this really isn't one of them. So I wonder if the member can speculate as to why the government is moving in this direction and maybe identify, as I have, some of these other alternative ways that we could actually help increase Air Canada's competitiveness.
The honourable member for Durham.
Thank you, Mr. Speaker, and I'd like to thank my friend for his question and outlining, yes, that there are a variety of public policy options available to the government. In the previous government, the capital cost allowance acceleration and a variety of other R&D credits and reforms were ways that we were trying to help the manufacturing industries across the country, particularly in my province of Ontario, on a range of industries, Mr. Speaker. And I met regularly with the Aerospace Association and industry in Canada on ways that we could do that in a way to help them. What we see here, as I said earlier in my speech and in previous answers to questions, is something that is really the result of litigation, which is the result of the financial instability of one of those aircraft assemblers, Mr. Speaker. And what we haven't had is a proper talk on that industry. Certainly, having lived in and served in the Air Force in Winnipeg, I know the excellent track record that industry has and global reputation, Mr. Speaker. How can we best facilitate the success of that industry? Some of the policies of the previous government are the answer, as well, Mr. Speaker, letting the regulatory process for airports like the Toronto Island Airport to run its course, and then the private sector will actually help before the government has to come with a bailout.
Questions and comments. The honourable member for Laurentide Labelle.
Thank you, Mr. Speaker. The member for Durham made reference to celebrating the Avro Arrow. The cancellation of the Arrow by Conservative Prime Minister John Diefenbaker represented a substantial and significant hit to Canada. He mentioned it to Canada's aerospace industry and took away our leadership position in the military aerospace sector. It'd be hard to argue that we ever recovered from that missile hit, as a manner of speaking, as recent discussion over new fighter jets clearly demonstrates. Can the member please tell us why we should take his party's advice on questions of leadership in aerospace with such a disastrous legacy and with the significant long-term consequences that resulted from the prior attempts at Conservative leadership in aerospace? Or am I off the bow mark?
The honourable member is asking a question that admittedly is a little bit off the topic that's in front of us today. Nonetheless, as he pointed out, the honourable member for Durham did actually raise the point in his remarks, so we'll certainly allow the question. The honourable member for Durham.
Thank you, Mr. Speaker. He certainly was off the bow mark. I did get his final reference, so kudos to him. Certainly, Mr. Diefenbaker was almost burned in effigy at this dinner I had, and I had a hard time staying in form, pretending to be George Hees, one of his ministers at the time. And I would like to thank the Clarington Museums for such an amazing event, Mr. Speaker. But I think there's been no government that consistently has supported this industry better than Conservative governments, Mr. Speaker, because the Industrial Regional Benefits Program from our procurement programs is really what keeps these supply chains alive. That is why this Minister of National Defence is asking the Prime Minister to reverse his position from the election. You know, like I said in my speech, they like to take two positions on one issue. In the election, they were cancelling the F-35. Now, maybe not. I would remind that member, and I would thank him for teeing up this response. As a former Sea King aviator, I certainly do know the hundreds of millions of dollars lost and the job cuts and losses to the aerospace industry as a result of the move by Prime Minister Chrétien. In fact, his first move as Prime Minister in 1993, Mr. Speaker, was to devastate the aerospace industry and set the Air Force back. So I'd like to thank that member for taking us back on a bit of a history lesson.
Resuming debate, the honourable member for Caribou, Prince George.
Well, thank you, Mr. Speaker. I'm pleased to rise in the House to speak to Bill C-10, an act to amend Air Canada Public Participation Act and to provide certain other measures. Speaking in technical terms, this legislation will remove the articles of the Act that stipulate Air Canada undertake operational and overhaul maintenance in Mississauga, Montreal, and Winnipeg. Now for the plain English version, Mr. Speaker. The proposed amendments to the 1988 Air Canada Public Participation Act means that jobs of 3,000 Canadians who provide aircraft maintenance would be affected. Under the amendment, Air Canada would still be required to do some maintenance work in each of these provinces, but would be allowed to change the type or volume or scope of any or all of those activities in each of those provinces. As well, the level of employment in any of all these areas could be changed depending on the scope. They'll be free to dictate how many people will be employed by these centres and what work they will do. But let me be clear with regard to one particular aspect of this, Mr. Speaker. The Conservative Party believes that it is time that Air Canada becomes a private sector company that is not supported by taxpayers. We agree that Air Canada and all of our carriers should have the ability to be more competitive. A level playing field, Mr. Speaker, and this does not have to be at the expense of high-quality, well-paying jobs of Canadians. Having spent almost 20 years in aviation, Mr. Speaker, I'm aware firsthand of the challenges the Canadian aviation industry face in remaining competitive in a global or ever-changing global industry. But before getting into the weeds of this bill, Mr. Speaker, let me just speak about the history of Air Canada in this country for a moment. Mr. Speaker, Air Canada inherited a fleet of 109 aircraft upon being privatized in 1988. All of Canada's major airports where Air Canada first flew were built with the financial support of the Government of Canada at the time. Air Canada is the largest airline in this country and an important international player in the aviation sector because of, not despite of, the support from the Government of Canada and Canadian taxpayers over the years. Today, Air Canada is the largest tenant in nearly every major airport in this country, with the exception of Calgary and the Billy Bishop Toronto City Airport. Mr. Speaker, this gives Air Canada significant influence over each airport's operations and access to the best landing slots in all of our major airports. One might be tempted to say a little bit of a competitive advantage over other carriers, including our other national carriers. As I said before, we welcome the original intent of the Air Canada Public Participation Act when it was introduced in 1988. But the Act put in place clear conditions to ensure that all of the support Air Canada had received from the government to turn it into a profitable Crown corporation was not lost. Government could be seen as perhaps protecting their investment, Mr. Speaker. These conditions were Air Canada would be subject to the Official Languages Act, would maintain its headquarters in Montreal. 75% of its voting shares had to be held by Canadians. And finally, Air Canada had to, and I quote, maintain operational and overhaul centres in the City of Winnipeg, Montreal Urban Community, and the City of Mississauga. Mr. Speaker, given all this, it is surprising that the government would only make such a narrow change to the Act. While it's unclear what level of benefit this legislative change will give Air Canada, it is clear that the intended change will make it possible for the carrier to move thousands of jobs from Canada to other jurisdictions. Mr. Speaker, if we're going to talk about giving further competitive advantage to one of our national carriers, perhaps it would be appropriate to look at the industry as a whole. Because, Mr. Speaker, if afforded all of the advantages previously and Air Canada is still having difficulties remaining competitive, it might be a sign that our national aviation industry might need some retooling. Let me talk about some of the challenges facing the aviation industry as a whole, because to understand the issues, one must first understand the product, Mr. Speaker. Air transport is a critical economic and social infrastructure, providing access to trade, investment. It connects people to jobs, friends, and family, and delivering vital goods and services in remote areas such as air medevac. Geography, population size, and environmental conditions increase the operating costs of air transport in Canada compared to other jurisdictions. The Canadian passenger travel market is relatively mature, and it has enjoyed small to medium growth over the years. The total Canadian passenger market is estimated at between 122 to 125 million in-plane and deplane passengers. But, Mr. Speaker, this pales in comparison to the emerging and developing markets around the world. In some measures, this is due to some of the very same policies developed for the industrial and economic environment in the 90s. Simply put, Mr. Speaker, the very same policies that were designed to protect our industry are now the ones hindering it. Most of Canada's domestic air services are provided by Air Canada and WestJet, and a small number of regional and local air carriers across the country service some small communities from coast to coast. This allows for better customer service and connectivity. In the 90s, Canada saw a Southwest Airline low-cost airline model introduced by WestJet. This came at a time where consumers and communities were held hostage by predatory pricing by Canada's two major airlines at the time, Canadian and Air Canada. Canada's main charter carriers are Transit and Sunwing, and they're focused primarily on seasonal vacation destinations. WestJet's entrance into the Canadian market created excitement by offering low cost of travel. Actually, Mr. Speaker, it allowed many Canadians to experience air travel for the very first time. It was an exciting time, and it was an exciting project to be part of, Mr. Speaker. There was a time that air travel was only for the elite, was considered glamorous and accessible to only those who could afford it. With the entrance of low-cost carriers in competition, air travel is now easily afforded, and this has stimulated our market growth. Both Air Canada and WestJet have now introduced lower cost, lower fare vacation or charter subsidiaries, Rouge and Encore. Respectively, this has stimulated some vacation or destination growth in a number of markets, and as we speak, there are a number of startup low-cost carriers at various stages of financing that are expected to enter the market in short term. Ultimately, this will lead to price competition with existing carriers, and for a time, our national carriers will react with even greater seat sales and maybe even new routes. But as past experience suggests, only the new entrants with deep pockets will be able to survive. Unable to compete or go head-to-head with the big boys because the deck is stacked against them, Mr. Speaker, airline startups and failures are frequent. Ultimately, the only ones that suffer the most are the communities and ultimately the consumer. Mr. Speaker, all this to say, maybe it is time to reconsider policies that may have served us well when the Canadian aviation industry needed protection to flourish, but now impairs our competitiveness. Of course, such protectionism comes at a cost that is largely borne by the consumer, who pay relatively high airfares by the Canadian travel and tourism sector that also, due to higher costs, has been losing market share for over a decade. Simply put, Mr. Speaker, Canada is sliding backwards in terms of our competitiveness. Mr. Speaker, the Conference Board of Canada estimates that Canadian airports in 2012 accounted for $4.3 billion in real GDP, but had a total economic footprint of $12 billion, generating almost 63,000 jobs and contributing over $3 billion in federal and regional taxes. Canadian airports are vital to the success of the Canadian economy, key gateways for inbound and outbound tourism, business and personal travel. Domestic commerce and international trade all are dependent on our key gateways, our airports. Canada is blessed with strategic geographical location. We are equidistant. We are at the crossroads of the great circle routes between Asia, Europe, and the Americas, and we have this competitive advantage, but yet our nation has never taken full advantage of it. Our competition have successfully negated this competitive advantage with integrated policies and programs aimed at stimulating inbound tourism and facilitating connecting traffic through their global hubs. Essentially, Mr. Speaker, overstepping, or to use an aviation term, doing a flyby of Canada. Canada's airports face increasingly aggressive competition from countries that have recognized the importance of air transportation as a driver of economic growth. Our neighboring U.S. counterparts market directly to and easily access a large portion of Canada's U.S. transborder and international travel market. Finally, Canadian airports also compete with each other for the allocation of limited carrier capacity. Mr. Speaker, our regional airports and communities are oftentimes pitted against one another in competition for airline service. As mentioned during the Billy Bishop debate, Canadian airports also face challenging times with changing aircraft capacity and the continued focus on environmental issues such as noise due to residential encroachment. In the 90s, with the introduction of the National Airports Policy, a new framework was defined with relation to the federal government's role in aviation. NAS airports comprised of the 26 airports across Canada that were deemed critical links for our country. These airports were deemed essential to Canada's air transport system. These airports served 94% of the air traffic in Canada. The airports were transferred under lease to airport authorities and in some cases municipalities. The infrastructure of these airports, Mr. Speaker, were antiquated. If not all, some were in need of attention. Through the transfer negotiations, reinvestment monies were given, but the expectation of for these airports were that they were to do everything in their power to be self-sufficient. Airports have very few revenue generation streams, Mr. Speaker. With the transfer of airports and the newfound independence also came the realization that user pay systems were needed. Airport improvement fees now become the norm, and today we have airports that are incredible examples of the NAS airport of the 90s. And we also have seen airports that continue to struggle to be competitive and to be innovative. With a user pay approach to financing air infrastructure and services, it is effective and it is sustainable, but it further increases the cost for sector and for uses. It costs more for airlines to fly into our airports because it costs more for our airports to operate. Canada is unique among its competitors in charging onerous rents and taxes that undermine competitiveness. Airport rents, for example, can represent up to 30% of airport operating budgets, far more than that would be expected in dividends and income tax from a private for-profit airport such as what we see in Europe. Mr. Speaker, the federal government takes in about $300 million annually in rent, but it only invests back $50 million back into our airports. Canada cannot become a world leader in terms of cost competitiveness of air transport without heavy public subsidization of the sector, not only to match the subsidies offered by some of our competitors, but also to overcome the naturally high-cost operating conditions and lack of economies of scale. If Canada wants to remain competitive, we need to fully integrate parts of our local transportation system, recognize essential partners such as government, airlines, tourism, and business interests, and using an overall Team Canada approach to align policy, promotion, and stimulate air travel to and from and within Canada. Mr. Speaker, this alone will have a broader, far-reaching positive impact than what we're discussing today. It will have a broader, far-reaching positive impact than continually giving a single private sector company competitive advantages over others. Arguably, the most important challenge facing Canadian industry today is our air policy. The key to enhancing Canadian connectivity, global competitiveness, and economic prosperity is realigning our Canada air policy. This government can improve Canada's competitiveness, help create opportunity in trade and tourism, which in turn will create more demand for air services, strengthening our national carriers, all of our carriers, Mr. Speaker, not just one, by using their time not to pick off the low-hanging fruit, the easy wins, and looking after friends, Mr. Speaker. Let's look at our policy, our air policy, Mr. Speaker. Let's apply our blue sky policy more progressively and in a manner that is strategically aligned with Canada's international trade and tourism objectives. Let's pursue more aggressive open skies agreements with Canada's free trade partners. Let's pursue progressive and more open agreements with Canada's tourism markets. Open up more markets for tourism and trade. Wow, what a novel idea. Mr. Speaker, tourism is a large and high-growth industry. It has a significant impact on the global economy. In 2013 alone, the tourism industry saw more than 1 billion international tourists worldwide, generating more than $1.3 trillion in receipts. Canada's tourism industry contributes $84 billion to the economy and employs more than 600,000 people. Competition for tourism is heating up more and more, And as more countries are investing in tourism marketing, aligning their aviation and visa policies to attract greater share of this market, Canada is lagging further and further behind. Aligning our tourism objectives with our aviation policy will only serve to build a stronger Canadian aviation industry, stronger carriers, Mr. Speaker. Mr. Speaker, I have a quote from Air Canada's CEO, Kaylin Romanescu. It is indeed time that Air Canada Public Participation Act, dating from the company's privatization nearly 30 years ago, be modernized to recognize the reality that Air Canada is a private sector company owned by private sector interests, operating in highly competitive global industry that has undergone dramatic transformation over the past 3 decades. I agree, Mr. Speaker, but there needs to be a level playing field, and protecting Canadian jobs should be the #1 priority. The announcement made by Air Canada to undertake and overhaul maintenance comes only after the airline announced that it would be purchasing Bombardier's C-Series jets. Mr. Speaker, Air Canada had until very recently been subject to lawsuits from Quebec and Manitoba as a result of the service center closures in those provinces. In the Quebec case, it failed to reopen a factory that went bankrupt in 2012, putting 2,000 skilled workers out of work. The Quebec government filed a lawsuit that accused Air Canada of breaching its legal obligations when it transferred some heavy maintenance work outside the country. The Quebec Court of Appeal sided in ruling last November. However, Mr. Speaker, Quebec dropped the case when Air Canada agreed to purchase 75 Bombardier C-Series jets and service them in the province. Convenient timing? I think not. The Manitoba government also ended legal proceedings after the airline signed a new maintenance agreement that is expected to create at least 150 jobs in the province. Air Canada already outsources its maintenance work to 2 suppliers in Quebec, in addition to providers in U.S., Singapore, Ireland, and Israel. While the Minister of Transport proposed legislation should have nothing to do with Bombardier, this bill, unfortunately, has everything to do with Bombardier, Mr. Speaker. And while the government has yet to announce whether it will provide Bombardier with yet another $1 billion bailout, as requested December 11, 2015, it seems they're finding ways to skirt the public with backroom deals. In a short justification for introducing Bill C-10, the minister hailed the Air Canada's decision to purchase the C-Series aircraft, combined with the government of Quebec's and the government of Manitoba's intention to discontinue litigation against the carrier as the main cause. So nice of them, Mr. Speaker. He also noted that this would allow Air Canada to be more competitive in an evolving and ever-increasing globalized industry. I think, Mr. Speaker, that line alone speaks for itself. Mr. Speaker, the taxpayers of Canada have done a lot for Air Canada, and the company is rewarding them by taking away, high-quality, well-paying jobs from Canadians. The Conservative Party does not support any bill that seeks to eliminate jobs, especially when there are viable alternatives to do so that won't affect the company's bottom line. This government has an opportunity to look at all of our industry and make some real change. If the government really wanted to take a measure that would stimulate the entire Canadian aerospace sector and, as I said, create real change, including Air Canada, it could choose to tackle any of the issues I had mentioned previously. I would note that all of these measures have near universal support in the aviation sector and would not lead to a single loss of jobs in Canada. Thank you.
Questions and comments. Question commentaire. The honourable member for Elmwood Transcona.
Mr. Speaker, I just want to thank my honourable colleague for his speech. We've heard from this government a few tautologies, Mr. Speaker. We've heard that a deal is a deal. They've invoked that in order to refuse to stand up to Saudi Arabia with respect to their record on human rights and proceed with a contract that would deliver arms to that country. We've also heard the law is the law is the law. This is a deal in law, Mr. Speaker. That's what this is. It's a deal that was made when Air Canada was privatized. It was a deal that was made with Canadian workers and aerospace workers. So here we are. We've got a deal. It's in the law. And we know that the law is the law is the law and a deal is a deal. Why is it that that's good enough for the government to go ahead and protect the interests of the Saudi government, but it's not good enough to stand up for the sanctity of the deal when it comes to protecting Canadian workers?
The honourable member for Caribou Prince George.
Well, Mr. Speaker, I I want to thank our honourable colleague through you, Mr. Speaker, for that question. I'm not quite sure if there was a question in that, but you know, Mr. Speaker, the Bill C-10 or the Air Canada Participation Act was done in 1988, and as we've talked about, times change, things change. We have to be able to compete in a global, ever-changing global environment. But Mr. Speaker, fundamentally, that bill or that act was put in place to protect Canadian jobs, protect the government's investment. And as we move forward, I think it would be wiser for this government to maybe take a step back, not a rush to pass this legislation, and if they really were serious about creating jobs and creating a great environment for trade and tourism, they might consider some of the thoughts and some of the suggestions that members on this side have put forth in the debate today. Again, if we are to remain competitive, we need to not just look at one carrier. We need to look at the industry as a whole to make Canada a sound trading partner and competitive on the global stage.
The honourable member for Caribou Prince George. Questions and comments. Questions et commentaires. The honourable member for Yellowhead.
Thank you, Madam Speaker, and for the member for Prince George, Caribou. I understand your background is in aviation, and you talked about the downloading of the costs to the airlines, to the public. And reminds me of security at most of our airports. The security costs are downloaded directly to the airlines and to the public that are traveling. Do you think that the whole regulation system needs to be looked at and changed? Because the global security at our airports, I feel, should be a national requirement by government and not put that cost onto the general public or to the airlines that are using those airports.
The honourable member for Caribou Prince George.
Thank you, Mr. Speaker. Well, let's a point of clarification. Canadian Air Transport Security Association actually is in charge of Canada's security system at our airports from coast to coast to coast. However, it does come down to implementing the costs on that does always come down to the user pay. The end user has to pay for that. We live in an ever-changing global environment that places challenges on all of our security systems and our transportation systems. We want to make sure that the safe travel of whether it's our goods or our people is always paramount. And our Canadian airports are second to none in this. But again, if we are to be competitive, if we want to stop carriers in countries overflying Canada, if we want to remain competitive on the global stage, if we want to take advantage of our strategic geographic position, we need to look at the aviation, our transportation sector as a whole, our tourism. We need to align all of that with our trade, our tourism, and our air policy environment. And if we do that, our carriers, our airports, our trade, our tourism will be healthy.
Questions and comments. Questions et commentaires. The honourable member for Nanaimo, Ladysmith.
Thank you, Madam Speaker. So this is an interesting rolling of history here. We had just a few years ago the Liberal government of the day, the third party at the time being extremely critical of the Conservative government for not upholding the legislation, which was a term of privatization of taxpayer assets, commitment to protect Canadian jobs in place as a trade, as a term for that privatization. And the third party was at that time very critical of the Conservative government for not taking stronger action just a few years ago. So we now have legislation before the House that looks like a very clear reversal of that position, that we are seeing a very strong protection of the corporate interest and not seeing this proposed legislation standing up for local jobs that are guaranteed to to stay in Canada, good paying jobs, Canadian jobs. So through you, Madam Speaker, I'm curious what my Conservative colleague is feeling about this very turned around history on this story, and now that the narrative is quite turned around. Thank you.
The honourable member for Caribou Prince George.
Well, Mr. Speaker, that's an excellent question from our honourable colleague. I would have to say, Madam Speaker, is that the timing of this legislation is awfully suspect, as I mentioned in my speech. Only after Air Canada has announced that it will indeed purchase the C-Series aircraft from Bombardier. They've got a commitment of maybe up to 75. We've seen some lawsuits drop with Quebec and Manitoba. There seems to be, Madam Speaker, a rush to get this legislation in place, and perhaps maybe a loss of memory of their stance previously. But again, we've seen with this government loss of memory in recent months after October 19th and after their campaign, where they made a lot of promises, and there was everything, as one of our colleagues said, rainbows and unicorns, and now we see the loss of memory in their stance previously in the previous government, previous parliament, and so they're changing it. It's a rush to judgment, and I think it is merely looking after friends. Thanks.
Questions and comments, questions et commentaires. The honourable member from Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. My colleague from Elmwood, Transcona, earlier referred to Liberal tautologies. A deal is a deal. The law is the law. I thought maybe he should have added a proof is a proof is a proof. Because we clearly have proof here that there were clear rules in place, that those rules weren't followed, and now the government is trying to change the law to allow for not following of the law, not respecting taxpayers in this context. And I want to ask the member, we talked about the interests of corporations, the interests of workers, but there's a more fundamental issue here, and that's basic fairness. What message does this decision by the government send about fairness in the marketplace, about actually honoring the law, honoring your commitments?
The honourable member for Caribou Prince George.
Another great question, Madam Speaker. I think it speaks volumes, this government's ability to kind of maybe have blinders on when it comes to friends and things that they need to get past and want to rush through. You know, Mr. Speaker, Madam Speaker, sorry, government's role is to create the environment so that companies, whether private or other corporations, can succeed. And that means creating a healthy tax environment, a healthy and competitive environment so that industry can flourish, so that trade can flourish, so that we can move people and products to market easily. And government shouldn't be interfering in issues that will give one private sector company competitive advantage over another. Simply put, Madam Speaker, I think that this government should stick to its knitting, and if they really want to have real change, maybe take a look at the industry as a whole and maybe not a singular part of that industry or a singular competitor in that industry. And if they really want to do some good, let's take a look at the whole industry and they'll have some real impact.
Resuming debate, reprise de débat. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. I appreciate the opportunity to now give a speech on this debate, having participated throughout the day in questions and comments. And I just want to share that the reason I've been involved in the debate, the reason I'm giving this speech, is because this was actually an issue that a constituent brought to me at my office a number of months ago. This gentleman had been an Avios employee, was someone who had lost his job as a result of what are, in my view, Air Canada's ongoing efforts to shirk its obligations, its clear obligations under the Air Canada Participation Act. So it was a pleasure for me to chat with this gentleman. I always appreciate it when constituents come to my office to educate me about issues I may not know about, and then when I have the opportunity to then reflect their concerns, certainly concerns which I share in this case in the House. So that's the context I bring to this debate, and certainly it's telling that this was an issue that my constituent wanted us to be talking about. And yet it's very clear from the way that this debate has progressed back and forth that this is not an issue that the government wants to talk about. They want to bring forward this legislation, to be sure they want it to pass, but while we have active participation of other parties in this debate, this is clearly not something that the government is keen to talk about. And it's not surprising why. Because, Madam Speaker, here's the deal. The government came up with an arrangement which I think they feel satisfies everyone of importance. But this legislation ignores the one too often overlooked stakeholder group. And that group is the people. The ordinary working women and men of this country, taxpayers, people who can't afford to hire lobbyists, people who can't afford to go to $500 a plate fundraisers with ministers, people who go about their ordinary business and just hope and expect, perhaps against the odds, that the government will treat them fairly and honestly. This government has come up with a solution in this context which they believe, it seems, to quote the title of a recent book I read, which they seem to think satisfies everyone but the people. And as obscure as the Air Canada Participation Act may be to some Canadians who haven't interacted with it directly, I think this legislation is something that everyone should pay some degree of attention to, because it tells us a great deal about the way that this government does business. And to paraphrase Michael Corleone, Madam Speaker, if you want to do business with this government, then they will do business with you. I'd like to start then the substance of my remarks by reviewing the story of how we got to this sordid piece of legislation, and of who has already paid the price for the policy of the government, and of who will continue to pay the price as we go forward. So in 1988-89, through two separate offerings, Air Canada was privatized under, notably, a previous Conservative government that I think had the wisdom and foresight to see the value of proceeding in that direction. But I think most of us would accept now, in principle, the value of government stepping out of that, being directly involved in that kind of business activity. But certainly, in the point leading up to that privatization, the people of Canada had already been very involved in terms of putting money into the development and ongoing maintenance of what had then been a Crown corporation. Now, the mechanism of privatization is important here. The privatization of Air Canada was achieved through a share issue privatization, or SIP for short, and this is exactly what it sounds like. The government issued and sold shares in what had previously been a publicly owned company. Particularly in this case, and in some other cases in those years when the government initiated SIPs, certain provisos or restrictions were placed on the company being privatized. So Air Canada was subject to 4 conditions. It would be subject to the Official Languages Act. It would maintain its corporate headquarters in Montreal. 75% of its voting shares had to be held by Canadians, and it had to maintain operational and overhaul centers in Winnipeg, Montreal, and Mississauga. This was the law, but these were also conditions of the privatization. And this latter point, maintaining operational and overhaul centers in these 3 Canadian cities, is what this legislation seeks to remove. It seeks to no longer require that these jobs be kept in Canada. So we can be very clear that this legislation is not about creating jobs in Canada. It is about sending jobs out of Canada. There's no denying that. And certainly the government may point to other jobs being created in the aerospace sector, but it's very clear that the effect of this legislation is to allow, to facilitate these companies, this company sending jobs out of Canada. Now, as everyone knows, when you put conditions on the sale of anything, whatever that thing is, that is likely to have some impact on the price. Quoting from a 2012 U of C School of Public Policy paper on this privatization, quote, "Whether these provisions were in the interest of Canada or not, they probably reduced the initial share offering prices and government's sale proceeds. Because of these conditions, shareholders got the shares for less than they would have otherwise, and taxpayers got less money." To summarize, the Government of Canada sold Air Canada shares subject to certain conditions. Conditions which reduced the value of those shares, but which the government felt at the time was worth the cost. Recognizing that that was how the privatization happened in 1988-89, it would seem fairly obvious to me that as a matter of basic fairness to Canadian taxpayers, you would expect that any subsequent removal of those conditions should not come for free. The removal, in particular, of the conditions around the requirement that Air Canada keep certain jobs here in Canada, the removal of those conditions has, on the one hand, an economic cost for workers and taxpayers, but on the other hand, has an economic benefit for Air Canada. Effectively, the government is legislating windfall gains for Air Canada at the expense of workers and taxpayers, at the expense of ordinary people. So why is the government doing this? Why would they pass a law which absolves Air Canada of clearly stated commercial obligations, which are long-standing, and which allowed shareholders to acquire Air Canada at lower prices? Why would they do such a thing? It doesn't make sense until you realize the other interests that are at play. In fact, other interests that have been alluded to directly by government members. Not, again, the interests of workers and taxpayers, but the interests of another private company. Mr. Speaker, Air Canada has been sued by the governments of Quebec and Manitoba for their failure to live up to their obligations under the Air Canada Participation Act, the act which lays out the requirements that operational and overhaul centres be maintained in Winnipeg, Montreal, and Mississauga, as we've discussed. But these governments have now both suspended their litigation because of some notionally unrelated, but in fact very much related events. This appears, in fact, to be an elaborate scheme aimed at bailing out a different group of shareholders, that is, Bombardier shareholders. Now, Bombardier is a company that all of us want to see survive and do well, but certainly on this side of the House, we are more interested in protecting workers and taxpayers and not providing further windfall gains to company owners. The connection between windfall gains for Air Canada and windfall gains for Bombardier has, I think, already been well laid out by my colleague for Carleton Trail, Eagle Creek. It's been alluded to, but not clarified by members of the government. I think in any event, it's worth going over one more time. On February 17th of this year, Air Canada announced that it had started negotiations with Bombardier to purchase C-Series aircraft that they had not previously expressed interest in. And then on March 8th, the minister put this bill on notice. The governments of Quebec and Manitoba suspend their litigation, and it's hard to imagine them successfully resuming it if this legislation passes, the law under which they were suing, after all, having at that point been significantly altered. So Air Canada receives the free removal of conditions of their privatization at the same time as they are exploring previously unplanned purchases from Bombardier. Now, I think the government knows that a direct bailout of Bombardier is unlikely to be acceptable to the public at a time when Bombardier, like Air Canada, is outsourcing jobs. So there appears to exist, or there may exist, what you might call some form of an indirect bailout. The benefit of the removal of conditions flows from the government to Air Canada, and the benefit of a previously unplanned large purchase flows from Air Canada to Bombardier. This seems to be the crux of the matter. What we know is happening, and we're not clear as to why or how, but what we know is happening is that the benefit of the removal of conditions flows from the government to Air Canada, and the benefit of a previously unplanned large purchase flows from Air Canada to Bombardier. Now, something of this connection was made explicit by the Quebec government when they discontinued their litigation against Air Canada. Here's what they said in a press release. Subject to concluding final arrangements, the government of Quebec has agreed to discontinue the litigation related to Air Canada's obligations regarding the maintenance of an overhaul and operational centre, following Air Canada's agreement to collaborate with the province to establish a centre of excellence for C-Series. Note the careful language here. Collaborate to establish a centre of excellence for C-Series. Now, the government, again, they won't acknowledge this connection. I asked one of the members explicitly what the connection is. Why are they talking about these new investments in C-Series in a debate about the Air Canada Participation Act? There's a bit of wink, wink, nudge, nudge as they talk about these things together, but they won't actually acknowledge the connection. Well, it seems fairly clear what's going on given the timeline, given the benefits that are flowing to Air Canada from the government and then on from Air Canada to Bombardier. It seems, therefore, that Bombardier is getting help from this government after all. And now, all of a sudden, they're claiming that they don't need the help anymore. Here's a Financial Post story from March 23rd. It quoted a representative of Bombardier, and this story came out, by the way, the day before this act was proposed, but certainly after it had been put on notice. Here's what a representative of Bombardier said. Really, the federal funding would just be an extra endorsement for the program. That's really just an extra bonus that would be helpful, but it's very clearly not required. Now, we're talking about a $1 billion bailout. That's an extra bonus that I'm sure many of us could use as well. But this is quite a different tone than we heard from the same company a few months ago. And I wonder, Madam Speaker, is it really that they didn't need the money all along? Or is it simply that by March 23rd it was clear that the same benefit would be received, just perhaps by a different means? And notably, without the pesky conditions that might require real and substantial reform, without those trappings which might be associated with a more direct package of financial support. I actually worked for the Department of Industry during the tenure of the last government. And at the time, we were involved in bailing out a number of major auto companies. And I got to know some of the members that are still in this place during those years. And I know that for those of us who are conservative-minded, who believe in free markets, it was a very difficult decision for the government to be involved in bailing out car companies. And many conservative-minded people may still not agree with that decision. But it's clear that there were some very particular conditions and circumstances operating at the time. And so at the time, in 2009, the government undertook a very carefully constructed bailout approach. It did a few important things, though. It required reforms that ensured viability. And it involved the best possible effort of the government to ensure that there would be some kind of meaningful return on the investments that were made. Part of the deal was a loan, part of the deal involved the acquisition of shares. For those who believed the bailout at that time was necessary, it was at least transparent. It was done in the least bad way because it involved reform, and it was set up in a way to try and ensure that there wouldn't be a need for bailout in the future, that these companies would go on to be successful and continue to create jobs in Canada. And that, in this case, not to underscore the challenge of the decision at the time, not to undermine that, but it's clear that to some extent those companies have, to some extent it worked. Those companies have continued to exist. But the novel approach we see here is what appears to be some form of an indirect bailout, benefits flowing to Bombardier via Air Canada in a way that's not transparent, that's not accountable, and that involves no reform. And to a company, Bombardier, that I should underline, by some estimates, has since 1961 received approaching $4 billion in various forms of government assistance. I would just say that if you want to be involved in supporting a private company, you should at minimum try to ensure that it is the last time you have to do it, that there are reforms in place that ensure that you're not going to be providing bailouts on and on and on. And that's the problem here, is that there is this murkiness, there is this allusion to things that may be happening, but we don't actually know how they happened or why they happened. Now, I want to comment directly on some of the comments made by some of the other members and offer some refutation. Now, we hear a lot of interesting language by the other members who have spoken, and not that many members of the government have spoken to this. They talk about modernizing the Act. I think one member told us it's 2016, as if stating the current date is an argument for so many different things, not only just the policy of gender parity in cabinet, but also now this. All you have to do is state the current year. Say you're modernizing, you're moving forward. But I don't think that selling out Canadian workers, selling out Canadian taxpayers is modernization at all. I think, in fact, it takes us backwards.
They've said that this is updating the Act. Well, again, updating is not what this is. This is a substantive policy choice the government has made, which betrays taxpayers and betrays workers. Now, the government has, in certain speeches, made the point that there are costs that are associated with these conditions that Air Canada has to bear, but that other private companies don't. But the reality is that those conditions were associated with those shares being sold at a lower price, as I mentioned already. But let's not forget that Air Canada has benefits as well that other companies don't have. Canada regulates its airline industry significantly in a way that I think very clearly has been designed to protect the economic interests of Canadian carriers. And we can debate back and forth the value of those various individual policies. But there's no doubt that those policies in fact exist, that Air Canada has gotten certain advantages from government regulation as well. So that's something that we need to recognize and take into consideration. But in any event, this is simply a matter of fairness. Those were conditions that were imposed on Air Canada as a condition of its sale, and those who bought those shares knew exactly what was happening. Now, we do hear this argument about the importance of Air Canada's viability. And, Madam Speaker, there's no disputing that. All of us want to see Air Canada, as well as Bombardier, be strong, create jobs here in Canada, and provide good service to Canadians and lots of choice in the marketplace as well. But there are many different things that could be done to improve Air Canada's viability. Some of my colleagues have mentioned these already, but increasing the foreign ownership limit of Canadian-based airlines to 49% would be one option. Allowing more money to come into Canada instead of jobs to go out of Canada. That would be a better way to improve competitiveness. Things like continuing to streamline immigrations and customs processes, establishing a set of principles to guide airports when determining fees. These kinds of reforms would help Air Canada's competitiveness, would help the competitiveness of Canadian airlines in general. I did want to just say on the point about these being costs that other airlines don't have. Of course, that's true of the Official Languages Act as well, and I don't see a movement by this government to remove the application of that act as well. So even still, there are still going to be conditions on Air Canada which don't exist on other airlines, and I think they would understand why. So to summarize, conditions are being lifted at a cost and no benefit to taxpayer. Bombardier is getting the business from Air Canada, and because there are no conditions, both companies are able to continue to send jobs out of this country. Air Canada gets something for nothing, Bombardier gets something for nothing, and this government thinks they're filing away a potential political headache. But the real question is who gets left behind in all this? Well, it's the workers and the taxpayers. It's ordinary folks. Those are the people that are getting left behind because the Liberals are sacrificing the principles of real economics and the principles of real free market economics for their own particular brand of crony capitalism. Those of us on this side of the House believe deeply in the market mechanism, but the necessary condition is fairness. And this bill isn't fair. It's not fair to workers who will lose their jobs. It's not fair to taxpayers who could have gotten more for Air Canada's privatization. It's good for elites, but it's not fair for the people, and that's why we're opposed.
Questions and comments, questions et commentaires. The honourable member from Skeena-Balti Valley.
Thank you, Madam Chair. Thank you to my friend down the way for his speech. And while we have some common ground in disliking this bill, we come at it from different angles. I'm not sure that increasing foreign ownership and control of the airline industry in Canada is actually the silver bullet that maybe some Conservatives hope for, because if what we're hoping for is to have a strong aviation sector in this country, perhaps we need a strategy, as radical as that notion sounds, an actual strategy to build up the jobs and build up the workforce here in this country. And one of the concerns I have with these centers of excellence, which are being dangled out by the government, one wonders what we're training these workers for if at the same time the same government is moving those same jobs overseas. I don't know if they're teaching Spanish at these schools, but it may be a thought from this government. So the sequence of events is this, Madam Speaker, and this is my question for my friend, that we had many criticisms, and we were joined by Liberals in these criticisms at the time, of the Conservative government not enforcing the Act, not enforcing the law that Air Canada must operate under. And I can remember the member from Papineau standing out in front of the House of Commons and in Montreal and in Mississauga and in Winnipeg and saying, if you vote Liberal, they'll uphold the law. There was a little asterisk on that. He didn't mention that in the meantime, when forming government, they would change the law so there'd be nothing to uphold. So, in fact, he wasn't technically lying, Madam Speaker. He wasn't technically lying when he said it would be sunny ways. He just didn't mention the storm clouds that were on the horizon, that the sun was out for a moment, but when push came to shove and Air Canada wanted something that Air Canada has long wanted, and Bombardier wanted something else, the quid pro quo comes up. And now is the so-called seriousness of governing, where the 2,600 families and the jobs that they rely on in Mississauga, in Winnipeg, and in Quebec around Montreal are now to be sacrificed for this grand deal. So my question is this. If the Conservatives were unwilling to enforce the law and the Liberals were simply willing to kill the act, is it not now at least time for this country to face up to reality and to be truly competitive, actually create the national aviation strategy that workers and Canadians have been calling for so long, rather than these cynical shell games that we see from across the way? Thank you.
Honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. And there were many points that the member made, some of which I agree with, some of which I don't. He's quite correct to point out that on this and many other areas, we see the government not following through with commitments they made, not following through with commitments they made to various groups. And we've spoken about the increase in the budget deficit, about the increase in taxes for small business. I could go on and on. Now, a bit of a disagreement here about the issue of foreign ownership, but I'll just say this. If we have to choose between sending jobs out of the country or bringing dollars into the country, I say we're better off bringing dollars into the country than sending jobs out of the country. If we have to choose between one of those two alternatives to try and make Air Canada more competitiveness, I'd rather be bringing business and opportunity and jobs and investment here to Canada. That would be our approach on this side of the House. And certainly one of the other differences between us and the Members' Party is we do believe in the value of the market mechanism. We believe in the value of free markets, generally speaking. But for that to work, there has to be basic conditions of fairness. And there isn't, that basic test of fairness isn't met by this bill, because it's arbitrarily changing the rules midstream to legislate windfall gains for Air Canada at the expense of workers, at the expense of taxpayers. So that's the kind of approach that we need. And the member talked about an aviation strategy. I mean, I think what's important is the action here. And you can package it up and call it whatever you like. But certainly the policies that we advocate, which were competitive tax rates for the aerospace sector as well as for all businesses, that allow people to invest in Canada and allow people to create jobs in Canada, those were the kinds of approaches that were good for the aerospace sector, but also for all business in Canada. So that's what we emphasize, and it's unfortunate to see the government moving away from that suite of policies.
Questions and comments? Questions et commentaires? The honourable member for Skeena-Baltic Valley.
Thank you very much, Madam Speaker. A certain question I have that underlies this debate that is yet to be made clear by the Liberal Party itself is that they seem to have established this quid pro quo with Bombardier and Air Canada, and we're wondering who actually benefits from this. So for the cost of these 45 planes, which everybody familiar with the file agrees with are excellent jets that fit the needs of Air Canada, but one has to wonder why the Liberals would so strongly backtrack on a commitment to all those workers, all those maintenance jobs, which, as he rightly says, and many speakers have pointed out, are going to be moved overseas. Because all this bill deals with is just that aspect, is getting Air Canada off the hook for the commitments that they made in law. They're changing the law to make it fit the reality that the Liberals now want because Air Canada asked for it. But the quid pro quo with Bombardier, that perhaps the Quebec government were unsure, is to say that these 45 planes are somehow going to compensate for this, and that there's these now centers of excellence that if you thought were important, would also be enshrined in law. That if the Liberals were absolutely committed to these and could name the number of jobs and how long they'd last for and what they were for, would certainly merit a pen being put to paper, and somewhere in C10, of which there are many pages, they would find the heart and the gumption to actually commit to Canadians that aspect as well. But instead, those are promises off. And we heard that the Liberal member from Winnipeg North long rallied against this, and we all know he can speak. and talk and talk and talk. And he chose many of those moments when he rose in this place, when in opposition, to lay down petitions from his constituents, because he said, I'm doing the work of an MP. I'm doing the good work of a member of parliament, and he was right, because his constituents were worried that good-paying jobs were about to be shipped overseas because the government was not enforcing the law, a Conservative government at the time. So what was the member from Winnipeg North's solution to this, now that he's in government? Was to change the law so that government wouldn't have to abide by that nasty little thing called the rule of law, and Air Canada could do as they will. The question is this somehow a quid pro quo that works out for anyone, either the taxpayer or the 2,600 workers that are losing their jobs? And not just those workers, Madam Speaker, as you well know, in your constituency and all of our constituencies, good-paying jobs like this don't just affect the person when they lose that job, but their entire family and the spin-off industries that surround that job. Is this somehow a good cost-benefit for Canada? And is this somehow not just the most cynical form of politics that we've come too accustomed to from this party?
The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. The member asked at the beginning who benefits from this legislation. And I suppose an important connected question to that, given who benefits, who is it that this government is listening to? Discussions with whom are informing their policy choices. And it's very clear who benefits from this legislation and who doesn't. This legislation provides windfall gains for Air Canada owners, and perhaps, depending on the quid pro quo involved, to Bombardier owners, at the expense of workers and at the expense of taxpayers. Madam Speaker, I will say I do appreciate questions from the honourable member, but I think I've been pretty tough on the government, so I would appreciate to hear their response to this. Madam Speaker, what do they have to say for themselves? Do they have questions about the things that we've said? I'd like to hear from the government on this, Madam Speaker. Who do they think benefits, and why are they bringing forward this legislation? Let's hear what they have to say.
Questions and comments, questions et commentaires. The honourable member for London West.
Thank you, Madam Speaker, and thank you to the honourable member for his comments. I want to reiterate that Air Canada will continue to be expected to carry out maintenance activities in Manitoba, Ontario, and Quebec. The amendments of this Act recognize that some of Air Canada's aircraft maintenance may take place outside of the limits of those cities in the surrounding provinces and in other provinces. Notably, and we've mentioned this before, the Montreal urban community only covered part of Greater Montreal and no longer exists as a jurisdiction. Also, Air Canada's maintenance activities expand beyond the strict confines of those cities. For example, the carrier has extensive activity throughout the Greater Toronto area beyond Mississauga. So it's obvious that that this Act will change only the part that is necessary, that we will continue to expect that they carry out maintenance activities in the three provinces.
The honourable member for Sherwood Park, Fort Saskatchewan, a very brief answer, please.
Madam Speaker, really, it's unfortunate, bordering on shameful, that the member would present this legislation in this way, because, frankly, the legislation provides no assurance whatsoever that a serious number of jobs will remain in Canada. It uses effective weasel language that gives Air Canada all the flexibility it needs to do exactly what it wants to do. And may I say, Madam Speaker, that if the government actually respected the principle of fairness, they wouldn't be amending this legislation at all. These were clear obligations at the time of privatization. These were things that Air Canada agreed to, that informed the share price, and that's why the only fair thing to do is to honour workers and taxpayers, not their crony capitalist friends, and defeat this legislation.
Reprise de débat, resuming debate. The honourable member for Cowichan, Malahat, Langford.
Thank you very much, Madam Speaker. It's an honour to rise in the House today to start debating Bill C-10, or at least have my turn on it. Now, I know coming from the riding of Cowichan, Malahat, Langford, all the way out on the west coast on beautiful Vancouver Island, I don't really have much of a relationship with aircraft maintenance jobs. But, you know, I guess it was from my time spent as a constituency assistant for 7 years that I really developed a keen passion for the plight of working men and working women. I did the casework in former Member of Parliament for Nanaimo Cowichan, Jean Crowder. I did the casework in her office for 7 years. And during the course of that 7 years, I had the honor of meeting with many working men and women who were going through tough times. And I guess coming to this honourable House as a Member of Parliament, I have always identified with them. I thought my job was to come here to try and pass good laws, to implement good policy, and to make sure that the government was actually on the side of people who give value to companies. Because when we're talking about corporations, we often talk about the president, the board of directors, or the CEO. But the people who truly give value to a company are the men and women who go out every single day and do their job. And that's what this bill is about. This is what we are, in a sense, talking about. I want to give particular thanks to my colleagues, particularly from Elmwood Transcona and Rosemont La Petite Patrie. I listened to both of their speeches today, and I think they gave both very passionate speeches on what's really at stake with this bill. I've also had the time, both during Friday's debate and during this particularly long Monday session, to listen to a few comments from Liberal members of Parliament. We have heard notably from the Parliamentary Secretary to the Minister of Transport, who has stated that in today's world it is common for global air carriers to outsource aircraft maintenance. Those comments tell me that there's not even a pretense anymore from the Liberals for saving jobs. They just admit it. You know, sorry folks, it's a tough world out there. If Air Canada decides it's going to have a cheaper job elsewhere, well, sorry, there it goes. I also heard an interesting comment from the Member of Parliament from Laurentide Labelle. He said this bill is about supporting Canadian jobs, Canadian ownership, Canadian principles, and Canadian competitiveness. It is a Canadian bill for a Canadian company. Well, we know he's very patriotic in those comments. I don't know if he's actually reading the same bill, because the fine print is not really doing well for Canadian workers. And I would say that that's not a very strong Canadian value when we're actually legalizing outsourcing, because that's precisely what this bill is doing. And of course, our favorite member of Parliament on this side of the House, the honourable member from Winnipeg North, we do like to quote him a lot because he has been an amazing standard bearer for his riding in years past, but not now. Your principles seem to change when you occupy that side of the House, Madam Speaker, and I think his comments really do bring that to light. He has said in the past that when talking about previous bills that, talking about this bill, he said that this would continue to reinforce the government's expectation that Air Canada would undertake aircraft maintenance in Quebec, Manitoba, and Ontario. Well, a government's expectation is different from an actual piece of law that stipulates it has to be done. You know, I could expect Air Canada to give me free tickets for the rest of my life. They're not going to do it. And the same with this particular situation that we've got with aircraft maintenance. We are giving away the legal framework that stipulates aircraft maintenance jobs must be done in Canada. And if Air Canada decides at some future point to ship those jobs overseas, well, we simply do not have any recourse. Now, I mentioned previously, Madam Speaker, that I had spent 7 years working as a constituency assistant. I've always had a great appreciation for law, particularly federal law. You know, it's the way it's worded. Sometimes it can be very direct. Sometimes it can leave nothing to the imagination. Other times it's very much open for interpretation. And, you know, we have our job as legislators here to create the law, and the courts interpret it. I have heard from Liberal members of Parliament say that, well, you know, the jobs will, in a sense, be protected because we have this deal with Bombardier, and so by the very fact of extending jobs with the deal with Bombardier, it doesn't really, the subtext there is that these maintenance jobs don't matter because it's sort of a, you know, comparing apples with oranges, take away with one hand, but we're giving with another. I think for the benefit of all honourable members in this House, it's important to actually read the main clause, and that states that the corporation may, while not eliminating those activities in any of those provinces, change the type or volume or any or all of those activities in each of those provinces, as well as the level of employment in any or all of those activities. So, yes, Air Canada is not allowed to eliminate jobs in those 3 provinces. It could maintain 1 job there and still satisfy this act. That's basically what the wording, that's how I read this bill. I hope Liberal members of Parliament are reading the same bill, because when Air Canada is given the freedom to change the type, volume, or level of employment, it means you can go from those well-paying aircraft maintenance jobs to someone who maybe is earning only $15 an hour, which would be nice if they instituted a federal minimum wage of $15 an hour, but unfortunately we're probably going to be looking at something in the neighborhood of 12. Those good paying jobs, those jobs that pay $60,000 a year, those are going to be shipped overseas. It's only a matter of time. We have seen this story play out many a time. There are many examples of Liberals saying one thing and then doing another, and that's an unfortunate statistic that we've had to deal with. The current Prime Minister, when he was just the Member of Parliament for the riding of Papineau, he stood with Avios employees, and he said that the law is very clear. Air Canada has to maintain the maintenance in those cities. The fact that the government isn't enforcing that law is something that we've drawn attention to. Now that he's the Prime Minister, the Member of Parliament from Papineau is singing from a different songbook. He has forgotten the fact that he used to stand in solidarity with workers and proclaim that we, the Liberal Party, are here for your jobs. We will always stand by you. But now we see that he is taking the side of Air Canada. He has forgotten his solemn promise to those workers. And I, for one, certainly hope that people will remember that as we continue on through the years. And when we one day reach the year 2019, I know we in the NDP will certainly be reminding people of that the progressive paint job that the Liberals have applied to themselves is just that. They have become something other than they promised.
Hear, hear.
When I look at the particular reasons why the NDP is supporting this bill, opposing this bill, what we want to see is we oppose this bill because we want to see Air Canada basically maintain jobs here. We oppose the bill because Air Canada is going to basically outsource maintenance jobs. The bill legalizes layoffs. And Air Canada has basically been seeking carte blanche from the government. And if this bill passes, if Bill C-10 receives royal assent, it certainly will have that. We want to keep those good-paying jobs. I mentioned earlier that aviation maintenance engineer jobs start at around $60,000 in salary, and they can go up to $90,000. That, in my books, is a very good paying job. I used to earn less than that as a constituency assistant, and I've helped many people who have raised good families on that. They've managed to keep their payments at bay, but if we get rid of those jobs, there's going to be thousands of people who lose it, who will be unable to pay the bills, and conversely, the government is going to lose an important tax base. It ultimately, once you start losing those jobs, the spin-off effects start compounding. You have people who will have to require more social assistance, and so on and so forth. Now, the other thing I've been most interested in during the course of this debate, of course, has been the deal that we have seen between the federal government. It's basically 4 players here. We've got Bombardier, Air Canada, the federal government, and the Quebec government. And we know that the deal that was announced in February and the subsequent tabling of this legislation, it is a little bit strange, the timing of it all. The Member of Parliament earlier today from Calgary Nose Hill was, she used an interesting phrase. She said, this bill, it basically does everything. She had to give compliment to the Liberals because this bill did everything about Bombardier without even mentioning their name. And I thought that was a great phrase to use. This bill, she said, should be called the quid pro quo bill. And it's easy to see why. I wish that this House and all honourable members could be privy to the conversations that have gone on between the Minister of Transport, the CEO of Air Canada, the upper echelons of the Quebec government and Bombardier. We would, I think, find an interesting link where, on one hand, the Air Canada has promised that we will get these Bombardier aircraft, we will do a 20-year maintenance contract in Canada, and on the other hand, the deal that we get out of you from the Liberal federal government is that you change this act so that we are free to ship maintenance jobs overseas. It's pretty easy to connect the dots. It's there right in front of us, and I think that's been identified very clearly by many MPs in this House. You know, Air Canada, I have flown it a lot. It is our national air carrier, and I have heard lots of talk from Liberal members of Parliament saying that, you know, in a competitive world, Air Canada needs to be able to compete. It needs to have all of the tools at its disposal that other air carriers don't. I think one Liberal MP even referred to this act as a set of handcuffs. Well, I really do shake my head at some of the terminology being used by the government side of the House, Madam Speaker. When we refer to guaranteeing good paying jobs in Canada as a set of handcuffs, well, you might have some explaining to your constituents when they hear about that term, because I would have thought that, you know, guaranteeing good jobs in Canada would be actually something that we were sent here to do. That's probably one of the most noble and honorable things that we can do as members of Parliament. Now, Air Canada, I was mentioning, is a unique company because of the privatization it went through in 1988 and 1989. And I was quite young at the time. I was about 9 or 10 years old, so I'm not really going on memory, but the fact of the matter is that Air Canada inherited a sizable chunk of assets from the federal government. Those assets were paid for by taxpayers. And yes, I do acknowledge that times have changed since that time. But the fact of the matter is that Air Canada got a start as a private company with a large number of assets that any other aviation company had to build up from scratch. It got a very good head start in the game. And I think the government of the day decided to put this act in place, the Air Canada Public Participation Act. They decided to put this particular clause because I think we have seen time and time again where governments, you know, negotiate deals with companies and say, look, if you can promise us that you will keep jobs in this region of Canada, we will do something for you. We will give you a slight tax break, an incentive to, you know, offset your capital costs and so on. But none of those agreements were enforced by law. They were they're basically done on a handshake. You know, we are getting your word that you are going to honor this commitment. I think the government of the day felt it was necessary to put this agreement in law because so many of those agreements have been broken. There is a huge culture of bad faith where companies have promised one thing only a year later to do the exact opposite. And the fact that this was enshrined in law gave those workers and the government of the day the peace of mind that we would have well-paying jobs in 3 major centers. We would have people who could raise families on those incomes, who could come through and be a, you know, let's face it, a very good source of revenue for the government, because ultimately a government's finances depend on a healthy tax base. It can be no other way. We need those good paying jobs to keep our economy going, and that's one way a government keeps on going. Now, I realize that times have changed and that the aviation world it's quite different. It's a very competitive world out there. There's a lot of unknown factors, but I think it's quite disingenuous to pin all of the troubles that Air Canada is facing these days on maintenance workers in 3 centres in Canada. I think that should be a source of strength for the company and not something that we're identifying as a weakness, because in a sense, all of the Liberal arguments I've heard on this bill, they amount to, I would say, a vote of non-confidence in our workers. They are saying, well, you know, Air Canada is shackled. They're handcuffed to these workers, and we have to give them the freedom to take their job overseas, or the company is going to fold. That is absolute. It's just nonsensical. Air Canada is not going anywhere. It's our national air carrier. Everyone I know in this house flies Air Canada pretty much, but it's got so many guaranteed landing spots in so many airports. It has a virtual monopoly on prime landing spots in all of the major airports in Canada. It's not going anywhere. So to pin all of its woes on maintenance workers in these three centres it does not absolutely make sense. And I challenge the government to actually bring forth some arguments that do, but I don't think we will. The other thing I want to cover, Madam Speaker, is the concept of due process. We know right now that workers from Avios, the union that represents them, it is going through a court battle right now under the terms of this act. And we know that the Supreme Court is probably going to hear those arguments later this year, probably June. But the major trouble that union is going to face is that if this government changes this law, if we get it to royal assent before that court case, the legal case for the union is going to be gone. The law will have been changed. And I think that, due process is about making sure the state respects all legal rights that are owed to a person. And yes, it's well within this legislature's body to change the law. I'm not disputing that. But I think it's an action that's being done in incredibly bad faith to go and reverse the law after a union has been basically fighting a court battle since 2012. They've gone through the local courts to the Superior Court, and now the end is in sight with the Supreme Court. And it's like getting a sprained ankle right when you can see the finish line, except the person that gave you the sprained ankle is a government that's supposed to be on your side. That's what's happening here, Madam Speaker. And so I just think that's incredibly bad form, not respecting the due process of that court system, of changing the law before we have a chance to get a ruling. And by the way, all the courts have upheld the union's point of view. The law was broken. Exactly. It was broken. Right. So, as I wrap up, Madam Speaker, I guess I would like to take a few examples from my home turf. And I'm so pleased to be sitting in the House today with my incredible Vancouver Island crew, the Honourable Member from Nanaimo, Ladysmith, Courtney Alberti, and North Island Powell River. We collectively, as Vancouver Island MPs, we have seen what's happened when good jobs leave our communities. Right now, we're having a lot of fish processing plants that are closed down, and those activities are now taking place overseas in China, in Asia, and so on. The other big one is the export of raw logs. Every single one of us here from coastal British Columbia is very much familiar with the loss of good, well-paying manufacturing jobs. And you know why those good-paying manufacturing jobs have gone? Is because we have not had a provincial government or a federal government that was willing to stand up for good manufacturing jobs. Instead, we are allowing raw logs to be shipped out of this country. And it's just another pattern. It's another pattern that we see time and time again. I just wish we would see a government come to light that would be saying, you know what, we're going to stand on the side of the workers this time. We're not just going to use them as a backdrop for our election. We're actually going to stand and do something concrete in this noble House for them. So, Madam Speaker, I think my time is coming to an end, but I think I've made my points really clear. We in the NDP absolutely and fundamentally oppose this piece of legislation, and I hope that some Liberal members of Parliament will develop a conscience and vote with us against it. Thank you.
Stand up for Canadians.
Questions and comments, questions et commentaires. The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. And the member is quite correct that the law was clear, the law was broken, workers were suing Air Canada in court, had won at a number of levels, and now the law is being changed. And of course, as Conservatives, we have some significant philosophical disagreements with the NDP, but as people who believe in the importance of the market mechanism, of the value of free markets to generate wealth and growth and opportunity, we understand that that has to be underlined by a basic system of fairness. And the NDP don't always agree with us about the value of that market mechanism, but the government clearly has no commitment to the principles of fairness which are supposed to underline that system. So I wonder if the member can just comment on that, and hopefully we'll get some questions from the government again, because the government has been very silent throughout this afternoon of important debate, and there's no doubt that they don't want to be talking about this important issue. But I wonder if the member can just reflect on that, the total lack of fairness in this bill that we're seeing.
The honourable member for Cowichan Langford.
Thank you, Madam Speaker. Yes, I agree with my honourable colleague across the way that the process has not been honoured, and I don't think that some of the major players who've been fighting for those good jobs are being honoured. I mean, the 2,600 people from Avios, their union is still fighting that battle from 2012. That was 4 years ago. And so what we're basically saying, what the Liberals are saying, well, that 4 years of challenging, of trying to get those jobs back, it's going to be nothing with this bill. Where I would disagree with my honourable friend is on the notion of the free market. Markets are not free. They operate under heavily regulated laws put in place. They have an illusion of being free, but if you saw all of the different government laws and regulations that a market actually operates by, and the worst thing about it is that it rewards some people more than others. So in the same manner, I think that in order to sort of counterbalance what goes on with the market, governments do sometimes have to step in and level the playing field. And sometimes governments have to be a champion for good-paying jobs. And that's why we on this corner of the House are standing so proudly for that point.
Questions and comments, questions et commentaires. The honourable member for, just a second here. The honourable member for North Island Powell River. It's going to have to be a brief question because 6:30 is fast approaching.
Thank you so much,
Thank
Madam
you.
Speaker. I just wanted to thank my honourable colleague for that most amazing speech and recognize that this amendment would legalize layoffs, which was previously illegal. And what it's going to do is increase the uncertainty for people who rely on those jobs to take care of their families. Right now, in my riding, the community of Port Alice is in a situation where they're waiting to see what's going to happen with their good-paying jobs from the local mill that's been shut down. And I know that I'm getting a lot of emails and calls with people who are frantic. So I'm just in solidarity with these amazing people who have worked so hard. They're going to be losing their jobs. How does that relate to the people that will be talking to their MPs who are not standing up for them today?
Okay, a very brief answer from the member for Cowichan Malahat Langford, and you'll be able to carry that time to another day for debate.
Thank you, Madam Speaker, and I thank my colleague for the question. Yes, like she's referring to the actual wording. Like we have heard members of Parliament from the Liberal benches say that, well, you know, we are expanding it to make sure that greater amounts of Ontario, Quebec, and Manitoba are going to have these jobs. But the actual clause that's very important is Section 4. And when you're talking about giving Air Canada the freedom to change the type, volume, and level of employment, that's very clear to me. You're giving the corporation carte blanche to ship those jobs overseas if it makes sense for their corporate bottom line. Thank you, Madam Speaker.
Thank you very much, and the member will have 6 minutes approximately the next time that this issue is debated. In accordance with in accordance with Standing Order 38, motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. L'honorable député de Belleuil-Chamblay.
The honourable member for Belleuil-Chamblay. Thank you, Madam Speaker. I'm happy to have this opportunity to follow up on a question I put to the Minister of Transport a few weeks back, and I'm happy, in fact, to discuss the issue here in the House because it's an issue that my community has been very concerned about for a long time now. The most deadly accident in Canada's history three years before Confederation, it occurred then, but it remains the most deadly rail accident in Canada's history, and it took place between Belleuil in my riding, and some 90 people died in it. In Mont-Saint-Hilaire, in 1990, there was another accident that oddly resembled the tragedy of Lake Megantic. A train that was carrying fuel went through the region. There was a problem on the rail line. There was an explosion. Chemical products were released. And the firefighters weren't able to deal with it, so there were all kinds of problems. So it was a very worrisome situation. In 1990, Madam Speaker, that's not all that long ago. So when the Lake Megantic tragedy occurred, the people in my riding, and especially the people in Mont-Saint-Hilaire, were very concerned. Like at the Richelieu River, the railway goes right through the heart of my riding. My former area also included Saint-Basile-le-Grand. Mont-Saint-Hilaire is now in it, Belleuil, other municipalities that are affected by this very important issue. So that's why I put the question to the minister. The minister said that rail safety is a priority, but why hasn't he taken action yet? Madam Speaker, I know what answer I'm going to get today, this evening in this House. We did read the budget. We see a lot of rhetoric. They talk about the importance of enhancing inspections, but unfortunately the resources aren't keeping pace. And so what we've seen and heard, in fact, from meetings at the Transport Committee, that there were cuts and there are 21% fewer resources available for rail safety inspections, less than in the past. So that's very worrisome, Madam Speaker. The member for Edmonton Strathcona, who is our transport critic, and I brought the issue back last week, put it to the minister, but once again, the minister wasn't in a position to provide us with an answer, and he simply settled it by saying, well, we're going to talk to the municipalities. But it's an urgent situation. The election campaign was 6 months ago. The consultations have been ongoing, but now we need some concrete action here. The municipalities have spoken out. We know what they need. They need information before, not after the dangerous goods are going through their areas. We need to ensure that prevention measures can be put in place, and not because we don't simply want to react. The outdated cars, the .111s, need to be withdrawn. There need to be more human resources to do the inspections because there are, in fact, too many trains carrying dangerous goods going through these areas. I reassure people in Belleuil and Chambly that I will continue to rise in this House to defend them, to defend their concerns on this important issue. Thank you, Madam Speaker.
The Honourable Parliamentary Secretary to the Minister of Transport.
Thank you very much, Madam Speaker, and thank you to the Member of Parliament for Belleuil-Chambly for raising this question on a subject which is a priority for both the Minister of Transport and the Government of Canada. This government is committed to continuously improving railway safety for Canadians, and I would like to assure the member that the Department of Transport Canada has a rigorous and robust rail safety regulatory framework and oversight program in place. The oversight activities include monitoring the safety of railway companies' operations, as well as compliance with rules, regulations, and standards through audits and inspections, and taking appropriate enforcement action as required. The government takes the safety and security of the railway and transportation of dangerous goods very seriously and is committed to ensuring that the appropriate levels of safety are maintained. Since the tragic accident in Lac Mégantic, Transport Canada has put in place a significant number of measures to improve railway safety, including requirements for securement of unattended railway equipment, improved tank car standards, emergency response plans, and a new liability and compensation regime for federally regulated railways. Most recently, we introduced the rule respecting key trains and key routes governing the transportation of dangerous goods by rail in Canada. The objective of this rule is to further strengthen railway safety, and the requirements in the rule seek to improve safety and reduce the risks of transporting dangerous goods by rail. In addition to imposing speed limitations, the rule puts emphasis on track inspection and maintenance, risk assessments and mitigation, and allows for the incorporation of safety and security concerns of municipalities and other levels of local government in risk assessments to be conducted by railway companies. Our government makes it a priority to be there for communities in both the short and long term when Canadians need us. The Minister of Transport announced the federal contribution to the Reconstruction Office in Lac-Mégantic on January 30th, 2016. This action reiterates our commitment to support the reconstruction and economic recovery of the city of Lac-Mégantic. Furthermore, the Minister will return to Lac-Mégantic next week to meet with citizens to hear their concerns and answer any questions they may have regarding rail safety in their municipality. The Minister and the government are and will continue to be there for the people of Lac-Mégantic. In addition, the city has mandated a firm to conduct a feasibility study on the bypass track. Approximately half of the cost of the study is financed by our government through Canada Economic Development for Quebec Region from its multi-million-dollar envelope for aiding Lac-Mégantic's economic and commercial recovery. The federal contribution is $441,000. While work has been done on the issue of rail safety and the transportation of dangerous goods, we need to do more. As mandated by the Prime Minister, the Minister of Transport will continue to examine further measures to enhance railway safety in Canada and continuously improve railway safety for all Canadians. Thank you very much, Madam Speaker.
L'honorable député de Belle.
The Honourable Member for Belleuil-Chambly. Well, thank you very much, Madam Speaker, and I'd like to thank my colleague for her answer. I appreciate the good intentions by the Parliamentary Secretary and the Minister. I'm sure that when the Minister visits the site, he's very sad to see what happened there. But despite all of these good intentions, some steps have been taken, but there is still an urgency. More action needs to be taken. When I go back into my riding in the evenings, on the weekends, and during the break weeks and talk to my constituents, we all realize the same thing. The trains are too long, they go too quickly, and there's always a danger associated with that. So at the end of the day, when we take a look at the municipalities and their needs, they're still not in a position to get the information they need within an appropriate time frame to know exactly what products are being carried through the territory across on the rails. This is very important for the firefighters in order to have a prevention plan in place. I thank my colleague opposite, and I thank my constituents. I will continue to take a stand on this important issue.
Secretary to the Minister of Transport.
Thank you, Madam Secretary. And our government is committed to continuously improving railway safety and the transportation of dangerous goods for Canadians, and has rigorous and robust rail safety and transportation of dangerous goods regulatory frameworks and oversight programs in place. Since the tragic accidents in Lac-Mégantic, Transport Canada has put in place a significant number of measures to improve railway safety. However, more needs to be done, and the government is well aware that the Canadian public continues to have concerns. That is why the Minister will be in Lac-Mégantic next week to meet with citizens to hear their concerns and answer any questions they may have regarding rail safety in their municipality. We will continue to examine further measures to enhance railway safety in Canada and act on the mandate that the Prime Minister has given to the Minister of Transport. Thank you very much.
The Honourable Member for Courtenay-Alberni.
Madam Speaker, I rise today to continue the debate about wireless rates in Canada and what this government plans to do to bring in more fairness. And I want to thank the Parliamentary Secretary for the Minister of Innovation, Science and Economic Development for joining me tonight. A recent poll by Angus Reid found that only 8% of Canadians believe that they're getting a good deal on the wireless service they pay for. We know that Canada has some of the highest wireless rates in the world, and a report out last year showed that they're still growing. When Canadians apply for jobs these days, they're expected to be reachable at all times. Telling a potential employer you don't have a cell phone will not help your chances. Wireless services are crucial to the economic lives of Canadians, and it is increasingly how we stay in touch as a country. But the price to be connected should not be prohibitive. In my riding, where the median income is well below the national average. Families are having a tough time making ends meet and making difficult decisions regularly, and the ever-increasing cost of wireless rates sure isn't helping. The median income in my riding is $26,000 a year. In Canada, it's $31,000 a year. Cell phones today, they're necessary for security. Again, I talked about employment, but it is something that is really a difficult cost for low-income earners. And again, coming from an area that is facing challenges, where families are making where it's getting harder and harder to make ends meet, we need to find ways to reduce costs to our constituents. Earlier this year, the big three telecoms, Bell, Rogers, and TELUS, all raised their prices for their wireless plans even higher. They blame the low dollar as the cause, but experts say that it is unlikely to be the real driving force behind these prices. Why are prices so high, Madam Speaker? Well, we have to ask what kind of competition exists in the industry. Are there any forces lowering telecom prices at all? And sadly, it's left to a New Democrat to explain the benefits of market competition to this Liberal government, as well as the previous Conservative government, who failed to take any real action after a decade in power. And 2 months ago, Canada's telecom regulator, the CRTC, they refused an appeal from a group of small internet service providers that would have allowed them to resell wireless services and add a healthy dollop to competition into the market. Bell, TELUS, and Rogers successfully argued against the small ISPs and their submission. They said that it was rigorous competition already existed. Let me tell you, as a former small business owner, there's a lot of frustration out there when the three largest companies in an industry simultaneously raise their prices and then tell Canadians that there's plenty of competition in the marketplace. The minister might point to the Wireless Code of Conduct, but if it was having the desired effect, we would see rates going down, which unfortunately they are not. And we're still seeing Canadians being surprised by phone bills with massive add-on charges. The question I posed to the Minister of Innovation in February was, what new actions is the government taking to stop the price gouging? And I'm asking today that same question. Since then, we've seen the government table its first budget, so you would think we would have more clarity on this question. Today, unfortunately, Madam Speaker, there is absolutely nothing in this budget addressing the incredibly high rates Canadians pay. The word wireless doesn't even appear in the budget, not even once. Will the minister, the parliamentary secretary for Innovation, Science and Economic Development, now take this opportunity to outline what action the government is taking to protect consumers, encourage true competition in the wireless market, and to stop price gouging?
The Honourable Parliamentary Secretary to the Minister of Innovation, Science and Economic Development.
Thank you very much, Madam Speaker. I'm very happy to respond to the comments from the Honourable Member for Courtenay-Alberni concerning our wireless policy. I have a lot of respect for the Honourable Member. We have offices that are basically next door. He's somebody who has a lot of experience, and I hope that I will give him a good answer to his question. Madam Speaker, the Government of Canada keeps a very close eye on the telecommunications sector. It's essential for innovation, and it's an important factor for the growth of our digital economy. The Minister of Innovation, Science and Economic Development has the mandate to support competition, choice, and availability of services, and to promote a climate that is favorable to investment in telecommunications services. As we announced in the 2016 budget, and I'm very happy that my friend made reference to that budget, our government will invest in 2016-2017, starting in that year, up to $500 million over 5 years in a new program to extend and improve internet services, broadband internet services, in rural and distant communities. By investing in the quality of our broadband network, we will promote access to a greater number of innovative services, which will continue to improve education, healthcare, productivity, and the quality of life in local communities. Many government sectors are contributing to the policies and the regulations for the wireless sector. The minister is also responsible for the Telecommunications Act, which establishes the overall orientation of our communications strategy, Madam Speaker. The minister is also responsible for policies governing the use of spectrum and wireless spectrum. The government will continue its efforts in the area of wireless spectrum to make additional spectrum available to wireless service providers to promote competition, investment, and innovation, which is in the interest of all Canadians. These new spectrum frequencies will be added to those which are already available to telecommunications companies, both incumbents and new companies in the market. Madam Speaker, all decisions concerning spectrum will be taking into account the goals and the mandate that I have just mentioned. We will consult with industry and Canadians before establishing the rules for future spectrum auctions, and that's very important. In August, the CRTC will the CRTC regulates this area. The CRTC has taken a number of measures to support wireless consumers, including the creation of a national mandatory code of conduct for wireless service providers and by regulating fees. For example, roaming fees, the fees that incumbents, the major companies, bill to smaller companies when they roam on their networks. To conclude, Madam Speaker, the Competition Bureau ensures that businesses and Canadian consumers prosper in a competitive and innovative market. The Competition Bureau undertakes investigations into anti-competitive activities. And I will conclude, Madam Speaker, by saying once again, you might be able to finish with your further comments. The Honourable Member for Courtenay Alberni.
Madam Speaker, I thank you to the Parliamentary Secretary for his comments and for being here and bringing his energy. Certainly we welcome the investments that the government has made in supporting the broadband network in Canada, but really, rate users aren't seeing the benefits of that on the wireless side of things. They need vision. They need action now. I'm wondering if the Parliamentary Secretary feels that rates are okay today. When it comes to the CRTC, the CRT is showing inconsistency in its approach to wire broadband versus wireless. On the wired side, the regulator has rejected arguments from the big network owners that allowing wholesale access will discourage their investment, yet it has accepted the line of reasoning in wireless. So, I mean, it's one or the other. We kind of want an approach that's going to serve all Canadians and all consumers. So I hope the Parliamentary Secretary can help me with an answer to that. We want a vision. We want some action on that.
The Honourable Parliamentary Secretary.
I understand my honourable colleagues' impatience in wanting to see some work being done on this very quickly. I can tell the honourable member, hopefully minister, some other in future government, but I could tell the honourable member that this is an issue which we're concerned about. It's a big issue, as you know, and we're very concerned about how that plays out in Courtenay, Alberni, as well as in regions across the country, especially rural regions. We know that there could be every action that we're hoping to take, Madam Speaker, is one that will encourage competition. But we could also use the money that we put aside in this budget to make sure that we allow for some, that we leverage a partnership with the private sector, with those who have a stake in this, and to allow for new players to get on the scene so that we can encourage more competition and better diversity and certainly more service to the members' riding and other ridings in rural areas of this country.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 a.m., pursuant to Standing Order 24-1.
Thank you.